whatever. But I think, yeah, the response was due on the 15th. So. Today, they're calling. We may call her later today. Yeah, yeah. 32 here, just sure. So if we end up starting, I'm just gonna bring him out, started, even if he's not here. Yeah, if he does get here, you're saying you want him just to wait in the jury room?
And then let you know, and then you can bring them out whenever.
That's fine.
Okay.
Hey, oh boy. So he hasn't called you or emailed or?
I haven't called him either. Not yet. I've been working. I got.
Don't bother. Don't bother. I'll just say line and direct. I'll incorporate that in my notes before I call you. All right, Your Honor, I'm ready to go. All right. Deputy Scott, if you could bring in, or sorry, Lieutenant Lattimore, if you could bring in our juror. We're back on the record. Defense counsel having indicated he is now ready to resume his cross-examination. Mr. Reynolds, please make your way down. Oh, I guess I could. All right. Thank you. Please be seated, everyone. Welcome back, members of the jury. Thank you for being here bright and early. And with that, we're ready to resume defendant's cross-examination of Mr. Reynolds. Mr. Reynolds, I'll remind you that you remain under oath. Mr. Craig, the floor is yours.
Thank you, Your Honor. All right, thank you, Mr. Reynolds.
Good morning.
Good morning. So we were talking about your lawsuit. We were in the process of looking at the complaint. Can you hear me okay?
Yes, sir.
Okay, great. So we were in the process of looking at the complaint that you filed to initiate the lawsuit.
That's right.
All right, perfect. Thank you, Lexi. And we had established that there was a contract attached to the complaint and that you were suing on that written contract per the terms of the complaint, correct?
Yes, sir.
Okay. And can we please get a look at paragraph 6? And then the amount of that contract is actually designated in the complaint. In paragraph 6, would you please read that to us?
For its services, plaintiff was to be paid an agreed contract price of $120,279, which the defendants agreed to pay.
Okay. So according to your lawsuit, the contract price at issue in this litigation is $120,279, correct?
That's correct.
All right. And can I get a paper copy of that? And can I give him one as well? I'm going to go ahead and give you a paper copy.
Okay, thank you, Counselor. Thank you.
All right, so let's look at paragraph 23. All right, now this, would you please read that paragraph to us?
Plaintiff and defendants are parties to the agreement signed on 10th October 2020 governing renovations plaintiff completed on defendant's property.
Okay, so this is plaintiff and both defendants, correct?
Yes, sir.
And they're parties to the agreement. And this is the agreement we're very familiar with now, signed on October 10th of 2020, correct?
That's right.
And look at the next paragraph. Would you read that?
The defendants have reached the agreement by failing to provide payment in full for furnished labor, services, equipment, and/or materials used to renovate the property.
Okay, so your statement of record is that they have breached that October 10th agreement, right?
Yes, sir.
Okay. Now, you've also claimed there's another agreement that was signed earlier, and the price on that was $136. But that's not mentioned anywhere in this complaint, correct?
I'm not sure if the agreement is, I'm not sure. I would think that the separate agreement was what this is in reference to as well.
Okay, but the separate agreement is not mentioned anywhere in this document, is it?
Well, I don't know, Counselor. I mean, when it says have breached the agreement to provide an opportunity, 24, by failing to provide payment in full for furnished labor, services, equipment, and/or materials used to renovate the property, that's a pretty inclusive catch-all for the work that was done.
Okay,
Does
but
that make sense?
the term agreement here is capitalized, right?
Yes,
It's a
sir.
capitalized term,
Yep.
and it's defined earlier in the document, correct?
Specifically where, I'm sorry.
Oh, that's all right. So let's look at,
15?
that would be paragraph 5 on the second page.
Okay.
All right. Which says, why don't you,
On or about the 10th of October, plaintiff and defendants entered into an agreement, the agreement, whereby plaintiff agreed to furnish labor, services, equipment, and/or material for work on improvements constructed on the property. See Exhibit A.
okay. So let's go to the end of the complaint.
Can I, just to clarify on this same exhibit, Counselor, can I read another paragraph?
Sure.
15, defendants made changes to the scope of the agreement, capitalized, which plaintiff performed without additional payments from the defendants.
Okay. Thank you, sir.
Thank you, sir.
Let's turn to the last page.
Claim of lien?
Sorry, not the last page in the exhibit, but the last page of the text of the complaint. There we go. It starts with the word wherefore. Kind of midway through.
Wherefore plaintiff prays
That's it.
that they have judgment against defendants in the sum of $7,356.50.
Thank you, sir.
But
So
I'm sorry.
that's all right. On this page, this is where you're asking the court to provide you with a remedy, correct?
Yes, sir.
And that remedy is for a money award of $7,536.50,
That's
correct?
Yep.
And then you're asking for a special lien and for the right to foreclose on that lien, correct?
That's what it says. Yes, sir.
All right. And you're asking for attorney fees,
Correct?
right? Okay. So you filed suit to foreclose on the property, right?
I filed a lien on the property. Yes, sir.
Yes. And then you filed a lawsuit to foreclose on that lien.
That's correct.
Okay. Now, and then let's see, you also have number 5 here. You're asking for trial by jury, right?
Yes, sir.
Okay. So you've got a $7,500 dispute here. And your strategy is to bring a lawsuit to foreclose on their home, right?
No, sir, that's not correct. That's not my strategy. My strategy was to be paid for the work that was done and to address any issues that the defendants had. We were denied access to the property to do so. That wasn't my strategy. My strategy was to ask to be paid. And the procedure, as I understood it, was to file a lien to encourage them to do it. It wasn't my strategy to end up here in a jury trial. No, no, not at all.
Okay, but you
We
came
were
to,
compelled to do so because of defendants' responses to us.
okay, but you came to court, all right? You put a public statement on the record,
Yes, sir.
and that public statement says, I want to foreclose on this property. That's what you said right here in
I
writing,
want to foreclose on the lien. Yes, sir.
right?
That's what it
The
actually
lien against the
said.
property.
The lien, yes, that's correct.
Yes.
That's
And
right.
of course, you're in the construction business. You know what this means.
It means an encumbrance on the property. Yes, sir.
It means the property is auctioned on the courthouse
Oh, it
steps.
doesn't mean that until things are.
That's what foreclosure is, sir.
That's what
We've been
foreclosure.
litigating
We
this
can interrupt
case.
each other. You
Okay,
can finish your
sorry.
question and then you can finish your answer.
Foreclosure is an entirely different beast than what you're describing here.
Well, so you put a lien on the property
That's right.
and then you filed suit to foreclose. It says it right there on the board,
In
to foreclose the lien. Right?
yes, in response.
Okay. Thank you. That was the question. I appreciate the answer.
Thank you.
So my next question is, did you think about small claims court?
I thought that's as far as this would go, frankly. I thought we would be paid and we would be done. We'd be allowed in to address the issues that the owners had and we could move forward.
But you know there's such a thing as small claims court,
I
right?
think it escalated, counsel, on your clients' threats of police actions, of IRS investigations, of taking us to court.
Okay. All right. Well, we'll talk about that. But my question to you, which I would like you to answer, is are you aware that there's such a thing as small claims court?
I am.
And did you think about taking this to small claims court?
It escalated before there was an opportunity. There was also, I think, an opportunity to mediate. But, there was no willingness on the part of your folk to make it happen.
But you started the lawsuit, sir. You escalated to a lawsuit and you went straight to Superior Court, straight to foreclosure, straight to demanding a jury and attorney fees. Right? You skipped small claims court entirely.
I object to the characterization of the question that it implies you have to go
Sure.
through
I
certain
would
steps.
sustain that. Mr. Craig, you can rephrase.
Okay, I'm not saying small claims court is mandatory. I'm saying you could have chosen to go to small claims court first before you sued to foreclose on their property.
I object again. I don't think that's a proper statement of the law. I think you cannot get a foreclosure or lien that deals with title of the property in small claims court. It has to be Superior Court.
All right. Mr. Craig, I'll sustain that. You can move on. Or if
Okay.
it is-
So if I understand correctly, your rationale is that you had to come to Superior Court because you wanted to foreclose on a lien.
Objection, that's not what he stated.
we'll let him answer that question. Overruled.
Counselor, I'm afraid this has gotten so convoluted in my brain, and I apologize for that. But the repeated references to foreclosing on their property was never my intention. I understand what a lien is, a mechanics man lien, but that is filed in a Superior Court. That's what happens. That's what happens. And
But I'm saying you already filed the lien, right? Let's get the lien here. Let's see. Yes.
Thank you.
All right. Do you recognize this?
Yeah.
This is your lien.
Yes, sir.
Move to admit.
We need a number?
86,
D86 is already in.
already in. Okay. Let's put that on the screen. And Lexi, could you scroll to the top? Okay. So this is your lien. And read me what it says right there at the top in the upper right, or yeah, upper right on the second line.
Filed and recorded 13 June 2022.
Okay, so you recorded this lien on the public record on June 13th, 2022, correct?
Yes, sir.
All right. And then she disputed the lien, didn't she?
Yes, sir.
Okay. And then so you filed a complaint in Superior Court afterwards.
That's my understanding
August?
I'm sorry, Counselor.
That's all right. On August 25th, 2022, correct?
Yes, sir.
So you had a lien filed on the public record, and then a couple of months later, after she disputed the lien, you filed a lawsuit to foreclose on it. Correct?
Correct.
Okay.
And
And
Counselor.
you did not go to small claims court in the interim?
No, I didn't.
Okay.
Can I finish my answer, Your Honor?
Yes, please.
Finish your answer.
Yeah, my understanding was that once the lien was disputed, as a matter of law, a lawsuit had to be filed to maintain the lien. That's my understanding.
Okay. And you were okay with doing that to preserve your $7,000 lien. You're okay with suing them to foreclose on it.
I had
That's okay with
to
you.
keep the lien alive. That's what had to be done.
Okay. That's what had to be done for $7,000.
That's my understanding. Yes, sir.
Okay. All right. Now, you said that one of the reasons you brought this lawsuit is because Francisco threatened you, right?
Yes, he did.
In his text messages.
Yes, he did.
And you put some text messages into evidence. And I think there was one where he threatened to report you to the IRS, right?
Among others, yes, sir.
Okay, some other threats too. And we'll talk about those. Now, you weren't really concerned about being reported to the IRS, were you?
No,
Okay. Your books are in order. You're not cheating on your taxes.
no.
You're not concerned about that. All right. And let's see, what was one of the other threats? Something about hiring illegal immigrants.
Yep.
You weren't worried about being liable for that, were you?
Nope.
So that threat wasn't much of an incentive for you to file a lawsuit, was it?
No, but his repeated texts in the middle of the night, bring me my money, his postings of me selling a car in Los Angeles.
Well, we're talking about text messages
These are
that you
text messages to me. Yes, sir. Yes, sir.
prior to the lawsuit.
That's right. That's right.
Those were not put into evidence, were they?
Maybe not yet.
Okay, so we haven't seen those text messages yet in this proceeding.
Okay.
Objection, just for clarification, we did put the text into evidence and those were prior to the lawsuit. They were from April of 2022, which is prior to the lawsuit by 2 months. Let's not confuse the jury.
Okay, so he's talking about text messages in the middle of the night about a car?
Bring me my money. He texted me in the middle of the night. There were repeated phone calls from, I'm sure, burner phones. I couldn't drive down the streets of my neighborhood, which I've lived in longer than he has, without being yelled at, getting the bird flipped at me. There was a pattern of harassment, counselor, that extended to the witness that lives down the block, that we were unable to get much clarity on yesterday. But there was more, really, than bring me my money. There was a whole series and there's actually a motion that was filed against, in this court against Mr. Maia for his behavior.
So I understand you've alleged that Mr. Maia anonymously sent you text messages in the middle of the night 2 years into this lawsuit, and you filed a motion last year about that, what was the outcome of that?
Counsel, I think at this point, we're going down a route that isn't really relevant for the jury's consideration. So
Okay.
you can stick with the theme, but we can move on from that point.
All right, so we're saying that he texted you in April.
He texted me as early as March 14th, 11th.
Of 2022, correct?
Saying, do not come on my property. I had a subcontractor on the job. He said, you are not allowed to come on the property.
Okay. So now, based on these text messages, did he seem like he was upset?
What can I say? I assume so.
You don't know if he was upset or not?
He certainly was unreasonable, counselor. Why don't I characterize that, which probably is more accurate from my knowledge. I wasn't even in town that week.
So you can't tell if he was upset or not based on him, I don't know, texting you in all caps and saying, stop, play games.
Sure.
So he was upset. You might say he was enraged.
I would agree to that. Sure.
Okay. All right. So now you agree with that. So, do you get the impression that he really understood what was going on with the project?
Do I get the impression?
Yeah.
No, sir, I do not.
Okay. And did he understand the billing and the amounts of money at issue?
I don't think he really did. No.
Okay. So he didn't really have a good comprehension of the project and the work you had done for his wife, and her father.
That's not accurate, and that's a different statement, sir.
Well, I asked if he understood what was going on with the work and the billing, and you said no.
I don't know that he understood what was going on with the billing, but I do know that he was present in the building. He would come in and look at the work. So it's not fair to say he was unfamiliar with the work.
And you knew, of course, that he was not a party to the contract.
I didn't know that really. On strictly legal terms, absolutely. But he was living in the house. He was directing choices that were made, and those are evidenced in the text chain. And they say, Francisco says khaki, not haystack.
Okay, all right. We'll talk about that in a minute, but you knew he wasn't a party to the contract. You had no obligation to build anything for him.
Oh, I didn't have an obligation to build it for him, but I was given to understand that he was also a participant in the choices that were made.
In the choices that were made, but not an owner of the property and not someone you were obligated to under the terms of your contract.
I would characterize that as inaccurate, counsel.
Oh, so you do think he had standing to enforce the contract?
I think he had a lot of input into the job. He allowed us access to the crawl space. When Regina wasn't around, she would say, Francisco will open it for the plumber. So yeah, he had access and he had a great deal of control of our access to the building and parts of the building.
But he didn't have a right to sue you if you made a mistake or did something wrong.
You know what, Counselor, I don't know that.
You don't know that? You don't know who's in your contract?
No, sir. What I do know is that you just said he didn't have a right to sue us. I don't know that. I don't know.
You're a contractor, sir.
Sorry?
You know who's liable under your contract, right?
I know who's liable under the contract, sure. But
I'm sorry.
No, you
No, I
go
don't-
ahead. Finish,
okay.
Counselor.
And you know who you're obligated to do the work for,
That's correct.
right? And you were not obligated to do the work for Francisco.
The obligation was to the veteran, the VA, and Regina.
Correct.
Mhm.
So he didn't have any right to enforce that obligation.
He didn't have any right to stop us from coming onto the property, but what am I going to do? What am I going to do? Call the police? Which he
You
said
said that you
he
were
wanted to
concerned
do.
he would sue you,
Yeah.
but you knew he didn't have any right to sue
I
you.
don't know what rights he had, Counselor. I really don't. People sue each other for all kinds of ridiculous stuff, as we've seen.
Now, do you have any idea why Mr. Maia was so enraged in April?
In April,
Yeah, when he sent these text messages, April of 2022, the job had finished.
I'm sorry, Your Honor, I don't have all these text messages in
I
front of
would
me.
object to that as speculation. Mr. Maia was here yesterday. He could have been asked that
All right.
question.
On the speculation of objection, that's overruled. If you can answer the question, I think he said he doesn't feel comfortable answering it without text in front of him. You can re-ask it or rephrase or however you want to proceed.
I mean, these are the text messages they tendered.
Or just from his own recollection. Just you can rephrase the question.
I'll give him the text message.
Thank you.
There, Chris.
Let's give him the whole set.
Okay.
Here you go.
Thank you, sir. I'm looking at this one and this one,
Okay,
April.
okay.
I recall that was 2022.
April of 2022, yes, sir.
Yeah, this is right after the job was essentially finished and before the lawsuit, 2022, end of the project.
Uh-huh.
All right. And you've got those messages in front of you.
Okay.
Now, do you have any idea why Mr. Maia was so upset at that point in time?
Allegedly that I had set up 4 appointments to bring him receipts. And as stipulated yesterday, the receipts were provided. That I told the VA that I was harassing him by phone. Receipts must be provided for tax purposes while you refuse to provide. My last text to you, I'm giving you a fair chance. Just end this easy for you.
Okay, so I'm not asking you to read the messages.
Okay.
I want to know if,
Your Honor,
I don't-
you asked him the question, why was Mr. Maia so upset? He
Okay,
should
I
be given
don't need
a-
the summary of it all. Mr. Craig, you can redirect him if you need to. If you're saying he's not reading the questions, ask him what it is you want from him.
okay, thank you, Your Honor. I'm asking you if you knew why he was upset, not to read the messages, but did you know why he was upset with you at that time?
I'm afraid I don't know precisely why he was upset with me. He accused me of a multitude of things yesterday, one of which was that I was robbing his house. Repeatedly, he said this, that I'm Mr. BS. Yeah.
But you were in the midst at that point in time of a pretty intense dispute with Mrs. Maia about this project, correct?
Correcting things in the project to the satisfaction of Miss Maia and the VA. That's correct.
All right, so there was a dispute between you and Mrs. Maia, right?
Correct.
And emotion was significant in that dispute at that time, was it not?
Not from us, no.
Okay, all right, but from the family.
The family were going through some tough times, absolutely.
Yeah, so you know what was going on with them in April?
Why don't you let us know, Counselor?
Well, I'm asking if you
No, I don't
if you remember.
precisely.
You don't remember what happened then?
There was a death, yeah, yeah.
Okay. Yeah, there were 2 deaths.
Yes, sir.
Her brother
Yes,
and her brother-in-law
yes, sir.
right around the same time.
Sure.
So at that time, she's grieving those losses,
Correct.
right?
Correct.
And that's why she asked you to communicate with Francisco.
That's exactly right.
She didn't really have the ability to deal with all this.
Understood.
Right. So she was generally handling this project personally up until that point, wasn't she?
That's a fair assessment. Yes, sir.
But she couldn't do it anymore. She was kind of done. Now, did you perhaps think about giving the whole situation some time to cool down and then coming back and trying to communicate with Regina about it?
In hindsight, that would have made perfect sense.
Okay, in hindsight, that would have made perfect sense, yes. But now, you filed this lawsuit on August 25th, right?
Yes, sir.
All right. So you were so upset about these text messages in April that you felt the need to defend yourself by filing a lawsuit in August, right?
I was so upset.
Yeah, you were so threatened that you waited 4 months and then filed a lawsuit.
I think the lawsuit was in response to their suit.
Oh, yeah, okay. So to their suit, did they sue you?
To the keeping the lien alive, they, and this could have been avoided, my understanding is of the lien.
Okay, right. So,
But to answer your question about me feeling threatened by Francisco, his behavior, independent of these texts, was so onerous that it was difficult for me to ask my guys and me repeatedly. We came back again with the VA to try and resolve the issues, and we were forbidden entry.
okay, all right, so,
So the frustration that I felt as a contractor was that we couldn't get in to take care of notes. The VA in repeatedly asked the owners to allow us access. We were denied repeatedly.
all right, so your plan, you've got a client's husband who's very upset with you because his wife is hurting and he doesn't like the way you've been treating her, all right? And so you're worried he's going to do something irrational, right? He's going to report you to the IRS, some frivolous report. And your plan for de-escalating the situation is to make a preemptive strike and file suit to foreclose on their property.
That's inaccurate.
Objection misstates the testimony of the client.
All right, he's on cross-examination. You can answer the question if you're able to. Overruled.
That's inaccurate. This is in April.
Right. This is in April. You waited 4 months to bring your preemptive strike.
Is that a question, Counselor? Or an observation?
I'll withdraw it. Now, you've talked repeatedly in this case about how this whole thing could have been resolved if you'd just been allowed to make repairs, correct?
That's right.
All right. And in the beginning, we kind of covered the fact that you are a professional contractor with 35 years of experience in the residential construction industry.
Yes, sir.
And so you have an understanding of how construction disputes are resolved, correct?
Yeah.
Okay. And you are no doubt familiar with the fact that if there's a construction defect, the contractor does have a right to make repairs. Correct?
Yes, sir.
Yes. That is a right that is embodied in Georgia law, isn't it?
It is.
In fact, there's a special act for contractors called the Right to Repair Act, correct?
Yes, sir.
Okay. And so you understand when a contractor is sued, they can bring a motion pursuant to the Right to Repair Act, and they can put a stop on the lawsuit, right?
I didn't know that, no.
You didn't know that?
No, I didn't. because I've
35
never-
years in the construction industry?
Counselor,
Let him finish
Okay.
his answer.
I'm not an attorney. I've not been sued before,
Okay.
okay? I've never filed a lien before. So I've had a pretty unblemished record of working with clients over those years and not entering into disputes like this, resolving things amicably.
Okay. Never
This
been in
is-
a dispute like this?
Not like this. I've gone after my money before and I've won. But I have not had a dispute like this where I was accused of not doing the work because I was unable to come in and address it.
Okay. Well, regardless of the reason why, whether you knew about it or didn't, you did not bring an action, motion to stop this case and enforce your right to repair. Correct?
Correct.
Okay. And you do have professional counsel in this case.
I do.
All right. And you've been litigating this case for 3 years.
Yes, sir.
Okay. And during the lifetime of the case, you've never made an offer to settle.
I've not, no.
Okay. And I guess your testimony is that you don't know that the Right to Repair Act can enable you to enforce the complaining party to engage in negotiations with you for repairs.
Well, we were also operating under the aegis of the VA, who were very, very much desirous to have the vet occupy the building. They wanted to close the contract. There's correspondence to that effect. There was about a $20,000 amount that was withheld by the VA until these things were resolved. And there's documentation from the VA saying, if you don't afford the contractor access to the property, we are going to close this case and give a balance to the contractor, which they did.
So you were involved in a prior lawsuit.
Yeah.
And in that case, you worked on a job.
I'm going to object to this line of questioning. This
Yeah.
is far out of field. It's not relevant to this case. It's
All
going to
right.
take,
Mr. Craig, I'll let you argue this at a break, but for now, I believe that would be sustained. You can bring it back up when I've had a chance to hear your argument outside the jury's presence.
I don't have any problem if he
Okay.
wants to talk about what happened in the outcome, but going into the specific, I think he's set up to try to go into the specific facts of that case. That's irrelevant.
Okay.
And so.
As I
if
said,
he wants to talk
we're going to
about
put all
what-
this to
what
a
it was
side
about
before
and how it was
Okay, Mr.
decided.
Bernie, I need to say something here,
Sorry.
which is we're going to move on from that and we can come back to it when I have a chance to hear your arguments, Mr. Craig.
Okay.
All right.
All right. Thank you, Your Honor. Could we possibly go over this outside the jury's presence?
Is this the last thing you have?
The last thing on my
All right.
list.
Members of the jury, if you could just step out just for a second.
Sorry.
Okay. All right, just from the outset, I just feel very uncomfortable with this issue. I think it's raising some real 404 flags for me where it initially was introduced during Mr. Reynolds' direct. I think its purpose would just be to prove character in terms of conformity therewith, but there was no objection made. So I guess, Mr. Craig, why don't you take it from here? Why you think, I guess if you're going to go into the details of the prior lawsuit, how that's admissible and what's the purpose you're using it for?
Okay, all right. Well, to start with, they did bring up the prior lawsuit indirect, and he brought it up now. And he said that he won that lawsuit. And I would dispute that.
Okay.
Also, there are remarkable similarities between the prior lawsuit and this one. And
Why would those be relevant? Just
so they do
similarities.
show a pattern of conduct in the management of his business. Failure to keep accurate books and records, alleging these oral agreements over and above the original price of the contract, and then the litigiousness of suing based on these alleged oral agreements for more money than he's entitled to. And the outcome in that case was actually that he sued for like $120,000 and he was awarded 30.
So again, your argument here is this is what he did on a prior occasion, which is what he did here. He's acted in conformity therewith.
Yes, yes.
All right. So that would generally be explicitly barred by Rule 404.
This is a fraud case, and character is inherently at issue in a fraud case. Character for truthfulness, which this is directly pertinent to. We're saying these oral agreements are not truthfully alleged. These things are made up. This is what he does. He goes in.
Okay.
He gets
So
into
so
the
prior instances of if you have prior inconsistent statements or prior acts of dishonesty, those can be explored. Those are relevant grounds.
it's
If you can
it's-
actually connect the dots on those, I could see that.
okay. It's a prior act of dishonesty of claiming that he's owed a lot more money than he's actually owed. Just what he's doing here.
Okay, Mr. Burney.
Your Honor, I think the response here is that the two lawsuits are not the same. This is the repair of a single-family house for one family under the auspices of the VA and has its own set of requirements in terms of how that has happened. What happened in the case down in Baldwin County is that he had renovated 12 historic homes for one man who did not live in any, that maybe lived in one of the homes. And it was a commercial situation, and we did in fact sue. He countersued along the same lines of what they've countersued for. We prevailed in the action. The jury did, in its wisdom, determined what the damages were. All the counterclaims of the defendants were dismissed, including conversion, breach of contract. And so I just don't see it being relevant. I think it's, it's too loose of a connection here. I don't think he's proven any act of dishonesty on the part of my client that would enable him to even go back to that. And I think it opens up, a can of worms here in this
Okay.
case.
Well, if it's one that's opened, I mean, I would say that y'all were the first to bring it up, and I think the rule we're looking at squarely is now 608. Since he's got him on cross, he's referencing specific instances of conduct for the purpose of character for truthfulness, and to the extent he's able to prove that, he has to take the witness as it comes and the answer that's given. So if you counsel is believing as a good faith basis, I mean, cases can be dismissed for many reasons. That doesn't necessarily determine what actually happened in the case below. So I guess I'll put it to the point. I think under 608, the objection be overruled, and you can go into this, and we'll go from there.
I've got one other issue that's going to come up
Sure.
in this context, which is an exhibit. Can I see 117? And of course, we've got attorney fees and bad faith alleged. So I'm going to share it with you as soon as I confirm that it is what I'm.
Just what generally is it?
It is a text message. I don't know if this might be moot because I may have the wrong exhibit here. Let me just see here. Okay, yes. So there is a text message here from Mr. Reynolds to Mr. Smith. Oh, here you go. Can you give him that one? Pertaining to the prior resolution of the other lawsuit, okay, and the outcome. And it does contain some colorful language that is not appropriate for court.
Well, you can try us. I think we've probably heard worse before.
Okay.
So the reality though is I'll say you can refer to this exhibit, you can show it to them, but you can't introduce it because that would be extrinsic evidence under 608.
And remind me, 608?
Well, it's a long one, but you could, I mean, you can have this if you want it. Take that back with you if you want.
Yeah. Okay. Thank you.
So
Your Honor, just to clarify, what was the basis that you overruled the objection on?
the original objection for him to even be going into this line of testimony would be that it is permissible under 608 as specific instances of conduct,
Showing,
character for truthfulness, and potentially even also prior inconsistent or impeaching statements that have been made during his direct, if that isn't what in fact is shown as well. There's perhaps an alternative basis. But in terms of whether he tries to tender 117, I'll just tell you, you can attempt it, but I think that's likely to be a sustained objection to its tendering. Anything else?
I would just have a.
Well,
Excuse me.
Hold up.
no, I would just say, Your Honor,
Yeah.
if we go down this road, then we would renew our request to have our character witnesses be available to testify for a short period in response to this.
Yeah, and so we're clear when we go down this road of character, the sole thing they're able to say is, I've known him, and my personal belief is he has a good character. They're not allowed to then talk about how he's, a deacon at his church and goes to homeless drive. It's just my opinion is he's got good character. That's it.
Understood?
And we'll see if that is
So
an issue. And I don't necessarily know if they're saying they're just attacking him for bad character. I don't think 608. I'll look at this, but I think if you're just saying for untruthfulness, I don't know. Mr. Craig, let me let you respond. You had something to say.
I'll cut y'all a deal, and I won't get into the details of the prior lawsuit. We'll just talk about the outcome, which is the can of worms that they opened.
Okay. And that would just be specifically impeaching a specific statement he made, which would not implicate character.
I'm not sure what you're gonna offer here in terms of the outcome. Is it gonna be, what is it gonna be? The order?
order.
It's gonna be
Yeah,
your
yeah.
opinion of why we didn't win the case when
That's
we
the order,
did prevail?
just the order and the
As long as
complaint.
there's- I mean, you can argue whatever you want, but I don't think it's appropriate to bring in all the other facts in the case, so the jury has to now ultimately decide two cases.
Right, yeah, that's what we're not going to do.
This is-
We're going
this
to
is-
bring in the complaint, which is the amount of money that he sued for, and the order, which is the amount of money that he got.
So to the extent and how far he takes this, that, again, it's his time. We'll see. But again, I'll note that if you try to introduce any of those things, I don't think that's permissible. You can refer to them, you can reference them, you can even read off of them, but you can't use them as exhibits.
I think it's highly prejudicial, Your Honor, for him to bring this in. This is saying he's not saying, but he is showing and saying the following. Mr. Simon lost that case, even though the order is going to say that he was awarded damages. And
Then I think you can rehabilitate him on that. But the statement was, he said he won that lawsuit. He believes he can impeach him to say that was not a truthful statement. And I think this is a permissible
Okay.
grounds for
I'm sure
cross.
Simon's champing at the bit to
All right.
Lou.
let him respond. Oh, use the
Okay.
bathroom.
But I
Oh,
don't
I'm
know. If
sorry.
you've got 10 minutes, beautiful. If you're going to go on another half hour.
I would
Counselor.
say you should probably go now.
Okay.
Yeah.
Thank you.
All right, we'll hold in place. Sorry, I should have let you say that initially.
No, I left. I thought I had to peek it.
I might also take a quick restroom break,
Okay,
Your Honor.
let's do that.
I'll
Yeah,
be-
we're off the record.
I can set this up here. So I know you don't want to have me take the microphone in the bathroom.
Did Chris take his microphone with him to the bathroom?
What?
Did Chris take his microphone with him?
No,
Okay, cool.
and I don't, it's not recording it, I don't have the headphones.
Okay, that's good.
Oh, I need to bring in juror 32. Lieutenant Lattimore, actually, I forgot. Can you bring out juror 32 and just have him sit in the jury box?
Yeah.
Yeah, that's fine. I don't want him interacting with him.
I think he went outside. I really hope that we end early enough so we can actually get lunch tomorrow or today. Yesterday, we showed up right as they closed the lunch thing, so I survived off of a bag of Funyuns and half a bag of Doritos. It's like, this is healthy.
I brought some lunchables.
See, that was smart. I woke up late yesterday and didn't have time to pack lunch. So, it's fine.
Yeah. I didn't see you.
I slipped in a little
Yeah.
bit. You having mic'd up today too?
I got the table mic, so in his mic. Sometimes you guys are quiet and then sometimes you say more than the judge, so it just
Oh.
depends on the court and how that relationship is.
sir.
Yep.
One at a time, fellas, only.
We got that.
Yes,
Be
and I
mindful of that.
Yeah.
All right, first, let's go back on the record, and we have juror 32 with us. Juror 32, I think you were again 20 minutes late today. Never got a call or update from you. What's your excuse this time?
I didn't even think to call in. I got here at 8:40 in the yellow lot. Not really, like, I'm thinking I'm fine. I get on the bus, the MARTA bus, 8:45, thinking it was gonna head out shortly after, and really not. I live in Roswell. I don't go to Atlanta. I don't deal with buses. I don't really know about it leaving at 9, getting me up here, at the building at 9:10. Being unprepared for situations. I've never just truly unprepared. Getting here early, so thinking I'm fine for 2 minutes or so.
Okay, well, jury number 32, certainly can't say I'm giving you a passing grade for your first jury attempt here. I mean, being on notice yesterday that we've got to start on time, I would have shown up extra early and been one of the first ones here, but instead you're here the second time. So we had to keep going without you. So you're no longer part of this jury. But I find that you did violate my orders to not even call in and give us an update on your ETA. So as a sanction, I think you're going to join us and just watch the remainder of the day in the back row, and we'll decide what we're going to do from there, okay? All right, so you can make your way out of the jury box. If you had any other belongings, Lieutenant Lattimore can collect those for you from the jury room, and we'll be with you at the end of the day, okay? Just in the back row. All right. Mr. Craig, any reason we can't proceed? Any reason we can't bring back the jury? Okay. All right, so the jurors. Thank you, Lieutenant Lattimore. All right, thank you for your patience, members of the jury. Mr. Craig, you can proceed.
Thank you, Your Honor. So, Mr. Reynolds, you mentioned you were in a previous lawsuit, and that you won that lawsuit, correct?
That's right.
All right, so that lawsuit was filed in October of 2019, and it looks like it was initiated in Fulton County, right?
Yes, sir.
Okay, and that was Reynolds, Renovations, and Restoration, Inc. versus some defendants who were current or former customers of yours, correct?
When you say defendants,
Granger, Hansel and Company, Historic Preservation Student Housing LLC, some LLCs, and we've got Richard Sims.
that's correct.
Okay. And in that case, as with this one, you're suing for money owed, right?
Yes, sir.
Okay. Now, turning to the back of your complaint, it looks like you were represented by Mr. Burney in that case as
Yeah,
well.
yes.
Yeah. How long did that go on? Couple years?
I think so. Yes, sir.
Final judgment was entered in May of 2022, right? Okay, so that case was going on pretty much all during this project.
While we were
Right.
building.
Yeah, so while you're working on Mrs. Maia's ADU, you were also litigating this case, this previous case. right? The previous case against Mr. Sims. Right?
Yeah.
Okay. All right, so now you had a prayer for relief in that case, like in this one, and you asked for specific sums of money, right?
Correct.
And I'm seeing 20,000, 80,000, and 15,000. So that's a total of 115, roughly?
Sounds about right. Yes, sir.
Okay. All right, so now I do recall midway through this project, you came to Mrs. Maia and said you needed more money to keep going, right?
I said that there were some overages in amounts of material cost. Yes, sir.
And you needed that money to keep going, was your testimony yesterday.
Objection that misstates his
Yeah,
testimony.
he can answer the question. The jury will recall the evidence. It's overruled. You can
Yeah.
go.
I don't know that I said I needed it to keep going at all, but I said.
Or to
it's-
speed things up, right?
I think that's how you characterized it. Yes, sir. To keep moving. Yeah.
Okay, to keep moving on the
That's,
project.
I think how you phrased it. Yes, sir.
Well, how would you phrase it?
Well, that we had a difference in from 2019 to the beginning of the job in 2021. There was a considerable cost overage in terms of material. I approached Ms. Ordonez, Regina, and said, I get it. I get
Okay,
it.
all right, that's good. We went over it yesterday. I don't want to ask you to repeat yourself too much. I know you've been up there a long time.
Thanks.
All right, so, but while you were asking her for that money, you were also spending a bunch of money on this other lawsuit.
Actually, I cannot recall. I know there was another lawsuit. I know it was delayed because of COVID, because of other things. So it was dormant for some time. And then
Okay.
yeah,
You don't know how much you spent on 2 years of litigating that case?
too much.
Okay, all right.
Yeah.
So it was a considerable sum.
Yeah,
All right, now you did get there was a final judgment entered in that case on May 17th, 2022, right?
yes, sir.
And you were awarded some money, all right? The court awarded you $36,961.
That's correct.
Okay. So you came to that court and you made a public statement in writing on the record that said, I'm entitled to money from these defendants in the amount of $115,000. Correct?
Yes,
And the jury in that case ultimately found that you were entitled to $36,000.
they did.
Yes, about a quarter of what you said you were owed, right?
I'm trying to do the math. I think a little more than a quarter, but yes,
Okay, all right.
they
Well-
found for us. Yeah,
Okay, they found for you
yeah.
that you were entitled to a quarter of what you claimed that you were owed.
They also determined that he was in error and was the party that owed.
Thank you very much, Mr. Reynolds. That's all I had for you.
Thank you.
Redirect.
Thank you, Your Honor. Mr. Reynolds, how are you?
I'm good. Thank you,
Hanging
Counselor.
in there? Let me start with where we were, the lawsuit that was just mentioned by Mr. Craig. There were counterclaims against you in that case as well, correct?
Yes, sir.
In fact, there was a counterclaim for conversion in that case.
There were.
There was a counterclaim for breach of contract in that case.
Yes, sir.
And those claims were dismissed
They were.
and denied by the court.
They were.
Thank you. Let's take you back now to the discussion of the contract, the agreement in this case.
Yes, sir.
I think you've been clear in your prior testimony, but just to reiterate, you have stated that the agreement in this case is based on the ADU agreement with the VA, but
Mhm.
there are other agreements that go with that,
That's correct.
right? And so when you said, under questioning from Mr. Craig, that you were discussing about other things owed for improvement of the property. What is the property that you are referring to?
1361 Grant Street.
1261.
Sorry, 1261, yeah,
You weren't referring to just the building of the ADU.
that's correct,
You were referring to the entire property,
precisely.
okay? And I think you also have testified that the walkway, the covered walkway, the cover to the walkway from the ADU to the main house was not part of the agreement,
It was a separate agreement.
right? And that was at the request of Miss Maia.
That's absolutely correct.
And there were other items that were not included,
That's true.
such as,
There was tiling on the front walkway, there were retaining walls, there were a fence shift of the fence line at the northern portion of the property. These were outside the ADU contract VA scope.
right? In fact, you discussed the, one of the main issues in this case, would you agree, is the deposit
That's right.
and whether or not it was refundable and what it was for.
Yeah,
And that's a word that, did you use that word or did Miss Maya use that word?
that's the word she used.
Okay.
Yeah.
And does that word, is that term of that agreement referenced or discussed anywhere in the written agreement in this case?
With the VA?
Yes,
No,
thank you.
no.
I would also ask you to clarify for the jury the claims in this case. We've heard about we looked at the spreadsheet. Let me get that for you. Let me show you this. This has already been admitted.
Thank you.
The net result of that spreadsheet is that you found that Reynolds Renovations is owed $75,3650, $7,536.50,
That's it?
right? And there are numbers in there, but there's the deposit money, the monies that Miss Maya paid you is not listed in any of those totals.
In the total, no, and it should have been.
And it should have also been listed on the other column.
That's right.
So that those two numbers should have been increased by 16,000.
That's correct, yes.
And
sir.
if you increase those numbers by 16,000,
Mhm.
you still get a difference of $7,536.50, correct?
That's correct, yes, sir.
Was that your intention to explain that that was the money that was owed to you?
Yes,
And the purpose of, what was the purpose of creating this document? The purpose was to determine what was owed, correct?
that's right. That's all it was.
Right.
Yeah.
And we've acknowledged in opening and that there may be a bookkeeping error here or there, correct?
Correct, yeah.
Do you spend all your day doing your bookkeeping?
No, I go to jobs. I'm missing out right now.
Right. And you have a person who does the bookkeeping with you.
That's right. Her name's Karen Hine.
You consider her to be a good bookkeeper?
She's been with me a minute, yep.
Yeah.
Yeah.
Is she reliable?
Yeah, of course she is. But we all make mistakes. We're human.
And what do you do when you make a mistake?
Well, you correct it, don't you?
Yeah. There's some discussion in this case about whether or not you asked for the right to repair under OCGA 8236, the Right to Repair Act. It's listed in your answer, is it not?
Yes, sir.
Have they ever made any offer to come to you and say, Simon, come fix this?
No, never.
From June 11th, 2022, in the year period, you said that there was a warranty.
That's
Did they
right.
ever make a warranty claim?
Never.
Did they ever tell you a list of defects until we got all the way through discovery?
No.
Okay. In fact, okay, I'll leave that there for now. And if they had said, Simon, let's work this out, come do this, this, and that, and we'll work it out one way or the other, would you have been willing to sit down and do that?
Yeah, that's what we do.
Okay.
That's what we do.
And you mentioned before that you hadn't ever filed a lien before.
No.
And did you do it for any particular reason?
I didn't have anything else. No, I'm being flip. No, I did it to make ourselves whole for the work that was completed.
And you're aware of the fact that in order to file a material means lien, it has to be filed within a certain period of time, correct?
That's correct.
And the period of time that you were filing it Was it right at the end, in the middle, of the
It
beginning?
was right at the end,
And so you decided ultimately to do it
based
just to
on,
preserve it.
like, yeah, preserve the
And the
possibility.
things that led you to do that were the way that
Yeah.
Mr. Maia was treating you
That's right.
and the way that they were responding to your and preventing you from fixing anything at the property.
That's correct. And there was a certain amount of pressure from the VA to get it done, to close it out, which is not germane, but it also was because the VA felt an obligation to get the vet into the building.
Right. And so you file the lien,
Mhm.
and then in response to that, Ms. Maia files a notice of contest of lien, which is in evidence.
Mhm.
And that document, as we discussed yesterday, requires that you,
Respond by filing a suit.
within 60 days, correct?
That's right. Yes, sir.
You didn't have a choice if you wanted to maintain that.
That's right. For
Was
the-
it ever your intention to foreclose on their home?
No, of course not.
Okay. Have you ever foreclosed on anyone's home?
Never.
Have you seen in your career other people, in the residential construction industry, liens getting placed?
Yeah, of
Are they
course.
placed with some frequency?
Yes.
Is there any limit about how much the lien can be?
I
in
don't,
order-
I don't know. I don't think so.
Right. You've never heard of any kind of floor that it has to be above a certain amount to file the lien.
That's correct.
In fact, but the lien is one of the ways that a material man, which is a contractor under Georgia law, gets paid.
That's right.
There was some discussion with Mr. Craig about Francisco and whether or not he really had any authority to do anything. And you were talking about that. I'm not sure you got a chance to completely answer that. Francisco Maia, you knew at that time, was Mrs. Maia's husband
Mhm.
and was involved in the orchestration of the project, maybe not as involved as Mrs. Maia, but definitely involved.
Yeah.
And do you normally ignore husbands? Is that a good result to ignore the husband?
At our peril.
Right.
Probably wives are worse to ignore, but yeah, I don't ignore
So if you,
a spouse.
right.
Yeah.
And why don't you?
I would think it would be enough to completely poison the relationship.
And Mr. Maia said that he took over the handling of the contract in
That's
March
right.
of 2022.
That's right.
And at that point, what did you think that meant?
That he was the person I needed to speak with.
Okay. And that person prevented you from accessing the property unless you brought him these
9,000
vague
or
sums of
11,000,
money.
depending, yeah.
What did that make you think about the way they were looking at this when he came to you with these different numbers that they were demanding to give you access to the property so you could finish your contract?
I don't think they wanted to resolve it. They weren't willing to help resolve it.
Did you ever get, okay, that's fine. Let's talk about the request for overages costs.
Hmm.
You had stated that Mr. Craig had tried to, ask you questions about that. And would you have continued on with the project and finished it if Mrs. Maia had said no?
Yeah,
And did you go to her and understand that it was something that she didn't have to do?
yeah.
Did you ever tell her, if you don't do this, I'm off the job?
No,
Is there a text message like that anywhere?
never.
Is there a text message from her to you saying that, that you have to, that you have to finish it or get off the job?
No.
Okay.
There's a lot of text messages saying how beautiful the work is, how nice the work is, from Regina during the process.
Your Honor, can I approach? Oh, sorry. That's showing you what's been marked as plaintiff 15.
Thank you.
What is that document?
It's a series of text messages between Regina and myself dating from October 31, 2019.
Did you do anything with those text messages other than use to have them transcribed onto that document?
No,
Did you change any text messages?
no,
Did you change any text messages in the set that we have admitted from Mr. Maia?
no.
Why wouldn't you do that?
It would be dishonest, wouldn't it?
How does it make you feel when they call you, when Mr. Maia says that you were editing text messages?
I don't know what to say about Mr. Maia's mental state. But the notion that I'm allying Mr. BS is pretty funny coming from him.
One moment here. I'm almost through. You gave a deposition in this case, didn't you, Mr. Reynolds?
I did.
And in that deposition, did you explain your understanding of the agreement as to the deposit
I did.
and that the walkway wasn't part of the agreement
Yeah, it was a separate agreement.
as well as other items?
Yes, sir.
And what, do you know when that deposition was?
July of 23, 24.
If I said July 14th, 2023, would that sound correct?
Yes, sir.
So the contract we talked a minute ago, the contract, that's the written contract that the VA prepared, who prepared that contract?
Largely Regina per VA guidelines.
Did you prepare the contract and
Some of it with her, yeah,
the schedules and the exhibits?
that's right.
Did you prepare any of the first 7 pages or the first 2 pages? Can you put it up, please? It's exhibit 3. So make it smaller, please, Katie. So that's the first page. Second page, scroll down so the jury can see what page that is. Oh, okay. Is that 3 pages? Kind of went fast there. I think it's 2.
Let's do it.
Like,
Okay.
I mean,
Did you prepare any of the writings on those pages at all?
No.
Do you know who did?
I believe from the VA via Regina.
And that contract discusses the fact that there was an existing metal ramp at that time, correct?
Right, yes, sir. Yep.
And exhibit D of that contract, which is the last exhibit, which is the cost estimate.
Act 1.
Is there anything on this cost estimate related to the covering of the breezeway?
Not a bit.
Why is that term missing?
Well, because from the very beginning of our discussions, the price that I said would take to do the job was $136,000. The VA was approving $120,000, and Regina's way to make that $16,000 become part of it through a separate agreement was to remove the breezeway from the scope and then to call that separate agreement would be go as a deposit to the greater job.
Is there any, Mr. Craig was talking to you about framing. Is that framing referring to the covering of the walkway?
Not a bit.
Okay. Is it discussing roofing or flashing?
No.
Because the walkway is covered in,
Powder coated metal. Yep.
right? I think that's all I have, Your Honor.
Any recross on those points?
So just one moment. So about these text messages, your testimony is you didn't delete any text messages. That's the complete set, right?
Yes, sir, that's my understanding.
And Francisco was just kind of crazy to suggest that you had.
Yeah.
Okay, thank you.
Thank you.
All right, Mr. Reynolds, you can step down. Plaintiff
Do
may call-
you want me to pass these to the court?
If you could leave those stacked by the court reporter, and plaintiff may call their next witness.
Plaintiff would call Karen Hine.
All right.
The bailiff will get her. And,
Just think someone needs to step out and get her.
oh, I thought the bailiff might.
We don't know. We don't know where they are sometimes, so we
Okay.
don't call for them. Whatever.
Number you need to put it up.
Yes, thank you.
You state your name, spell it for the record.
Karen Heim, Heim. Karen, Karen.
See you, Ms. Byrne.
Ready? Good afternoon, Karen. How are you?
I'm fine, thank you.
Good. I'm good, thanks. What is your occupation?
I have a couple, but I'm mostly a bookkeeper.
And who do you do bookkeeping with?
A couple of general contractors and a nonprofit.
And what's your background prior to bookkeeping?
I'm licensed as a commercial general liability claims adjuster, but I haven't done that in over 10 years, probably closer to 15. Prior to that, I was a social worker
Okay. And what part of town do you live in?
in Min Park.
Okay. And you know Simon Reynolds of Reynolds Renovations?
I do,
How long have you known him?
probably 15, 20 years as a friend.
Mm-hmm. And how long have you worked with him?
Eight or so, something like that, 8 or so years.
Right. Do you have a bookkeeping staff? Is it just yourself or?
Just me,
And so when you're doing bookkeeping, who are you working with on behalf of Reynolds Renovations?
Simon.
Okay. So it's the two of you working on this.
That's right. We're just a small business.
Okay. And what what tools do you use to do the bookkeeping?
QuickBooks Desktop. I think it's 2024 edition, might be 2021.
Okay. And were you working with Simon Reynolds Renovations starting in 2019?
Yes,
And you've been working with them continuously since then?
you said them, it's
Him.
him, yes.
Okay. And are you familiar with the bookkeeping of this project that's the subject matter of this case?
Yes,
Okay. And so let me do a little background. Is part of what you do accounting for monies that are paid by the client and costs incurred on the project?
yes,
And so as part of that, do you have a general understanding of the kinds of contracts that or agreements that Mr. Reynolds typically enters into on behalf of the company?
Yes, a
And-
general knowledge, yes.
And so what kinds of contracts are they, to your knowledge? Are they cost plus, fixed price?
Both, but for the most part, it's, yeah, I mean, both. Oftentimes it's cost plus a percentage, and then that becomes the fixed price.
Okay. And what is the typical percentage that Mr. Reynolds Renovations does?
Currently, 30%.
Okay. And what was it in 2019, 2020, 2021?
About, I believe it was 25%.
Okay. As part of the contracts that you've seen come through Reynolds Renovations, have you seen, have there been moments when clients will pay monies in advance?
Certainly.
And what percentage of those contracts have that feature?
I would say for the most part, all of them. The only ones that don't are, I mean, it's rare, but they're usually just small jobs.
And when those monies come in, what's the purpose of those monies, to your knowledge?
Well, it's a deposit on the job. It's to pay for materials and, it's an agreement between Simon and the client that the job is going to go forward. It's like a down payment.
Okay. Is it refundable?
No,
Have you ever had a contract with any of the general contractors you work with where the upfront deposit payment is refundable?
no,
Is it, to your knowledge, normal in the construction industry to not refund initial deposits to start work?
no. The deposits aren't refundable, and oftentimes they're kept even if the job doesn't go forward because the project is canceled for a reason other than the general contractor.
I see. Okay. So that would be the instance where nothing happens and the job doesn't go forward.
Well, what has happened is that estimates have been written and, material costs have been determined and labor costs with the subcontractor. So, that's not nothing. It's work that Simon has done to advance the job. And then after he's done all this work and it doesn't go forward, he's kind of out of luck. So that's why it's another purpose of the deposit.
I see. Okay. As part of your work with Reynolds Renovations, let's see here, sorry, I'm having a little problem here with this computer. Can I take 5 minutes, actually? I have to take a personal break.
Okay. We'll
apologize.
pause. Mr. Joe, we'll be right back with you, okay? All right, you can step into the back.
Fine.
You need some protein?
What?
You can sit down if you need to.
Yeah.
I just need a minute. I think I'm having a hard time talking. My mouth is very,
Okay.
I don't know why. Oh, shit.
Yeah, we'll be off the record here. And Mr. Byrne, if you need, take what your time you need to, and let us know how you're feeling. If you prefer to conduct your direct while sitting down, that's also up to you. So take a minute.
Take your time, sir. Take your
All
time.
right, we'll be back with you.
Okay, let me look at this real quick.
Protein bar?
Are you feeling any pains, anything?
Got another protein bar.
Okay.
Yeah.
I just couldn't think. I'm having a hard time thinking. Um,
Thank you. Thank you. Protein bars for everyone.
You get a protein bar. You get a protein bar.
mm. Just gonna be two.
Take all the time. I don't need you passing out on me.
Take your time.
What was I sounding?
You were like a little slow, but I just assumed you were thinking.
Loosen your tie.
Go ahead.
Loosen your tie, Chris. Stop pretending to be angry.
Okay. Let me call, I'll go out in the hallway and call him and just make sure.
I don't want this to interfere with the case, so I want to keep it going. I don't want to interfere with the case.
No, no, no.
What was the date?
Yeah.
Take the opportunity.
I feel like I'm sounding like I'm slurring my speech.
You're not slurring, you're just talking.
Like a thick tongue.
I don't think so.
On my.
I'm gonna ask the point.
I'll have hooked on it. Yeah, that's your. Haven't seen that before.
Positive.
Yeah.
100%.
As far as I can tell.
Yeah.
Them with like a US number and then it's down.
Yeah.
And they just pop it there,
Oh, fancy.
and they plug it in the USB, and it's the charts. We went all day yesterday and they.
We got that exhibit. Where's that? Oh, she's got it.
She's got it. Spreadsheet.
James, I apologize.
No problem, no problem.
I'm
No
ready
need
to
to
think
apologize.
I don't know what. Feel like I'm slurring my words.
Oh,
That didn't sound, they say it didn't sound like that.
you don't sound like you're slurring to me. No, don't.
It's still shaky.
But why don't you take a little break? We can take a recess.
I don't want to interfere with the case.
As I haven't. We got him a sugary protein bar. too.
seating court come to order?
Apologize, Your Honor.
No, no apology at all. Trials are hard, but you think you're okay? Just happens. It happens. Like I said, feel free to stay seated if you need to.
I think I'd prefer to stand if that's okay.
Okay. All right, we're back on the record, and Mr. Burney has indicated he feels ready to proceed, and so with that, we'll bring back the jury.
Pass out. We'll just come grab you. Hope you don't hit their trial bins. Crack your head on the desk. Funny.
It's gotta be over there. Oh, it's the spreadsheet. It's the square spreadsheet.
I am? Oh, brother.
It's okay.
No, I'm not. You apparently don't know me.
Just fine.
Do you want me to speak up
No, you're
or
fine.
get closer to the mic or anything?
Right.
Harassment, Jerry?
You can just put it up. Get it on there. Got a whole new seat.
Thank you, Lieutenant. Thank you, members of the jury. Please be seated, everyone. Mr. Bernie has indicated he is ready to proceed, and so you may resume questioning.
Thank you, Your Honor.
Put it up.
Chris? I'm sorry, I don't mean to interrupt you, sir. I wanted to know, did you intend to tender Exhibit 15 into evidence? The text messages? Because Lexi's telling me that you did not.
Okay. Well. Let me check it.
If you want to. So he's got the custody copy of it.
Okay.
I want.
I'm showing plaintiff's exhibit 15 is already tendered.
Okay. Great.
Oh, sorry, excuse me, 15A was. So I don't know if as an omnibus exhibit it was tendered.
15 is an omnibus and
Yeah.
15A was a part of that exhibit.
So is there an issue here? We want to tender 15 as an omnibus?
I want to just, because it's a large exhibit
Sure.
and there's maybe some issue about whether there's a page missing or something, I want to make sure that it is because of the sensitive subject matter. It would be something
Okay.
that my office, how preparing for trial.
Understood. It was just for now. We'll readdress that if we need to.
Okay.
Witness has already testified based on that exhibit presented to him from it. And now the court reporter has custody of it. So I would object to going back and handling and reviewing the exhibit before tender. I think.
Right.
I think that's a
Okay.
fair statement.
I guess if it's tendered by either party at some point, we can address these issues.
Okay, thank you.
So at this point, you can resume your direct.
All right. Thank you, Ms. Heim. Sorry about that. I had to take a quick moment there. I want to show you what's been marked and admitted in evidence as plaintiff's exhibit 24. And this is going to appear on your screen there. All right. Ms. Heim, have you seen this document before? This is an invoice. You see this printed, it's an email from Simon Reynolds, correct?
There's a message in the middle that says the host has spotlighted your video for everyone.
Press the blue button. Stay muted.
Stay,
Stay muted.
okay,
There you go.
okay. Now I can see it in its entirety.
Do you need, okay, so I think that's the main, have you seen this document before?
Yes.
And what is this? And it's a 2-page document. If you could scroll down, please, Katie, to let her see the second page.
Okay, thank you.
This is an invoice. We've seen several invoices like this in this case. How are these invoices created, to your knowledge?
Through QuickBooks.
And are they automatically generated? In other words, if you put in the information, you've set the template and it comes out to look like how you've set it up?
Yeah, yes, this is a template, but if you go back to the memo, there was some language added to it. Or usually it's stock language, if you will, that says, your invoice is attached, please pay at your convenience, or words to that effect. But this was modified to note that the payment was I'm sorry, that the invoice was for a deposit.
Okay, and in fact, it says, Dear Regina, the invoice for the covered walkway is attached. per our discussion, this will serve as the deposit for the greater job. Payment is due prior to the commencement of the job.
Correct.
Correct. And the amount of the invoice
$16,380.
and what is the date of the invoice?
Um, I
Or
can't.
the email, I should say.
You can't see the invoice.
It says it's due October 20th, 2020, and that is the date that the email and invoice were generated.
Okay, and, all right. And this is, you've seen this before through Reynolds Renovations, this kind of invoice.
Yes,
Okay, and it's of note to you because the description on the letter is different, correct, than normal, than
Yes.
stock template. Okay.
yes.
And the second page, on the invoice, can you read the description of what the invoice is for?
The covered walkway, footers, posts, roof structure, clear panels for roofing.
Okay. All right, thank you. Let's go to the other exhibit, the spreadsheet. All right, Mrs. Hine, Ms. Hine, I'm showing you what's been marked as plaintiff's 23. Have you seen this document before?
Yes.
Okay, and what is this document?
When we initially invoiced for the balance due on the job and it wasn't paid, after a couple of months, we got this certificate of occupancy and still didn't receive payment. I generated this spreadsheet to show what was owed and then filed a mechanics lien for that amount.
Okay. And so, can you walk us through what this document is? And let's take the top. It says original VA contract amount, $120,279, correct?
Yes,
And it says 16,000 RO paid RR&R.
correct.
And that was on May 5th, 2021, right? At the
That
very
was the
top.
date of the $16,000 payment, yes.
Right, and that was the payment that satisfied the prior invoice that we saw.
Correct.
Okay. And so there's a selection then of entries here, starting with $5,045. Can you walk through what these are?
Okay, the 5,000, starting with the 5,045 and then down to where it says 120,279. Okay, sorry. The 5,045 is a payment that was made to Reynolds Renovation, and it coupled with the 1,075, which was not paid to Reynolds Renovation, it was paid to the City of Atlanta for permits. Those two amounts, sorry, the 5,000, sorry, that it totals $6,120. And that was the initial, on the schedule from the VA. I believe there were 5 or 6 disbursements. And that amount, $6,130, totals the first disbursement.
6,120 or $30?
Yes, correct.
And that
I-
was paid by Mrs. Maya, correct?
Yeah, and it might have been $6,120, and I think, but if I'm doing the math right now, it was $6,120, and yes, those monies were paid by her.
Okay, and then what's the next entry?
The distribution, the second distribution on the VA schedule, and
And that was paid by who?
her,
Right, so she made another payment in August 30th of $13,263.
correct,
And those are all the payments that she made towards the original 120,000
correct,
price. Okay, and then the remaining payments, starting with 21,369, are Tell me about those payments, starting in September 7th, 2021.
So it's distribution 3, 4, 5, and 6 that were made by the VA directly to Reynolds Renovations.
And those were the VA's portion of the monies to pay the grant to Ms. Maia to build the ADU.
Correct.
Okay. And then we come down to the second half of this contract and tell me about these entries.
The first one was the $4,725.07 was a change in the cost of materials. And there's an email from Simon to Karen Anthony at Whitaker Builder and Supply that said, saying I'm going forward, or along those lines saying I'm going forward, and does increase costs, or it's like $4,724. Does that sound right? And so that's what that amount reflects.
And was that paid?
Yes,
And how was it paid?
she paid it with the check.
On or about what date?
October 12th, 2021.
Okay. And then what's the next one?
It's there were tile materials that she ordered, and when they arrived, she didn't like them, or there was some issue with it, and they were unreturnable because of COVID, or whatever was going on at the time, but they were unreturnable to the vendor. And so Simon discussed with her, and I don't know at whose suggestion, but it was used for her front walkway, and that was for the materials. And then the second amount, $2,780.40, was for the labor and subsequent materials.
And to your knowledge, were those two things, did they have anything to do with the ADU?
They did not have anything to do with the ADU.
Know what they were, where they were put?
They were put on her front walkway of the main house.
Okay.
They had nothing to do with the ADU.
And let's look at the next entry, please.
The neighbor had a fence, or I'm not even sure whose fence it was, but I believe it was a shared fence between the properties. And she had a survey done to determine the property line. And that particular survey showed that the neighbor's fence was encroaching on her property. I think it was like by a foot or something like that. And so she wanted the fence replaced. And if I'm not mistaken, it was chain link. I don't recall, but I think she wanted a privacy, wooden privacy fence. And that was the charge was for the survey and for the determination of the fence.
Was it for the survey or just,
Sorry, it was to remove the existing fence, install the concrete, and attach the existing fence to new posts, patches needed, labor and materials. And the verbiage that's on this spreadsheet was taken directly from Reynolds Renovations QuickBooks invoice.
okay. And the next entry?
Add to remove existing vanity top and replace with new, reinstall existing valves and new top. Again, this was verbiage taken directly from the invoice, and it's actually for the main house. It has nothing to do with the ADU.
Okay. And the final one, or the next one, I should say?
So for the vanity, she had written Reynolds a check for $3,000, and mind you, it's February 18th, which is 2 days after I had sent the invoice for the increased amount of $75.36, whatever the amount owed was. So she wrote a check to Reynolds 2 days after I sent that invoice, and we didn't receive any complaints or anything, but the next invoice is for the landscaping and the paving and for the retaining walls. And because, that she had given $3,000, and presumably for the walkway for the retaining walls that were going to be done. And so I applied the invoice for $942.50 to the $3,000, that left a balance of $2,057.50, to which I applied it to the invoice for the retaining wall, and that left the balance of $7,536.50, the amount for which the mechanic's lien was filed.
Okay, so, but when you applied the balance of the 3,000 to the $9,594, that's what you got to?
Yes,
Okay, and so on the left side are the charges. When I say the left side, the column after the second column, those are references of payments by Miss Maia or charges by Miss Maia for things outside the contract, correct?
yes,
And then on the right side, starting with 4725, on the next column over, the third column, those are payments that she made and are applied.
yes, and how they were applied, yes.
Okay. But the one thing that's not applied in any of these numbers is the 16,000, correct?
It's noted at the top as the deposit to start work.
Right, but it's also the charge. Do you understand that? Do you have any understanding of what the 16,000 was for? Referring you to the prior invoice?
It would, it would have been for materials and for the,
Let me refer you back to 24 to refresh your recollection.
Your Honor, I'm going to object to any effort to lead the witness.
All right. Objections noted. I think it's a discretionary issue, leading her through these kind of. You can renew the objection, but at this point, that's overruled.
there is a subsequent invoice for $16,000 even. I don't remember the date. It may be the October 20th, because frequently changes are made. For instance, it was Simon accepted a check of $16,000 instead of $16,380, which is frequently his case where he defers to the client.
Do you know what the 16,000 was for?
Yes, it was for the walkway, and it was marked and as paid with the $16,000. So it was a deposit on the walkway and also to start the VA job.
Okay. All right, so okay. And so let's go back to the other spreadsheet, please. Was that money, that 16,000, was it to be refunded?
No, never.
Did Mrs. Maia ever ask you to refund any monies?
No,
And was she aware when these draws came through to pay Reynolds Renovations from the VA? The ones in column 3?
I'm sorry.
At the top, on the top half of this document, on column 3, starting with $5,045, there's 2 payments she made. There's 3 payments that she made, the first 3, correct?
Yes,
And then there's payments from the VA.
yes, yes.
Was she aware when those payments came? Do you know
Was she aware of?
that these payments were made by the VA?
Yes.
Okay. Did she ever contact you at any time when those payments were made and say, hey, send me that money?
No, in fact, when I applied the $16,000 check that she wrote us, I modified the invoice to reflect deposit. And so she received a copy of it stamped paid with the date that it was paid. And on it, it said it was further clarified that it was a deposit.
And your understanding of the word deposit in the context of Reynolds Renovations is that it's refundable or not refundable?
Absolutely not refundable.
Okay. And so if we take these numbers at the bottom of column 2, it says 143.71. If the 16,000 is not inside the contract, just assume with me that it's not inside the contract for the original VA contract, the covered walkway. If you add that to that, that's going to make the 143.71 increase, wouldn't it?
Yes.
And what would it go to?
I can't see Could you scroll up, please? I can't see. The other way. A little bit more. Thank you. You asked, you just enlarged it so I can't see the whole document. Could you please put it back the way it was? Sorry. Because I can't see the top. Okay, sorry. Okay. I have notes on this because I did some math just to clarify. May
Uh-huh.
I refer
Yes.
to them?
Yes.
And I'm happy to share it. So okay, let me see. Okay. So the 143, let me just make sure. Wait a minute. Okay, here we go. Okay,
So let me just lead you here, or direct you, not lead you, but column 2, you've stated these are amounts due. The top part is the 120 for the ADU, correct?
yes, I can answer your question now.
Okay, and so what I'm trying to say is that where, if anywhere on here, where should the 16,000 be applied?
To the covered walkway.
Okay, and which columns, if any?
Well, it's applied to both columns. I mean, I have the 100, sorry.
But the 16, is the 16,000 that is listed in column 3, is that included in any totals in column 3?
No,
Okay, so it's not applied there. It's not
No.
applied to any, it's not applied to the 135, 535, is it, at the bottom?
no,
And it's not applied to the 15,256.22, is it?
no,
Is it applied as an amount due under an agreement outside the contract to the 143.71?
is it applied to?
So
No,
it's not. So, but if you increase both those numbers by 16,000, the difference of those would be 7536.50, correct?
Objection leading.
Overruled.
do I answer?
Yeah, you can answer.
Yes.
Okay. So to clarify,
You said the difference was $7,536.50?
Correct.
Yes.
all right. I think that's all I have. Thank you.
Cross-examination.
I was just looking at it on the screen.
Yeah. The number is 23. You don't have an electronic copy of 23.
Okay, hang on just a second. Here you go.
Can you just put it up on the screen?
Yeah.
Yeah. Now?
That'd be great. Just one moment, Ms. Hine. We're getting your spreadsheet back up on the screen for you.
Okay.
All right, thank you for being here today. I just want to quickly ask a few questions about the time period when this spreadsheet was created.
Okay,
I see that there's a date marked in the lower right-hand corner, June 13th of 2022. Is that about the time period when this was created?
yes,
Okay. And you created this spreadsheet, correct?
yes.
And you did this at the direction of Mr. Reynolds. Is that right?
I mean, he was aware of it. I was Simon and I discussed, filing a mechanics lien.
Okay. And did he ask you to prepare this for the purpose of filing the mechanics lien?
Not per se,
Uh, I guess, why does it say mechanics lien at the bottom?
because that's the amount that was filed.
Okay,
That's the amount for which the mechanics lien was filed.
okay. So, I mean, it says mechanics lien. You typed that into the spreadsheet,
Correct.
and you did that before filing the mechanics lien?
Yes,
And then this is the spreadsheet you use to calculate the amount of the lien, right?
correct.
Okay. And did you review all this at the time that you were preparing to?
Yes,
Okay. And you looked it over carefully at that time, correct?
I looked it over. Yes.
Not carefully?
I would assume it was carefully. Yes, carefully.
Okay, because filing a lien on somebody's property is kind of a big deal, right?
I suppose so.
Okay. Um, did Mr. Reynolds review this?
Yes,
Okay, and he approved this?
yes,
Okay. And then based on this, you all proceeded with the lien, correct?
yes.
All right. Thank you very much for being here. That's all I wanted to ask of you.
Can you redirect?
No, Your Honor.
All right, can this witness be excused?
Yes.
All right, thank you, ma'am. You can step down.
Thank you.
Plaintiff have any further witnesses for its case in chief?
No, Your Honor. Let me, one moment.
Back to
We have no further witnesses, Your Honor. It's, reserving the right as to attorney's fees.
All right. Would the parties like me to instruct the jury as to that stipulation?
We can, Your Honor. It might be, maybe we do that after lunch. I think
Okay. All right, but at this time,
some things he wants to do.
all right, at this time, the plaintiff rests?
We rest, yeah.
Okay. All right, and are there any motions that we need to take up, Mr. Craig?
I will move for directed verdict.
Okay. All right. So members of the jury, we have something we have to do outside of your presence. And we're still going to try and, I think, get a little bit more evidence in before we do our lunch break. So again, hoping for another just 10-minute break tops here. All right. Thank you.
Yeah, that's me trying to throw their case out.
Can I run to the bathroom?
Yes, yes. Oh, okay.
All right, Mr. Craig, the floor is yours.
All right, yes, Your Honor, at this time, I'd like to move for directed verdict as the plaintiff's case in chief. And I do have a written motion, which I believe we have in the file box. No, got it. I can just email it. Okay, that's all right. I guess we don't have it printed out for you. I apologize, but I can email it to everybody.
You need to step up, things for to inmates. Yeah, great. When council show up, they can go ahead and go on back and start meeting with them on out here or something. Yeah, that's to make sure, that we have. I heard they have. So, I just need to make contact. But this shouldn't be a problem. But they can go back and they get here before noon. Yes, that'd be great. Okay, thank you. All right, and Mr. Craig, why don't you could start summarizing while it's been emailed out the main contentions here in your written motion.
Okay, certainly, Your Honor. So I'm still haven't sent the email. Can you give me just one more second? I'm about to do this. All right. Let's see. Okay, that went to Ms. Sue and Mr. Bernie. Motion for directed verdict was sent to Ms. Sue and Mr. Bernie. Okay. So, Your Honor, we're moving for directed verdict on the ground that the evidence shows clearly that there's been no breach and no damages. Okay? So, let's just start by identifying the contract. All right? So there has been conflicting testimony rendered at trial today about what was the contract between the parties and, were there side agreements or was there just, what document was the contract, et cetera. So I can understand the court might be a little confused on all that, but actually the matter has already been determined by judicial admissions as to what the contract is and what the contract is that the plaintiff is suing on. So,
Is your argument that the complaint locks him in as an admission?
starting with the complaint, okay, but also the PTO. Because the PTO says if the case is based on a contract, either oral or written, the terms of the contract are as follows, or the contract is attached as an exhibit to this order. And the answer given to that is see attachment 1. And attachment 1 is our contract for $120,000. All right. We also have a stipulation on the PTO, which is stipulation number 4, which is that October 20th of 2020, plaintiff and defendants entered into a contract. We also have a request for admissions where they admitted October 20th of 2020, counter plaintiffs and counter defendant entered into a contract. And admission 10, that's a valid and binding agreement. And then we have our interrogatory 14, which says, identify all contracts that you contend exist between yourself and the defendants. And the response was, see attached VA construction contract. That is once again the October 20th, 2020 contract for $120,000. And it's undisputed that this is the contract that was ultimately submitted to the VA for approval, that the VA approved, and that this contract was to provide for the complete construction of the ADU project. So I'd say they're locked in. They're locked in by all these admissions and also by the terms of the complaint, which has never been amended. And the time for amendment is passed when the PTO is entered. But also the text of the PTO, which once again says if the cases are based on a contract, either oral or written, the terms of the contract are as follows. So this is the contract that the case is based on.
All right, to be clear, this would only affect count one, right? Because
I
quantum
like that.
merit is not a contract.
Okay, but you don't get quantum merit when you do have a contract.
These are alternative claims. So if I accept your argument, does it not only affect count one?
I think that the fact that they've admitted that there is a contract between the parties covering the ADU project means they don't get to bring quantum merit. They're alternative claims, but there is an underlying fact here, which is the existence of that contract and that agreement. And, so even if their count one dies, that fact is still true. It still exists. They're still bound by that admission. So they've got a contract for this project, whether their claim for breach survives or not. Now, the second point I have is that there's no damages. All right.
And do you really need an exact figure, or couldn't they just recover nominal damages on a breach of a contract? Meaning $1.
Okay, that's a great question. So as a threshold issue, I was just trying to identify the contract. So now we're coming to this next question of damages. But to get nominal damages, they do have to show a breach.
Right. So that's
Right.
still, that's assuming, they get past that first hurdle. But when you're saying I should grant a directive verdict solely on the issue of damages as an alternative reason for it, doesn't the possibility of nominal damages defeat that entirely? You can certainly argue to the jury, they didn't prove any damages, don't award them any, or only give them the nominal $1. But as a matter of a directed verdict, doesn't just the possibility of nominal damages defeat that argument as an alternative claim?
So quantum merit.
No, this would be back towards the breach.
Okay. Okay. So the question then is whether there was a breach. And so in my motion for directed verdict, I'm definitely arguing there was no breach because her obligation under the contract was to pay the contract price. And the evidence shows she paid that in full. Not only the $120,000 that is the explicit and stated term in the contract, but actually the testimony that was clear and unequivocal from Mr. Reynolds as the sole owner and manager of the company was that the amount of money she had to pay in total was $143.71 let's see here. So his testimony and this proceeding today was exactly consistent with his testimony at deposition. The testimony at this deposition was if Mrs. Maia had paid you this amount, the $143,071.72, the box on row 17, that would have been the total price of all work performed, right? And he said, as represented on the spreadsheet, yes, sir. And then I said, okay, we could have avoided this whole lawsuit essentially. And he said, wow. And then if she had paid this in full, yeah.
Your Honor, this isn't an evidence. I mean, I,
True. I'm just using this as something I've got down in writing that is consistent with and exactly the same as the testimony, not word for word, but it's the same as the testimony that Mr. Reynolds gave on cross. Now, we also have an admission that the actual amount paid is different from what is shown on that spreadsheet. That the actual amount paid is $151,535.22. And let's see here. So in our request for admissions, we presented the following request. From 2020 to March of 2022, counter defendant worked on the project. Throughout the time, counter plaintiffs made several installment payments to counter defendant, totaling not less than $151,535.20. Response: plaintiff admits this request as pled. So we have an admission to an amount due. We have an admission as to the amount paid, and the amount paid is greater than the amount due. So this also is going to apply to quantum merit. And then that takes care of attorney fees, because if there's not an underlying claim, attorney fees are gone.
All right. Well, let me do this. Since you put this in writing, that's very helpful, and I can read that, and I'll do that over our lunch break. If there are any initial reactions, responses from Mr. Burney, I'd like to hear those. And then, as I believe it's within my discretion to do, I'll defer ruling on these. But Mr. Burney.
thank you, Your Honor. First of all, I think that it's clear that in this case, there was a written contract that was for the ADU to applying only to the plans and specifications that are,
So I certainly understand your theory of the case. The first kind of hurdle here is he's raising these procedural issues again, like we did with these witnesses, that the interrogatories weren't properly supplemented, saying that if you had a oral separate contract apart from the written contract, it's not mentioned in the PTO, it's not mentioned in admissions, it's not mentioned in interrogatories.
it talks about other agreements
Okay.
in both the complaint and in the PTO.
Okay. So just want to highlight that for me, because there is a specific line generally about, summarize all the contracts at issue, oral or otherwise.
So what's undisputed in this case is that there are plans and specifications that go to the VA contract. The contract's very clear that these are what are included. Mr. Craig started his opening with, there's only one agreement and this is it. We clearly have shown evidence in this case that there are other things that were outside the contract, the tile on the front walkway, the fence on the north side of the property that was not included in the contract, the retaining wall. There's no mention of any retaining wall in the contract. That's really what the 7,500 really comes from, the retaining wall. Essentially, that's the bulk of the money's due. And so, and Mr. Reynolds and Ms. Hine confirmed today, there's some bookkeeping issues that were done, but the whole case hinges on the idea that the $16,000 is not part of the agreement and it's not refundable. Okay? So that would make it a payment outside the contract in addition to, so that the contract's not $122.79, it's the $136. And so that would take that number up, and it would also then correspondingly take the other number up to make it the $151 at $16,000. And so the point is that we admit it, but she did pay that, but not all of that is for the AAU agreement. There's more agreements in play than just the ADU agreement. And if if the court finds that those aren't agreements, then, which it could, then at quantum mero, it does apply. Because Mr. Reynolds testified that he did this work and that those sums that he did for those works were fair and reasonable,
Well, look,
sums for
I'll
the
put it
work.
this way. I don't think there's any doubt in my mind that there is a conflict in the evidence as to whether it's one whole agreement or whether they're separate agreements, some oral, one written. The only thing that I want to process here and perhaps hear your reactions to is really a procedural issue saying, hey, you shouldn't even be allowed to argue about oral side agreements because when you answered question 9 in the pretrial order, you didn't reference oral agreements. You only referenced the written one. And you're locked in because that's what pretrial orders are supposed to do.
Well, I think they're to be liberally construed, Your Honor. There's no question. I mean, from his deposition in July of 2023, they knew and understood that that was what was happening here, that we didn't agree that the walkway was part of the contract. Mr. Reynolds has testified to that. To the extent that, I would move to amend the pretrial order. I think this is what justice is about. We're trying to determine the intent of the parties.
All right, so understood. So you've made a motion to amend the pretrial order. So I'll take that under advisement as well to incorporate these issues. All right, with that then, I think you've addressed pretty much
So
substance.
I do want to just also say that it's also possible that one of the issues in this case is that the contract that's at issue has an ambiguity in it. And that is that it talks about a walkway in the specifications, but there's no line item on the item cost. Why is that term missing? What is that term? And so the court would then say, well, can we get a whole contract without that? No, and here's why. One, the deposit's not mentioned. The deposit's the key to the case. If they had a text message or one shred of evidence saying the $16,000 was going to be refundable and Simon agreed to that, then I think we would not be able to survive. But we don't. And there's nothing in the contract about a deposit anywhere. Yet, by their conduct, after the contract, they they paid a deposit, and the deposit said for the covered walkway. That creates an ambiguity in the case because it's a missing term in the contract. It's a material term, clearly. It represents about 13% of the whole contract price. And so it's a missing term. The court has to look at that, and all it can do is try to find a reasonable term. But there is no reasonable term because there's no reference in it anywhere. The only evidence is parole evidence. And the parole evidence is clear that the contract that was signed by Ms. Maia and signed by Mr. Reynolds, even though not the binding contract in this case right now, was for $136,000, and the spec, the item cost, job cost included the $16,000 for the covered walkway. That's evidence. That's parole evidence that I think. And there's no merger provision in the agreement. There's no entire agreement provision. They haven't pointed to any. And so the court then says, well, I can't figure out the term. I'm going to have to let the jury determine the intent of the parties. And I think that's the law.
Okay, understood. And so, as I mentioned, I want to read it before I would make any ruling. I will just say at the outset, the issue of the complaint to me implicates 9-11-15B, amendments to conform to the evidence, where if things come out at trial that are different than what are in the complaint or the answer, parties usually got to show prejudice not to allow amendments to the pleadings even mid-trial. And as to interrogatories and admissions, those are admissible. A party can be impeached on them, but it wasn't my understanding that those bind somebody definitively. It's just something for the jury to say and to take into consideration when assessing credibility. And then finally, when it comes to the pretrial order, those also can be amended even mid-trial at the discretion of the court. And so, again, I want to read the motion, make sure procedurally everything matches up. And so I'll go from there. Otherwise, we would then move on to the defense's case. And I'm thinking we get maybe at least 25 minutes, 30 minutes of testimony in before we would break for lunch. And so would you be prepared to get started with that, Mr. Craig?
Just read the rest of it.
Sure, Your Honor. It sounds like we just need a restroom break.
Okay, and you think you'd be calling your client first?
Yeah, I'd be
Alright.
calling her first.
Okay, then let's just, we'll proceed when she's ready and we'll let the jury know and then we'll end up going to maybe like 12:15-ish.
Can we all step out?
That's fine.
For 5? Okay.
All right, we're off the record for a few minutes here.
We're all right.
This is the rest. This is well. There's like sensitive stuff. X.
Well, I mean, you know, yes, they do. I mean, so.
As a point of law.
Yeah, I mean, because.
On that case.
On that, on the denial of the motion. That's just the way it goes. I mean, hey, you know. Check.
He doesn't have his earphone in, so he's not hearing anything. Right?
Oh, whatever.
We're off the record. I'm out. Let me look at this.
We run for Lily yet again. We got time, don't we?
Yeah. I think he said 12:15, Simon.
Sir?
Didn't he say, no, he said 15 minutes.
Yeah, because
Really?
he's like,
No. He said a couple minutes and then,
Go till 12:15.
go till
12:15.
12:15. Yeah.
So I should hang tight.
Probably, yeah. We're gonna be out
or
of here.
just quickly run and pee. I don't know.
No, I'll hang tight. Decide to leave.
Karen's still in the hallway. I told her to wait.
She's gonna be mad at me. I didn't think she was, she seemed too flustered.
I know.
I didn't feel like I could risk it.
No,
What's
I,
that?
She was kind of flustered. Yeah.
I told her outside.
Yeah, yeah.
Yeah, I told her I was like, you seem nervous. And she was like, I was nervous.
She did fine.
Yeah,
I mean, she accomplished what we needed.
blowing anything up.
No.
Yeah, so. Whew.
I just shoved the entire taco in my mouth during one of our breaks.
I left my poor legs in my hands. She was in the bag.
That's your line.
Advising is just getting across the street, getting to your car.
Yeah.
Because I did that the day before yesterday, so.
What?
Kevin aspirin.
Not on me. They might.
I bet you should, they will.
James might. have
Sorry,
this
can we
one.
get an aspirin? Please.
Aspirin?
I would use one
myself.
Wait, he said, he said he did.
Thank you.
All good?
Yes, sir.
It's except for my.
Migraine?
So does that mean you're giving him like crack?
Oh, yeah.
Not again.
Ah, okay. It's in the storage closet.
Just one, right? Just
Council, if you're ready, yeah, ma'am, if you want to go ahead and
my heart.
get situated, feel free.
Ready, Your Honor, and it may not seem like it, but I am watching the clock.
Well, I appreciate your mindfulness. All right, we are back on the record. All parties and council are present, and they've indicated they're ready to proceed. In addition, they've noted he's keeping his eyes on his remaining time, which is appreciated. And so with that, let's bring back the jury and proceed.
It's my kneecap.
It was not.
Yeah, that was. That was my right hip. That was my left hip.
All rise for the jury. I'll adjourn the president counted for you.
Thank you all. Thank you. Please be seated, everyone. So members of the jury, as you heard before the break, plaintiff has now rested their presentation of evidence. And so now we turn to providing the defense with an opportunity to present evidence to defend against the plaintiff's claims or to prove their own counterclaims. And so with that, Mr. Craig, you may call your first witness.
Thank you, Your Honor. Defense calls Regina Maia.
Yes. Regina Ordonez Maia.
Thank you, Ms. Maia, Mrs. Maia. How long have you lived at your current address?
About 20 years.
And who currently resides in the home with you?
My husband, Francisco, who you met yesterday, and my mother.
And did your father live there before he passed away?
Yes.
All right. I'd like to start with a few questions about him.
Your Honor, I don't want to interrupt, but can you speak into the microphone?
Yes.
Thank you.
This,
Go ahead and pull it towards you, Regina.
this it says stay muted, unmute. Do I need to do anything?
If you could click stay muted. Thank you.
Did you tell me your father's name?
Antonio Ordonez.
And was he a named defendant in this case?
Yes.
All right. And he passed away on February 18th of 2023, correct?
Yes.
How old was he when he died?
83.
And was he living with you at that time?
Yes.
And how long did he live with you before he passed away?
We moved my parents in a few months before this contract, so it would have been I guess, oh gosh, around sometime in 2019. So to kind of do the math on that,
Okay.
I guess it was maybe 5 years,
Okay.
maybe.
And your father was a veteran of the armed services?
Yes.
Okay. And when did he serve?
In Vietnam for, I think 6 years, maybe.
6
Maybe,
years?
maybe between 4 and 6 years. I can't remember.
Wow, so not just like one tour.
Right.
Um, and did he see active combat?
Yes.
And what was his role?
He was a combat engineer.
Okay. What did that involve?
So a combat engineer they are the people that go in first. They go in to clear the land. So you helicopter in, you land, and you clear the area of enemy or the opponent, I guess. You clear the land, and then you build the base and secure it, and then the main troops come in.
Okay.
And you also check for IEDs and tunnel clearing and all of that.
Okay. All right. So he's part of a larger team that did all
Mhm.
this.
Right.
Was he ever injured in the line of duty?
Um, he was, and specifically, he had the Agent Orange, which is the majority of his problem.
Okay.
Yeah.
So he was exposed to Agent Orange in the war?
Constantly, yes.
Okay. And was he disabled?
Yes.
And was did his disability get progressively worse over the course of his life?
Yes.
So talk to me about that, how it first showed up, how it progressed, and kind of where things ended up.
Well, I mean, it started basically birth defects with my siblings who passed away. Then in my youth, problems with his legs, being able to walk, feeling wooden. And then the neurological problems just progressed to more psychological. A flash forward to his 80s, he's just completely paralyzed, and in the bed 24/7.
Okay. All right. You said the 80s, his 80s, right?
Well, I guess starting in his 60s, he became confined.
Okay.
So I would say from the 60s on, he became immobile.
Okay.
So it was a long period of time for somebody to be confined with limited mobility, couple decades. The last decade of his life would be totally just immobile, like paralyzed. I would say paralyzed and unable to move, constricted hands, and living with everything turned in from decades of not moving.
Okay. All right. All right. Let's so I handed you Defendant's Exhibit 32. Do you recognize this photograph?
It's my dad.
Okay. And that's a true and accurate picture of him, right?
Yes.
All right. Your Honor, move to admit.
Any objection?
No objection, Your Honor.
All right, Exhibit 32 is admitted.
All right. Can we just zoom in a little bit? So this is him standing, obviously. Do you know about when this picture was taken?
Well, sometime in the 60s. I think looks like he was on leave in New York, or it could have been upon his return.
Okay. All right. And that's his military uniform.
Yes,
All
he
right.
was very proud.
He was very proud?
Oh yeah, that's why he came to America. He's from Ecuador. He came to America to join the military.
I see. Now, was he ultimately drafted though to go to Vietnam?
Right. He tried to join the Air Force and they declined him because he didn't speak English.
I see.
And then he was drafted
Okay.
to be in the Army frontline.
And at some point, did he become an American citizen?
30 years later, he became an
wow.
American citizen. Yes.
After his service?
Yes. In 1995.
Okay. All right. All right. Let's get 31. All right. Is this another picture of your father?
Yes.
I move to admit.
Objection to 31 is admitted.
All right. Can we get that on screen, Lexi? Oh, wow. Okay, there we go. Perfect. All right. So what is this showing?
That's my dad on the ship.
What ship is he
A
on?
ship heading either back or forth to Vietnam.
Okay. All right. And I don't see any guns on the ship, but I see some guns on him.
Yeah.
Was he fit?
Yes. Yeah.
Okay. Was he into fitness his whole life?
Yeah, he's a country boy, lived on a farm, so he was always very, active.
And did he take pride in his physical fitness?
Yes.
Did he try to keep up with his fitness even when these neurological conditions were setting in?
Yes.
How did he work out?
Ah, that's funny. He, cinder blocks. He literally had cinder blocks that he would.
So he improvised cinder block weights to work out with?
Yeah, because he actually did construction,
Oh, I see.
because that's what he did in the Army.
Ah, right,
He was a
right.
combat engineer. That's clearing, building. That's what he did. So.
All right. So we've already talked about sort of the timeline over which his disability progressed. Toward the end of his life, when he was living with you and he was bedridden, was he in any pain?
Significant, yes.
And did he have labored breathing?
He was on an oxygen machine it was needed, yes.
Could he walk?
No,
Could he feed himself?
no,
Could he talk?
limited,
Okay. Was he aware of what was going on around him?
yes. Well,
Okay.
occasionally it's in and out.
Okay. Could he get himself out of bed?
No,
Could he take himself to the restroom?
no.
Okay. Who took care of all that for him?
So I wanted to back up for a moment.
Okay.
Before they lived with us, I split my time between my house and theirs. And my husband, we were newlyweds. I married late in life. My husband insisted they just have to live with us. We had just gotten married, and a couple months later, he's like, move the parents in. It was amazing.
Francisco
Yeah.
insisted on that.
Yeah, because I was splitting my time between two houses, and also over there every day. I'd sleep 50-50, and then also I was over there every day. So I was taking care of my dad in conjunction with hired nurses and nurses provided by the VA.
Okay.
And then Francisco and just immediately jumped in to assist, when I met him. And when they moved in with us, he was also extremely hands-on because my dad, you don't see it here, but is a big guy.
Mhm.
And we had a lift. It was like a little Hoyer lift is what it's called. It's like a little crane. And so you need to get him in that and move him around. But even with that, it's like a 3-person job to do that.
Wow. Okay.
So
49. All right, so there's defendants 29. And this is what do you see in the picture?
So this is where they lived prior to coming to live with us. And
Okay.
he's in a hospital bed, in their living room at their
Okay.
house.
All right, so this is a picture of your father?
Yeah.
All right. Move to admit. Defendants 29.
Any objection?
Objection. Your Honor.
Submitted.
All right. Okay, so I see there's a balloon that says it's your birthday.
Right.
So I'm guessing it was his birthday or pretty close to it.
Right.
He looks pretty happy.
Mhm.
Yeah. Was that a good day for him?
Yeah. This was, prior to his major downfall,
Okay.
prior to when he was with us, that he quickly went into what they called hospice.
Okay.
Right, so it was at-home hospice. So this was before that. She was still, smiling and all of that. So
Okay. All right. Thank you. But this sort of, is this representative of his everyday life at that point in time in that bed,
is in bed 24/7. Yeah.
24/7?
Yes.
In that bed?
Yes.
Okay. Was that a special bed for him or was there a special bed that came later?
No, it was this bed.
Okay. Tell me
This-
about that bed a little bit.
This bed, it's a hospital bed provided by the VA, and the mattress got cylinders of air, and the air rotates. And it's very critical for this mattress to be plugged in with power because the rotating air distributes the body pressure to keep what's called the decubitus ulcers or the pressure ulcers from happening, because his body would have to, also in addition to this, you have to move him every 2 hours minimum. He has to be physically moved every 2 hours in addition to this rotating air that distributes the weight, because if his hand, even just like this for too long, he can't move his hand on his own, that would cause an ulcer. So just the weight would be shifted, that would be a help to prevent that. So the bed has to rotate underneath him, the air.
Now, thank you. Were you designated as his primary caregiver?
Yes,
And was this a designation issued to you by the Veterans Administration?
yes,
And did you undertake special training for that role?
yes.
Okay.
I had to get certified.
You had to get certified?
Yes,
All right. And did the VA monitor the quality of care that you were giving your father?
yes,
Okay. Did you have to change his bedding?
repeatedly throughout the day.
Okay.
So I wanted to just mention that when we moved him into our house, when you say that the VA monitor it,
Mm-hmm.
they had to come and inspect the house when we moved him in with us to make sure that it would be sufficient to care for him, because they wanted to put him in a nursing home.
Okay.
So it was either our house to be acclimated and fixed for him or a nursing home. So they were they monitored what was going to happen with him very closely.
Okay.
So I just wanted to throw that. They were very, very aware.
And you didn't want him in a nursing home?
Well, no. When he was in the hospital, he got released to a nursing home once, and it was the worst decision ever. And I promised I would never do that again.
Okay.
It
How did
was for his
Francisco feel
aftercare.
about that issue?
That's totally something that would never happen in his culture. Nursing homes are just no.
I see.
No,
All right.
he would. No, this is not even not even a discussion. It would not happen. He would not ever allow that.
All right. And so earlier you said you had to change his bedding with some frequency.
Right.
Did you have to change his clothing?
Right, because there's always blood or some thing on it. So it's sheets, undergarments. we often just didn't clothe him anymore, as you can see, because it's just no point.
Okay.
Because it's just constant changing, because he's always bandaged and you have to, it's just in the way.
And did you have to care for his skin?
Right, the skin on somebody in this condition is quite difficult. It's not to be gruesome, but if it's at the point where when you touch them too much, the skin just like slides away. It's you don't see that here, but you have to push, you really have to push the bed into the middle of the room, and several people are around very carefully and gently moving the body around.
Okay.
You need a lot of room.
So I think earlier you said something about an oxygen machine.
Right, and and this picture of him here, we're not showing you the really ugly pictures for a reason, but the oxygen machine takes up room.
I see.
And the Hoyer
So
lift takes
he's
up room.
on the oxygen machine in that picture?
At this point, it was more like evening time use. It wasn't
Okay.
common, but later in my house, it was all the time.
Okay. Constant oxygen.
Right.
Okay. Where did you keep him?
We cleared out all the furniture in the living room, and we put him in the living room. And my mother, of course, they've been married since they were in their 20s. We had to put her bed in there too. So we had her bed, his bed, and then all the medical equipment that was all in the living room.
Okay. Did Mr. Reynolds know about your father's condition?
Yes.
And did he ever meet your father?
He saw him. I don't they did not speak.
Okay.
But as I said, my dad was in the living room. I like to put my dad right in the front window because that gives him some sense of being alive, right? I've had bird feeders out there so he could see things and he would point at the cars, okay. So when Simon would come up on the porch, he often did, Simon would always bring candy and cookies and juice. He's very good about that. And so my dad would always see that. Simon would see my dad, but through the window, because we had a big window, that in that sense, but they did not speak,
Okay. And earlier we noted your father passed away on February 18th of 2023. And was that during the pendency of this lawsuit against you?
Yes.
Okay.
Well, we want me to dive
Go
into
ahead.
that. It
You
was
can.
when they were foreclosing on the house. My dad, I think, wasn't it?
So they initiated suit to foreclose on the house, right?
Well, my dad was in hospice, so.
At that time. Okay. So was he in the main house at that time or was he in the ADU?
It's the main house.
Yeah. Okay. And he was in the living room. Okay. So was he aware that you were being sued?
Yes, yes,
Did he know you were upset?
yes. He cried.
Okay.
Yeah.
Now
Come closer to me.
Yeah.
your mother lives there with you?
Yes.
How old's your mother?
80. She's turning, she's 84. She's 84.
We saw her in the courtroom yesterday, right?
Right.
And why was she here?
She's here because she has late stage Alzheimer's, stage 6, and we can't leave her alone. So there was a big disagreement about whether my husband had been served a subpoena, and he had never been served. But so we volunteered my husband to come in so that he wouldn't get arrested for a subpoena he never got. And so we couldn't leave my mom alone. So we had to bring her, and I did not want her to hear any of this because it's very upsetting.
Okay,
So-
all right. So Francisco is currently caring for your mom today?
Right, yes.
Okay. And he's been charged with caring for her during this lawsuit?
Oh.
While you have to be here?
Right?
Okay. And then yesterday you had to be here and Francisco had to come in,
Mhm.
right? And
Well, he
so-
didn't have to because has never been served, but we volunteered him to make things simple for everybody.
Okay, because you didn't want some subpoena that hadn't been served to be enforced, right?
Right.
Okay. So, did your mom have any disabilities during, so you said she's currently suffering from, was it Alzheimer's
Yes.
that you said? Okay, I'm sorry. I wasn't sure if it was dementia or Alzheimer's.
It's Alzheimer's.
Was she suffering from that at the time of this project?
Yes.
Okay. Does she have any other disabilities?
Not nothing noteworthy that, I mean, just regular like old people stuff,
Can
just
she walk?
It's pretty good. She's fairly good shape, I think, for her age.
Okay,
Yeah.
all right. Does she have trouble recognizing people?
Yes.
Okay.
Yes, she does.
But does she recognize Francisco?
She always recognizes Francisco, and she does not always recognize me. So.
All right. What are we looking at here in Exhibit 43?
Well, you can get a sense of my dad's size.
Okay.
My dad is in the middle, and you can see he's sort of having some difficulty standing or propping him up. This is at my sister's graduation. So it's my dad in the middle, my sister Francisca with the hat, my mom, I'm at the end, and her husband is my brother-in-law at the other side of my dad, sort of propping him up.
Okay.
And this was in the 90s, like 95, but you can see at that point he's having a lot of difficulty standing.
Okay. I move to admit defendants 43.
No objection.
Submitted.
Okay. Just happier times of the family.
Right.
These are the people in the house absent Francisco, who we met yesterday.
Right.
Okay. And we see your dad, is he kind of being supported there?
Right.
Okay. So this was back before he was completely confined to a bed, of course.
Right. He could walk some shorter distances at that point, but it's declining.
Can I see one? All right. So where's Francisco from?
Brazil.
And how'd you meet him?
We met through a mutual friend.
Okay. How long have y'all been married?
8 years.
All right. And what compelled you to marry Francisco?
Well, we got married very fast. We met, it was kind of a whirlwind romance, and fell in love, and we got married very quickly.
Did your family like Francisco?
Yes, and I think actually that's one thing why I think we got married so quickly is because I wanted to get married while my dad and my mom could see that I was married, because they, getting on in life and they're always nagging me. I got married in my 40s, and they just, rested easy. We were in love, and it's my dad would be like two peas in a pod with Francisco. These like kind
They
of
were close?
flamboyant South American men. I hate to stereotype,
I
but
see.
they are alike.
All right.
And just Francisco never actually got to see my dad like that because my dad was somewhat vegetative in a lot of ways.
I
But
see.
I knew that, and my dad, I could sense, through our way of communicating that he liked Francisco a lot.
I see. And has he been diligent in helping you with the care of your father and your mother?
Instrumental. It's amazing.
Okay.
Yeah. I mean, he's done things that I don't like normal people just would not do. It's incredible.
Okay. All right. So is he protective of the family?
Oh, it's a very,
Okay.
very, yeah.
So let's look at the property. Let's do Exhibit 51.
All right, I think that might actually, sounds like this might be a good stopping point.
Great.
Okay. All right, members of the jury, we are going to take our afternoon break. Why don't we be back at about 1:05 to get going and resume again. Don't discuss the case with anyone, including amongst yourselves, and don't do any research. Thank you. Maybe you can step down. All right, anything to take up on behalf of the plaintiff before we recess?
Your Honor, I would just formally move to withdraw any admissions that were made in this case. I would note that the contradictory evidence of the admissions was offered and admitted into this case and was not objected to by the defendant. Therefore, I think that goes toward lack of prejudice in the case. And I think we're required to move to formally withdraw those admissions as well as to amend the pretrial order.
What's the exact admission number you'd be moving to withdraw?
That the number, that the amount that they paid was 151. And I think is that the one you used, James?
Yes, yes. But I don't think y'all are disputing that amount in the evidence.
Like, are you saying they actually paid a different amount?
No, well, I mean, I think what they were saying is that the 151 was paid on the $120,000 contract, and that's not what we're saying. We're saying that of all the agreements that were made and all the services provided, the amount that they paid is 151, but it's not just applied to that contract. And I think that's what they were trying to imply.
I think that's the argument they're making. I think it would be helpful to, because I don't have a copy of the admissions. They weren't attached to like the motion or somewhere else on the docket. So if you can point to me the exact admission that you think you need to withdraw, then I'll hear that and consider that. It sounds like perhaps maybe
Well,
that isn't, but
Sorry.
yeah, that's fine. So you can come back to me with that. But noted. Anything else?
No, Your Honor.
All right. And Mr. Craig, anything on your part?
No, Your Honor. We're going to lunch, right?
That's right.
All
That's
right.
right. I'll again say, or note, we've got some criminal defendants coming in for pleas. Feel free to leave all your stuff where it is. They'll just be using the podium and the courtroom will still be open. But we'll see you back at that point. We'll be in recess.
Walk with you.
I need to go
Oh,
down
what
and get
time?
lunch.
Let's ready to go at 1:05.
Thank you.
Okay, yeah, yeah.
I'm gonna take this with me though.
We got defense counsel yet?
Yeah.
Oh, they snuck in?
They're in that conference. Well,
I thought they were gonna go back and visit with him.
she was just waiting her. She went through the other side.
Oh, okay. All right. Well, I'm gonna go finish my sandwich then.
I'm going to lunch, right?
Yeah. And we gotta wait on, Clarence.
Yeah.
What's his name too?
Unless he,
Is he coming too?
I haven't heard from him and she hasn't either.
Maybe she
so
can get
maybe
him
we can
Maybe she can get him to wait.
talk to him, twist his arm. That's all right. Probation is on its own. Soon as we get the ADA, we ready.
You looking for someone? Okay. You know if it's gonna be a while before they start? Start what?
Oh, they're supposed to have Jordan Pack in here.
I don't know, I know they're gonna start, but I'm not sure what.
When? I just wanna make sure I can run out for a second.
Who was it that just came in?
It looks like a family member for one of the, from Jordan Pack, cause she asked about Jordan Pack.
Okay.
She asked what time it's gonna start, but I don't know what time it's starting. What time we start?
Whenever the ADA get here.
Oh,
It was supposed to be at noon. The judge finished
yeah,
a little later. And
okay,
Hornsby's in the back to the.
okay. I heard your voice about 15-20 minutes ago in here.
Yeah, I had come a little early,
Boy,
but I don't know what nobody else is.
Cheryl,
I'm the only one.
well,
Joya says she running a little late.
okay.
What was the time, start time?
Well,
Yeah, but Judge went a little late.
yeah, but we didn't know y'all were going a little late. We were thinking it was gonna be at 12, so all I'm saying is, yeah, I'm okay with him running a little late, but I'm just saying.
What you saying?
I'm saying these other folk, I'm usually walking in here late. So I like to say it when I'm on time.
Okay.
How you been doing?
I'm well, thank you.
Is this,
Civil.
oh, well, who trying to mention stay?
That's downstairs.
So you're trying to brag you was on time?
Yes, ma'am. I have to take it when I can. Y'all know.
I had a blue and white polka dot dress I was gonna wear today, and I was like, I just feel like ironing.
See, this is one of them you ain't got time.
So what are we doing with Lee?
I might set aside and put it back on the same bond. It's a real dumb case, and I told her, girl, we don't need to know, we don't need to, oh, sorry. What is it we gonna do? Oh, I'm sorry.
So you're just gonna plead them?
No, she won't.
I'm not plead, but I'm saying you enter not guilty.
Yeah, I did that. I'm
Okay,
waiting
well,
on
you're
her to
good
sign.
on him.
I'm waiting on her to sign.
Okay. Yes,
Oh, I've been there, something, you want me.
that's fine.
Can Boyd give me permission to record?
It has to be, I think it's in here.
Oh.
Cause we had to change hosts.
Okay. Hi, Judge Boyd.
Okay, so I'm gonna get you host back. Is
I can do it myself in there.
Okay,
I
it's the host in here now.
I know, but I can do it at the, at my
Cheryl,
desk.
you give me permission?
I just did.
Okay, thank you.
Why is it not?
What, you
So,
say how late? It's in trial downstairs?
Judge Boyd.
yeah, Judge, there's a real Judge Boyd.
Oh, I believe that.
5 minutes, but that was 15 minutes ago.
But there's not a Judge Derryberry.
Yes,
No, she started back at 1:05.
105. Yeah, I hate to move away.
So is he gonna grant you permission to handle Johnson's cases?
He probably would, cause he gets out. He's finished. As the judge states, he's finished. He gets probation. He's got other places he could go. He's finished with us. Yeah, he ain't gonna wait on job. She said a few minutes late. Let me call him. Okay.
So we're not doing nothing with Lee?
It's not guilty.
Okay.
It's a little cold in here.
That's the state.
The show, we're just doing pack. No bond, no motion for bond. Okay.
Boy, can you make yourself the host? I need to sign off. Never mind.
Still haven't come back?
She went on your phone.
They called it the.
Yeah. I was like, you heard that door.
Yeah. Still can't find her.
Don't look like they're gonna do it.
Nope. She's on the way.
Who's one?
DA. Said she was on 7.
Oh, so what's her name still in the room?
She's outside talking to his other attorney. So as soon as she gets here, we ready.
Hi.
I just may have to make sure Clarence doesn't mind And I'm sure Jordan won't mind.
Okay.
If I sign. So for Clarence, do I put for Clarence? What's Johnson? Okay.
Ready?
Yeah, I need to. Sign. Oh, here, thing to draw you, I need you to sign. This is Mr. Lee's. Yeah, I think her came blessed up. She started this.
Okay.
And got a, she didn't even get a butt whoop, she got some scratches. So I'm through with her. I promise you, we don't put it guilty. This is Clarence. So, yeah. Okay. Maybe. I believe.
Where are you sitting?
Right here? Yeah, I can sit at the table.
What's
Just
that?
slide the stuff over.
Let's just have, who are we talking about?
Yeah.
I wouldn't mess with their stuff. We just have, hey, y'all. Yeah, let's just have
I'm gonna
Mr.
stand there and.
Maybe Ms. Rutland, you can just use this little
Okay.
thing in front of the
That's
jury
perfect.
box.
And I can sit here? Judge?
Yeah, yeah, of course. What's up? We're just about ready, or we need more?
We just go ahead. Okay, yeah. The other one they already finished, yeah.
Here's this.
Shoot, I didn't put his,
Are you in a trial,
Let me upload this,
Attorney Rutland?
No, I'm not.
Okay.
So how did jury selection go?
You didn't need me.
Where he took a plea?
No, Cassie Hall was sitting with him on the trial for the rest of the trial. And she had an immunity motion the morning of jury selection. So he was asking me to sit with him for jury selection. But then she got her immunity motion moved, so he didn't need me.
Okay.
Yes. Okay, I stand there. I've signed these indictments. And I put my name for him. This. As we said, this is the other one, sorry, as I said. The same prices.
all right, before we go on the record, let me just check in with counsel. What is the global outcome here?
It's gonna be time served with 15 years probation.
He's been in 3 years and I think a month or a little over a month.
Okay.
And he's just to explain a little bit, he's got the 3 years Fed time he has to serve. all of it.
So is he getting, so he's going back to federal custody after this? Is that the
He has to
expectation?
go back. Yeah, he isn't getting any credit for our time. And the judge who sentenced him federally knew that, so that he took that into consideration when he's giving him the other time.
So for the credit in this time, though, he would get credit for federal time, though.
No, federal, he never got any time.
No, no, but for this case, when he went, didn't he go over to the federal
Yeah,
custody for a while?
But see, he was on loan. He was still always at all times in our custody.
Right. So like, it
They-
counts
they
for
want
us.
that- Yeah, it just counts for us.
Right.
And
Okay.
he has to start whenever he gets there is when his sentence starts.
Understand.
When
So-
he gets in the Department of Correction.
So essentially, he's done how much time with us?
He's done 3 years and 30 days, but I'm not the best mathematician.
So
tried.
basically 3 years, and then now the expectation is he's going back to the feds to do another 3 years.
Yeah, he's got a few little pit stops that he's got to make in some other counties, but then he's going on to the feds to.
All right.
And he
And
won't start his time until he actually gets in the feds.
it's on all of the offenses on these indictments?
I'm sorry.
Sorry, it's on all 4 indictments that remain. Okay. So in terms of outlining, every one of the offenses, I don't know if that's going to be entirely necessary. I think that's included in the script in case people aren't formally arraigned.
Okay,
But he waived arraignment. That's part of the record.
okay,
So I don't think you really need that.
okay,
There's
Uh,
only one case, which is 22 SC 1819993 that is being reduced beyond
Sure.
robbery charge. I'm just. I
Sure.
don't know.
Maybe it's probably worth noting that, but in terms of, how you would go count by count, I don't think that's actually
okay,
necessary to accept a plea.
okay.
You can just kind of summarize, as you've signed, or however you want to do it. Let's see what you come up with. Otherwise, anything else you're waiting on the state's end? All right. Anything, Miss Hornsby, we're waiting on your end?
Nothing, and I have gotten Mr. Johnson, he has 2 of the cases.
Mhm.
I've got his express permission to be able to stand in for him.
All right.
And Mr. Pack has agreed that I can stand in.
Understood. Well, let's make sure we get that on the record
Yes,
then.
sir.
Ready, Ms. Smith? All right, we are on the record now with 4 cases, all State versus Jordan Pack. 2 of these cases are have Mr. Clarence Johnson as defense attorney of record, and that's 22 SC 180440 and 22 SC 181993. Then the 2 other cases, we have Ms. Hornsby as counsel of record, 23 SC 186680 and 23 SC 186688. And Mr. Pack is present and Ms. Hornsby is present, and the state is here through Ms. Rutland. And as I understand, Ms. Hornsby has permission on behalf of her client and Mr. Johnson to resolve all of these cases without Mr. Johnson being present here. Is that right, Ms. Hornsby?
That is true. We have jointly negotiated and dealt with these cases. And so he gave me permission because he had another court appearance.
All right. And the parties have reached a negotiated resolution in this case. Is that right, Ms. Rutland?
Yes, that is correct.
Okay. And Ms. Hornsby, Mr. Pack has signed each of these indictments indicating the change of plea that he wishes to enter a guilty plea and that he understands the nature of these offenses and the ranges that are involved with them.
Yes.
All right. Ms. Rutland.
Mr. Pack, will you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you. We'll need you to just speak up a little and you can lower your. Will you please state your true, correct, and legal name?
Jordan Pat?
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you? Or I'm sorry, is there any medication that you normally take that you've not been given today?
No, ma'am.
How old are you and how far have you gone in school?
35 and some college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to the charges in these indictments? And if you plead not guilty or remain silent, you can have a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyers about all of the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
Yes, ma'am.
Do you need any additional time to discuss the case with your attorneys?
No, ma'am.
Are you satisfied with their services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
And do you waive formal reading and any and all defects in the indictment for purposes of this plea?
Yes.
Mr. Pack, have you been arrested on these charges?
Yes, ma'am.
Okay, the state is unaware of any outstanding warrants related to these charges. Has your attorney advised you of the minimum and maximum sentence for each charge you're pleading to?
Yes, ma'am.
And do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court a global. Did you want me to go one by one for those or?
At some point in the plea, we should do that. But if you're just getting through the colloquy, I think you could just describe the offer globally.
Okay. A global offer of. $15 years to serve 1,127 days. And there are special conditions to your probation. One of those special conditions are you consenting to a Fourth Amendment waiver. You are to have no contact with any of the named victims in the indictments. You're to have no weapons or replicas of weapons. You're to have no drugs or alcohol without a valid prescription. You are to complete 100 hours of community service. You are to enroll in and complete an anger management course. and you are to complete an MRT course and maintain gainful employment upon your release. Do you understand?
Yes, ma'am.
Okay.
Just one thing, and I forgot to speak with Ms. Rutland. One of the named victims is Elizabeth Smith. She is the mother to his child. I have spoken several times to her, and even during his incarceration, she's allowed the son to visit him. And so, other than Ms. Smith, we're just asking that there be no violent contact because she has a good relationship and has spoken with him throughout his prison stint. That's the only victim.
Okay, so you're to have no contact with the named victims with the exception of Elizabeth Smith.
Yes.
Where you're to have no violent contact with Elizabeth Smith. Okay. Are you aware that the court does not have to accept the recommendation? And the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after another?
Yes, ma'am.
Do you understand that if you do not accept the court sentence, you may withdraw your plea?
Yes, ma'am.
Do you understand that you may not withdraw your guilty plea if the court orders a sentence other than your counsel's recommendation?
Yes, ma'am.
Do you understand that you have until the end of the term of court to file a motion to withdraw your guilty plea?
Yes, ma'am.
And do you understand that if you chose to file a motion to withdraw your guilty plea, the discretion to grant that motion lies within the discretion of the court?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand the general conditions of probation?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
And do you understand that if you are charged with a crime in the future, this plea may be used to enhance sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Are you a US citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses against you and to question them, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove that you're guilty of each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, and the jury would be instructed they cannot use your choice against you, the right to present other evidence of your own and call your own witnesses if you chose to, and the right to appeal of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands these rights they'll be waiving by pleading to these charges?
Yes.
Mr. Pack, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive the rights we just talked about and enter a plea of guilty because you are in fact guilty?
Yes, ma'am.
As to indictment 22SC 180440, you're charged with aggravated assault, family violence, and simple assault, family violence. You'll be sentenced to 15 years to serve 1,127 days.
Let's just do this to make it easier. We'll round down to 37 months, which is also basically 3 years.
Okay.
He'll get full credit for all the time, but I think he can just say 3 years.
Thank you. You'll get credit for 3 years, serve 3 years, and abide by the special conditions that we spoke about. How do you plead in that case?
Guilty.
And as to indictment 22SC 181993, you are charged with armed robbery. We are reducing that to robbery by intimidation. You are charged with aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, simple battery, and possession of a firearm by a convicted felon. On the robbery, you'll be sentenced to 15 years to serve 15 years to serve 3 years with the balance probated. The same on count 2. On count 3, possession of a firearm during the commission of a felony, you will be sentenced to 5 years to serve, to run consecutive to counts 1 and 2, and that sentence will be suspended. And on simple battery, you have completed your 12 months to serve, and possession of a firearm by a convicted felon, you are to serve 3 years. How do you plead?
Guilty.
As to indictment 23 SC 186680, you're charged with 4 counts of aggravated assault, which will hold the same sentence of 15 years to serve 3 years with the balance probated. You're charged with 4 counts of possession of a firearm, possession of a firearm during the commission of a felony, where you're served 5 years consecutive to counts 1 through 4, and the sentence will be consecutive suspended. You are also charged with 2 counts of criminal damage to property, where you have served 3 years, and that is the sentence, as well as criminal trespass, 2 counts of criminal trespass, where you have served your 12 months, and use of a firearm by a convicted felon during the commission of a crime, you are sentenced to 10 years to serve 3 years with the balance probated. How do you plead in that case?
Guilty.
Let me pause you on that one, Ms. Rutland. I just want to make sure we've considered merger issues. It looks like that's one offense state with 4 victims. I don't know, you know the facts of the case. I'm just going off the indictment, and he only has, does he have 1 firearm or more than 1 firearm?
Firearm.
All right, so I believe that those would all merge. So there would just be 1 possession during the commission and 1 firearm by the convicted felon.
Okay.
Unless you think differently.
No, I
All right. Then we'll adjust your recommendation accordingly, and we can keep going.
don't. Okay. As for indictment 23 SC 186688, you're charged with 5 counts of aggravated assault. You'll be sentenced to 15 years to serve 3 years with the balance probated. It will be subject to the special conditions that we spoke about previously. You're also charged with terroristic threats and acts, where you have already served 3 years, so that sentence will be done. Possession of a firearm during the commission of a felony, you are to serve, it's a sentence of 5 years to serve, consecutive, ended. And on the criminal trespass, you have already served 12 months. And on the possession of a firearm by a convicted felon, it will be a sentence of 10 years to serve 3 years with the balance probated. This case will also be subject to the special conditions that we spoke about. And
Guilty.
is this guilt, are these guilty pleas freely and voluntarily given with full knowledge of the facts, full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am.
And do you understand that you have until the end of this term of court or 30 days, whichever is later, to move to withdraw your plea?
Yes, ma'am.
Do you understand that you have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. And Your Honor, I believe the state and defense stipulate to a factual basis on in each case.
Yes, sir.
All right, any though thing that should be on the record regarding victims in these cases?
No, Your Honor. We hadn't been able to contact in 22 SC 181993, we hadn't been able to contact the victim.
All right, and then another thing I would note is on the indictment ending in 680, the one with the most counts, count 13 is possession of a firearm by a convicted felon under 133, and it has the enhancement provision where the minimum on that is actually 15 years. It's not the usual 5 years consecutive or 10. So just I'll note that to make sure the sentence is not a void sentence. So that's going to have to run consecutively to the, either during the commission or vice versa, just meaning there's going to be a longer term of a suspended sentence.
Of a suspended sentence.
Right.
They'll still probably be in the term of the probation too. I mean, because it's, aren't they all running? Oh, no, it's
It's the suspended,
consecutive.
yeah.
Okay,
We'll sort it out here and see. Is there any, did he have some pending probation in Fulton County at all?
no.
Okay. Mr. Kuzu, I believe you're joining us by Zoom. Is there anything that you can add on behalf of probation?
No, Your Honor. He just has active probation in Douglas County. He should have a hold for there.
All right. Ms. Hornsby.
Thank you, Your Honor. Jordan, I know he's got a lot going on during that period of time. But I'd like to kind of tell you a little bit about him. I actually, without realizing when I took this case back in December, I realized that I knew Jordan when he was a youngster. At 10 months old, he was placed into foster care without knowing his mother, his family, or anybody. At approximately four, he was adopted by the Pack family. That's when I first remember, because I know his mother. And I remember they adopted this beautiful little boy. We're very proud of him. He had trouble during the period of he did good in elementary school, honor roll. The beginning of middle school, he started out good, but that's where he started getting lost academically. Getting in trouble, little bits of trouble, just being kind of like, I guess what I would say, mannish and a nuisance to little things that he shouldn't have done, but it was what it was. And as he got a little older in high school, he tells me he stopped going. He just kind of was out messing with cars that weren't his, doing joyriding kind of things, but nothing really of a violent nature. But I think, unfortunately, I think at age 16, his adoptive parents relinquished their parental rights and turned him back over to defects. And so from 16 to 17, Jordan was back into defects custody and he aged out. Now, during the time that he got initially into the Pack home, he was diagnosed as a small child with several mental diagnoses, bipolar, manic depression. He says neurosis, which is the loss of control and empathy. He had formal diagnoses, and one of the requirements of his adoption was that he have this counseling and this help for conditions that he was diagnosed with at 4 years old. So he ended up just having trouble functioning. He had big questions about his parentage, his family. Mrs. Pack, I think she did, they were middle-class family, had given him a good home. And so not understanding why he would want to go back. But he had these questions to learn and to know, and I think that caused some confusion in the family dynamics. He had this, he tells me he had a burning desire to know, and that Miss Pack, his mom, he calls her mom still, it was just greatly discouraged and caused friction. He was kicked out of, he was in a mental health facility around, what age was that? 15. And after being kicked out of that facility, which I think the Packs thought was the kind of the last straw to try and help him, that's when they turned him back into defects and surrendered their parental rights. And from there, life just got bad for Jordan. And he just started, he tried to work. He's very smart. But I think he just was lost. And so for a period of years, he would be good and not get in trouble. Is that accurate? And then he'd get in trouble. He just kind of would lose his way, and henceforth this set of circumstances. He has been in custody since 2022. And as he went over to the federal system, he started to realize and do things to better himself. You know, the way you can take courses, he's probably took them all. His girlfriend, who's been here faithfully with him before he went in, she's noted that she's seen a change in who Jordan is. But she has all the certificates. I was like, I could wave them and throw them up, but I won't. I think you take my word that there are 112 dealing with anger issues, parenting issues, business, decisive thinking, and just all things that are geared toward getting Jordan on track about his future whenever he gets out of prison. He has one son who is his everything. He is Jacquez. Jacquez was 3 when he went into prison. Through Miss Smith, who is the mother, I've spoken with her several times. She, through her communication with Jordan while he's been in setting up visitation, she says she sees a change in Jordan. And she actually told me she looked forward to him being released and co-parenting because she sees the son when he comes home from his visits. He's happy, he's giddy, and he's excited about his father. He's 6 years old now. Now, knowing that when he gets out, Jacquez will be 9 or close to 10. There is still a lot of life that Jordan can contribute. He got his GED at 16. And when he took it, the highest score you can get on the GED, Jordan got it. He's just bright. He has his commercial driver's license. So, you know, whenever he gets out, he's always got that to be able to fall on. And I think, you know, I have gotten to know him a little bit better from the little boy, the cute little boy that I saw when they first adopted him, to the man who has a troubled past, but is committed to doing something different. Primarily his focus and his desire is his son. He talks about him, and that's probably one of the few times he smiles real big when he's talking about his son. But he's had a hard life. I believe and trust that Jordan, you know, he has, with 15 years probation, the feds gave him the 3 years and then 3 years of intense supervised like probation after that. I think all of these things will help Jordan stay focused and become a productive citizen. If he doesn't, he going back to prison. I mean, it's just no other way. So respectfully, we would ask Your Honor to accept it. He did have, whenever the court is ready, he did want to say something, but I want to thank Ms. Singleton for being here and always supporting him.
All right. Well, I think this would be his opportunity. Mr. Pack?
How you doing? I want to apologize first for my actions. So I understand. I took a lot of classes that give me different mechanisms to deal with. I think like the gist of everything is my anger. So from different things that done happened to me in my life, it's like I get mad, and I don't learn to understand that I can't do like whatever comes to my head or whatever I deem necessary. That's not society acceptable. So I had to learn different mechanisms to deal with my issues and outburst or whatever the situation may be. But I understand that like life is about decision making. And so I can choose to go forward, backward, right, left, it's on me. And unfortunately, I done did things that made me move backwards instead of forward. And so I don't think it's too late, but I just use everything I learned and keep moving forward.
Thank you for sharing that, Mr. Pack. And I think you recognize by, you know, the nature of the number of the cases and the nature of the offenses, we're kind of beyond that point of second chances. And you have a serious sentence that reflects that. But it could have been much worse for you. And I hope that, as counsel points out, you'd be thinking of your son throughout the next several years and when you are released and rejoin us in society, because like I said, it's not just going to be that term of probation hanging over your head. It's actually another, I think, 20 years of a suspended sentence that could be revoked as well. So you could come back, and if the state presents a witness and proves the case, that's 30 years revoked. So just remember that there's something, another additional motivation to keep you on the right path. All right. Do you understand the nature of all these charges?
Yes, sir.
And you still wish to waive all your rights and enter a pleas to each of these indictments and all of these counts that remain?
Yes.
And that's because you committed these offenses?
Yes, sir.
And Ms. Hornsby, you're satisfied your client is competent that the plea is knowing and voluntary and that there is a sufficient factual basis?
Yes.
All right, well, I agree, and I'll accept the plea and make those same findings. And I'll sentence you, Mr. Pack, as recommended by the parties on the indictment ending in 4400. The sentence would be 15 years to serve, 3 years with the balance on probation. You'd receive full credit for the time you've already served. And I would also note for the record, and it's my understanding, that you've also received a federal sentence for 3 years, that you would not receive any credit as of yet for that. So after you've completed this sentence, which essentially you're now expected to go to the federal custody and serve an additional 3 years. So you'll be confined for a total of 6 years as a result, and since the date of your arrest on these cases.
Only thing, I'm so sorry to
Sure.
interrupt, Your Honor. I was just asked, and I don't know if we talked about this, we've been talking so long about this, that the sentences that we have just run concurrent with that sentence, because they ran theirs concurrent with us, so that the time would be.
All right. Okay, noted. So count 2 on this original indictment would be 12 months to serve. The special conditions for this case and for the next 3 cases I'm about to describe will be that you're to be submitted to a Fourth Amendment waiver. You're to complete 100 hours of community service. You're to complete an anger management course, or show proof that you've done one since the date of your arrest. You're not to consume any drugs or alcohol without a prescription. You're to complete an MRT class, or again, show proof of completion of a comparable class since the date of your arrest. You're not to possess any weapons or any replicas of any weapons. You're not to have contact with any of the listed victims here, except no violent contact with a Miss Elizabeth Smith. For any technical violations like failure to report, those will be handled under the sentencing option system with a sanctions cap of PDC or RSAP. You're also to make your best efforts to stay gainfully employed once you're released. The sentence is going to run concurrent to all 4 of these cases, as well as to your federal sentence. And as to the indictment ending in 993, reduced to robbery, again, that's 15 years to serve, 3 years, balance on probation on counts 1 and 2. Count 3 is 5 years to serve consecutive to count 1, but that is suspended. And counts 4 is a misdemeanor, 12 months to serve. Count 5 is going to be, I think it was a straight 3 years to serve, which was recommended. Same conditions as the other sentence. And also the conditions of your suspended sentence in this case and all 4 of these cases, to the extent there are any suspended sentences, are the same as your general conditions of probation. For the indictment ending in 6680, the 4 counts of aggravated assault, that's 15 years to serve, 3 years, balance on probation. Count 4, possession of a firearm during the commission, is 5 years to serve, suspended, consecutive to count 1. The remaining possession of a firearm during the commission counts, which was 6, 7, and 8, those all merge into count 4. Criminal damage to property counts, that'll be 3 years to serve. Criminal trespass counts would be 12 months to serve. And the final count, which is possession of a firearm with the enhancement, would be 15 years to serve consecutive to count 4, and that is suspended as well. And then finally, you have the indictment ending in 688 with your 5 counts of aggravated assault, and that's, again, 15 years to serve, 3 years with the balance on probation. Count 6, I think that was 3 years to serve, a straight service, and then 7, 5 years to serve consecutive to count 5. 8, criminal trespass, 12 months to serve, and 9, this is the regular possession of a firearm by a convicted felon. That is 3 years to serve. Those all counts to run concurrent that aren't noted as running consecutively. I believe I've covered it all. Ms. Rutland, is there anything that I missed here?
Nothing from the state.
All right. Anything else on your behalf, Ms. Hornsby?
No, Your Honor.
Okay. You have any questions about anything we've talked about here today, Mr. Pack?
No, sir.
And Ms. Akuzu, do you have anything that he needs to know on behalf of probation?
Yes, Your Honor. Just whenever he is released, he needs to report to the Atlanta DCS office within 48 hours. That office is located at 276 Memorial Drive, Southwest Atlanta, Georgia, 30303. Thank you.
I'm gonna get this.
All right. Then with that, I believe unless there's anything else, we'll be off the record. Take care, Mr. Pack.
All right.
Thank you, Your Honor. Thank you, Ms. Rutledge.
All right. The other case we had listed, as I understand it, there's going to be a consent order to lift the bench warrant, and it'll be further noticed.
Yes.
All right. All right. Thank you all.
Complete my business. Thank you for scheduling.
See ya.
Thank you.
Ms. Rutland, did you end up, are you second chair?
No, I wasn't, and Cassie Hall got her immunity motion moved, so they didn't need me. But he told me there was another
Oh,
one.
I see. There will always be another one.
Right.
All right, I need to step off, folks, if you want to retake retake your positions here. Yeah, I gotta step off.
Okay.
I see y'all Friday. I'll send that one, do that one for me. Okay. Let's do, put in, FCA number, yeah, the FCA number.
Should have did it before lunch.
Okay.
It's not stuffing his face. Yeah, I do. It's a little far.
I didn't really touch anything, huh? Yeah, I just saw the exhibits here, but I didn't touch anything.
Oh, is this your phone? Is this y'all's phone?
No,
Mine,
Might have been defense attorneys, I guess.
Yes.
maybe just leave it there and then she'll come panicking back for it.
Yeah.
Thank you. Seat of federal time.
Different colored jumpsuit.
Different towns.
Yeah, like different offenses.
We live right around.
Okay. I live right by the, yeah. The courthouse is scary.
We used to take, Madison. We used to take his wife there every summer.
Right.
It was a nice school. We went back to Mexico.
What is he going for?
So, they call it that.
But like, particular homicide? Oh.
It's like morning. Expect for you past that. Beer can.
Oh, boy.
Okay.
You're good? Right, okay.
Should have respected.
I put it up. Minutes.
Should have more for you. We'll get another one out. Just checking with Mr. Craig before you grab him. That's fine. That's fine. But why don't we just go ahead and let him know we're gonna be with him very shortly here. Yesterday when they were lining up.
Bosh or something.
Well, oh, no, it wasn't me. But you're welcome. Anytime, anytime. You got the hardest job here.
That much about it. I've actually never gotten a massage.
Fulton County.
Yeah, kind of be quiet over there. I'm not sorry. Or.
Well, but you probably arm have likes you.
All right. Mr. Craig, anything we need to take up on your end before we resume?
One thing.
Okay, let me wait for the court reporter. All right, we're back on the record, and Mr. Craig had asked to address the matter before the jury comes back. Sir.
Yes, Your Honor. So we've got the admissions we were talking about earlier. I've discussed with Mr. Burney the possibility to stipulating to admit those. And I was hoping we could take care of that at this time.
So you got all of the admissions in total marked as an exhibit?
Yes, Your Honor.
All right, and so I guess
That
he's
is-
maying to tender those, Mr. Burney?
We stipulated that, Your Honor.
Okay, so they're admitted as what?
Defendants 14, I believe. Give me just 1 second to verify. Yes, that's 14.
All right, defendant 14 will be deemed admitted. Anything else?
We also like to stipulate to admitting the responses to interrogatories. That's our defendants exhibit 18. And I can get you a copy of that real quick before you.
Is that this supplemental fee?
I think it's the last one that's verified, but let's take it to the work and confirm that.
Assuming these are the accurate copies as you know them to be, Mr. Burney, any objection to that?
Looking at him, Your Honor. 1 second.
Let me see here. Actually.
I mean, if you don't think that's the accurate copy, we can clean that up later, but assuming this is an accurate
Generally
copy.
to the admissibility of the pleading, Your Honor.
Okay, assuming that's an accurate copy, defendants exhibit 18 would be admitted. Anything else, Mr. Craig?
No, Your Honor.
All right. Anything on behalf of the plaintiff?
No, Your Honor.
All right, if we could bring in the jury. And ma'am, you can take back the stand.
Add 14. Yeah.
Yeah. All right. Probably gotta have an extra one in here anyway, just in the drawers. I'll just.
All rise for adjournment. All jails are present.
Thank you, Lieutenant. Please be seated, everyone. Members of the jury, welcome back. And apologies for the delay. I dealt with a criminal-ish case completely unrelated to this one over the lunch break, and it went a little longer than I expected. So we are back here, and the defense can resume their direct examination. Mr. Craig.
Thank you, Your Honor. All right, Mrs. Maia, you ready to resume?
Yes. Yes.
All right. So we've just been talking a little bit about your family and who lives with you at your house. And I'd like to pick up the thread from there and talk to you a little bit, very briefly, just about the house itself.
Okay.
All right, I've handed you what is marked as Defendant's Exhibit 51. Do you recognize that?
It's the front of my house.
All right, move to admit.
Any objection?
No, Your Honor.
Admitted?
All right, can we get that on screen? All right. So I see there's a porch on the front of the house.
Mhm.
And are those some steps leading up to the front porch?
Yes. Yes.
And are those fairly steep?
Yes, there are steep steps, and on the side is the embankment that you can't really walk up there.
Okay. So could you get your father in and out of the house through this entrance?
No.
What about your mom?
Well, back then with hand holding. Today, there is a period of time, no.
Okay.
We were trapped in the house, basically. We
Okay.
can get into that. But today, it's a two-person job to get her up and down the stairs. We had to have a physical therapist come to the house and work with
Okay.
us on it.
Okay.
Occupational therapist, one of those was I forget which one's top. We had both. I don't remember which one actually did the walking.
Okay. Thank you, Mrs. Maya. All right, so let's get another photograph in here. I'll go to 76, actually. All right, so I've handed you what's been marked as Defendant's Exhibit 76. And what does that show?
The backyard.
Is that a photograph of your backyard?
Yeah.
All right, move to admit.
Your Honor, I'd only object to this as the foundation as to when this photograph was taken.
All right, if you can just establish that.
Okay. About when was this photograph taken?
I don't know exactly, maybe within a year or so,
Okay.
perhaps.
Was it before the construction
Yes.
project?
Yes.
All right, so does it show how your backyard looked before this construction project
Yes.
started?
Yes.
Okay. All right, I'll renew my motion to it.
Any objection?
So the testimony is that it's about a year before the construction
I
started?
don't,
No, I'm just asking for his response. Is that was, you heard
I
the
don't think a
testimony?
proper foundation has been laid yet. I think it's rather important. They've said that this is what the house looked like before, and we'd like to establish when this photograph was taken, if they can.
Okay, I think we heard testimony to that, and so it'd be admitted over objection.
Thank you, Your Honor.
All right, so,
elaborate on it? Because,
Sure.
because I'm not sure.
well, it's admitted,
Okay.
Regina. We've got it on the screen behind you, I
Okay.
guess, and in front of you now. So let's just talk about this photograph a little bit.
Mhm.
This is, I think you just testified that this is the way your backyard looked before the construction started, right?
Right. So regardless of the date of the photo, the yard is the same. We didn't do anything except prior to construction, we had the tree removed on the left. And so
Okay.
that would be the only, we had the tree cut down and then one of those grinders come in to remove the roots. So that would have been the only like topographical change to the yard.
Okay, all right. And does this accurately show the slope of the backyard at that time?
Yes.
And did the slope of the backyard change significantly from the time this photograph was taken up to the time that the construction project started?
From this photograph to the time the project is exactly the same.
Okay, all right. So this shows the slope of the backyard at the time that the project started?
This slope is exactly the same.
And so this would be also the same as when the plans for your project were drawn up, correct?
Yes, we had a survey of this at this point in time. Then we had a survey immediately before. They're essentially identical.
Okay,
And then we had a third survey after. So there's 3 surveys of this yard. And
okay,
then immediately before construction, they were identical. And
Okay.
then the post-construction survey.
okay, all right, thank you. And then let's do 65. It's already been admitted. Does this show your backyard after the construction?
Yes.
And I see kind of a cinder block wall in the background.
Right.
Lexi, could you just
Correct.
zoom in a little bit? Is that a retaining wall?
Yes.
Okay. How tall is that?
It's about 3 feet at its on the right side there, and a few inches shorter than that on the left side.
Okay, all right. So we're going to come back to all this. I just kind of wanted to get a look at the house before and after, the front and the back.
I can point out one thing
Okay,
as well.
sure.
The fence there, today, I believe we have photos, but the post holes are present today.
Okay,
You can see where the old fence was and the new fence, and the post holes
okay,
are, I thought it was a typo. They are 3 inches from the old post holes, not 3 feet. I actually thought that was a typo when he wrote it.
okay, all right.
Yeah.
It was moved 3 inches?
Yes, and we have the photos of the post holes where they were before,
Okay.
and then the current fence.
All right. I want to talk more about this,
So
but I
just that
kind of want
you can see
to
that.
set some context so the jury understands its significance. And I want to back up now to the very start of the project. Okay. And you might remember I had these 5 phases of the case.
Okay.
So we're going to talk about the first phase, which is the contract phase, when you were negotiating the terms of your contract. So how did you first meet Mr. Reynolds?
Mr. Reynolds was present during the Chosewood Park Neighborhood Association meetings.
Okay.
And that's how I encountered him. And in 2009, he gave me a free estimate on a porch renovation. And that is really the extent of my interaction with him. I didn't
Okay.
walk my dog by his house and talk with him. I think
Okay.
it had been years. So I don't know. I guess he's trying to establish a rapport. I don't know. After we became, I called him a second time. I didn't take him up on the first estimate for the porch. I called him again to get this estimate. And when we engaged for that, then I often walked my dog by. And so that's really how I met him, was just, he was in the neighborhood association.
Okay. All right. Did you approach him about this job?
I actually asked my husband to text him because
Okay.
I was nervous about approaching Simon first
I see.
because I had said no to his prior job.
Okay.
And
all
I
right.
thought, well, he's gonna try to maybe just not be, I don't know. I had turned him
Okay.
down and he was not happy. I remember
I
him
see.
saying, good luck with that, when I told him I had a better price on the porch. So I was a
see.
little nervous. And so the initial first text was Francisco texting Simon, and then I took it over from that.
Why did you choose to hire him ultimately?
Because I visited his work site in on another house. It was an old house, and then it looked nice. He worked in the neighborhood, lived in the neighborhood. And I thought, what could go wrong? He's so charming and nice.
Mhm.
I just thought it would work, you know? And my husband, man, he's like, get more estimates. And I actually, I'm like, no, he lives here. I went to his job site. It looks good. And I got a waiver. So the VA required 3 estimates, and I
Okay, we're gonna
got a
get
waiver.
into that in the approval phase.
Yeah.
So now, how did Mr. Reynolds influence the concept of the project? Did he make recommendations?
Well, initially this started out as a bathroom.
Okay,
Then it grew to a mom and pop addition to the back of my house.
I see.
And then it grew to an ADU.
How did that
Separate.
happen?
And it was just all, you can't just leave this free money there. You know, this is a
Yeah.
grant. This is a great program. It's all this free money.
Uh-huh.
And so it just kind of grew
I see.
from a bathroom to an entire standalone renovation.
I see.
Addition. So it just escalated because, and I agreed. I mean, you're not gonna, there's like $100,000 there. My dad is entitled to exhaust it, right?
Yeah.
So it grew from a bathroom to an ADU through that process, talking and.
Okay.
So, I mean,
All right.
that.
And did Mr. Reynolds encourage you to move in that direction?
It was a constructive conversation that made sense, and I agreed. And
Okay.
my husband was on board with that too.
All right. Who did the drawings for the building plans?
Shona Griffin,
And was she the designer for the project?
yes.
And how did you first become acquainted with her?
So a number of months into this project, once it developed into the phase of it becoming now an ADU,
Mhm.
Simon said that not just frequently, but he worked exclusively with Shona Griffin, and he had known her for more than a decade.
Okay.
I think he said that everything that he did that required plans, everything except for like one or two projects, Shona did them.
Okay.
And she also was a great expediter. I don't even know whatever that means, but it's something to do with construction stuff. And so she would do the plans and expediting. And so he brought her in from that. And she was like way out in, I don't know, almost to Alabama, like Douglasville or something. And so we would have to do a lot of Zoom or conference calling.
Okay.
So
All right. And who paid her for her work?
Simon,
Okay.
through the VA distributions.
So he brought her into the project and he paid her for the designs.
Yes.
Okay. Had you ever done a project like this before?
No.
Okay. All right. So let's go with two. Oh, you already are. Thank you. All right. What's that? Oh, it's a. Oh, yes. Plaintiffs too. All right. Do we have a PDF? Can we get it up on screen? Okay, great. Gina, this is plaintiffs exhibit number 2. Their exhibit. And take a look at the total price on that.
Okay. 136,000.
Yes, okay. And the date. Take a look at the date.
July 2nd, 2020.
Okay. So this document, does this look similar to the construction contract at issue in this case?
Yes.
And you're familiar with this document?
Yes.
And what is this exactly?
So we had numerous versions of the contract as the requirements changed.
Okay.
And at this point in the contract, you know, in December of 2019, so as I mentioned that this project started out as a bathroom and it escalated to, when I liked that idea, to a standalone building. Now, this grant can be used in 3 ways. You can buy land and build, that's one.
Okay.
You can renovate your house, your existing house, like a bathroom.
Okay.
So it's like an addition, that's 2.
Okay.
Or you can build a building as a second structure, so that's 3.
Okay.
And each one of those belongs to a different review department at the VA.
Okay.
So I actually started my process in 2016. So,
All right.
right, so I had been working for years under the idea that I'm going to be doing a bathroom. Okay.
Okay.
And it was only in 2019 that my approval, there's many steps before Simon, it reached that point where now, okay, I can involve a contractor, Simon. Okay.
Okay.
So I had been working with the addition team.
Okay.
So once we started doing the ADU, we were informed we would have to actually start all over again because now we would be in a different team, which is the ADU team.
Okay.
So in December of 2019, we all had a meeting, Simon, Shona, and myself. How do we fix this? And we involved the VA so that we can stay with the same team and not have to start over at ground zero.
Okay.
And the only way to get this going and to keep my project that I've been working on since 2016
Yeah.
was to create a connection between the ADU and my house. They had to physically touch,
Wow, okay.
right? And so that's why you will say, well, this 136 included a substantial, at this time, a more substantial addition, right?
Okay,
Of a breezeway.
okay. So, I believe, can you look at the bottom of the page and you signed this, correct?
I initialed it.
Okay, you initialed it. And the date is July 2020, excuse me, July 2nd of 2020. So what happened with this agreement?
Well, there are multiple things wrong with it. And it was never approved by the VA, number one.
Okay, was
And
it
for-
submitted to the VA?
No,
Okay,
no. Well, for potential for feedback, but not as routed for approvals.
how did you get from this to the one for 120?
Well, okay, so first of all, I started to get panic because this is just too much. It's just too much money.
Okay,
Okay, it's just ballooned.
but the VA is paying a portion, or are they paying all of it?
No, there were two grants, 100,000 and 6,000. So they
Okay.
paid 106.
Okay,
Okay.
and you paid the rest?
Yes.
Okay,
Okay. And so we talked about, well, okay, this is just all was just is blowing up. So the VA said, you don't have to have such a substantial connection. This doesn't have to be like you're building a whole compound, with a big substantial connection between the two. So it looks like a whole like building, like I have a wing,
uh-huh,
you can just have some beams with a ceiling, right? So
Okay.
I don't know how many beams, there's like 8 or 10, I don't know how many beams. It's the equivalent of something that you can get at like Costco for like a couple grand. It's not a
Okay.
$16,000 breezeway.
okay,
Okay, so we significantly reduced what it is, and we reduced the price because it didn't need to be that substantial anymore, right? You just
Okay.
need to have the things touching, right? And then it's an addition, not a separate structure.
okay. So did you ultimately move forward with this contract?
No.
And, all right, let's go to Exhibit 9. Okay, all right. So let's go ahead and put that on screen. Naming your defendant's Exhibit 9. Sorry, so it's going to be on the screen behind me. Now, what are we looking at here?
This is a contract signed on October 20th, 2020.
Okay. And who are the parties to the contract as identified there in the first paragraph?
It's Antonio Ordonez, my father, myself, and Reynolds Renovations and Restoration.
Okay. And is this the contract that was ultimately agreed upon between the two of you and then submitted to the VA for this project?
Yes.
Okay. So that earlier contract was that sort of an earlier draft of this contract?
Right, and it was torn up.
Okay.
It was not submitted for any approvals. And not only was there this contract, but there were other ones that also failed.
Okay.
So
So
if
this.
we're going to go to anyone, let's go to the one that was 55,000.
Okay.
I'll take that one.
Okay, all right. So, so this Exhibit 9, is this ultimately the contract for building the ADU and the breezeway?
Yes.
Okay. And this has a price on it of $120,279, correct?
Correct.
And did you understand that to include all of the work necessary for the completion of the ADU?
Correct.
And was $120,279 the total price for the whole project?
Correct.
All right. And once this contract was signed, what happened from there? What did you do next? Could Mr. Reynolds begin work right away?
Oh, no. Okay. So no. Well, there was a lot that happened, but I think what you're getting at is, apparently our permits were denied.
Well, I want you to talk generally about the process of getting this approved.
Oh,
And was there a lot of work involved with that? You don't have to describe it in detail, but just a little bit.
right. Oh, yeah. It took months from this point. So there was a lot of discussion back and forth after this. So when we submitted this in October, there were months of discussions after this, refining because this is not just the contract, 7 pages. There's maybe like 30 pages to this. I don't know why nobody's showing you this.
Well,
There's
are you
a lot.
talking about the exhibits?
Yes, there's a ton.
Okay, we're going to get there.
Okay, so all of that is incorporated as part of the contract. So there was a lot of work that went into that. And so
Okay.
there were months of additional work related to this.
When you say months of additional work, are you referring to work communicating with the VA to get everything approved?
Right, because the contract, you see the escape clause, I'm sure you're getting to there. The contract, even though signed, is still not effective until it's approved by the VA.
Okay. All right. Yes, there is a clause about that. Let's take a look at that.
They both have the escape clause.
Oh yes, both of them have that, right? Okay. So let's look at the bottom of page 1 under required conditions. And you see the paragraph entitled escape clause.
Yes.
And can you read that for us?
This contract is conditioned in its entirety upon the veteran receiving a grant under Title 38 USC Chapter 21. And if this veteran does not receive this grant, this contract is null and void, and any and all monies will be returned without exception.
Okay. So your understanding was that if this doesn't get approved, it's null and void.
Right, and the only contract that was submitted for that grant, as it said, this grant, this contract was the only one submitted for that grant.
Okay. All right, great. Was it kind of arduous getting everything approved during that time?
It was nitpicked. It was very arduous. It was looked
You
at
spend
up and down.
a
They
lot
have
of
their-
time?
Yes, their attorneys looking at it. I mean, I had to jump through so many hoops.
Okay, all right.
Crazy.
Was it exhausting?
Yes.
Okay. Now, did you have to get a special waiver for Mr. Reynolds to be approved as the contractor for this?
I did.
And why did you have to do that?
Because the contract or the VA requirements, they required 3 estimates. And with any of the requirements by the VA, it can all be managed by paperwork, right? And so all you have to do is submit the proper paperwork. It's a waiver. So I felt comfortable with Simon, and I submitted a waiver saying I don't want to go through the process of getting the 3 estimates, and here's why. And I had to justify it. And I said, look, I got an estimate before with Simon in 2009. I felt he was upstanding. I've had other estimates on my house for flooring, and I had to compare him to other, I had to do the whole thing. You just have to fill out paperwork, request a waiver to anything that you want to try to work around on the requirements. And I did that. And so
Okay.
you can
So-
work with the VA, you just got to do it the right way.
You were helping him kind of get past a competitive bidding process there?
I felt comfortable with it. So
Okay.
I saw the requirements. There's a way you're allowed to request the waiver, and I did it. I submitted the waiver, it worked through the legal channels, and it was approved.
All right. Okay. So let's look at the text of this contract real quick. The text of the contract, scroll up a little bit, Lexi, to terms. All right. So under paragraph 1 that says terms, would you read that to me?
Paragraph 1 terms?
Yes, all the way down to where it says Exhibit D.
You want me to read that out loud?
Yeah, sorry. Go ahead.
So contractor will complete construction at 1261 Grant Street, Southeast Atlanta, Georgia 30315, according to the following layout and site plans prepared by Ms. Shona Griffin, signed and dated by all parties. Exhibit A contains the narrative description of the plans. It lists the names of the files for Exhibit B and C. That's okay.
Yeah.
The total price will be $120,279 as outlined in Exhibit D.
Now, did you believe that Mr. Reynolds and Reynolds Renovations were going to follow the plans?
Yes.
So in your mind, was this a promise by them to build this project in accordance with these plans
Yes.
and in accordance with the estimate
Yes.
for that price?
Yes.
Let's turn to second page that says change order acknowledgement. There's a paragraph here about change orders. I won't ask you to read it because we've kind of been over this. But did you consider this paragraph to be a promise to you?
Yes.
And did that promise consist of a commitment not to make changes to the plans without change orders?
Yes.
And the change orders, did those have to be reviewed and approved by you?
Yes.
Okay. And then how many days did Mr. Reynolds have to complete the project?
135 days.
Who came up with that number?
Simon?
You didn't come up with that number?
No.
Okay. Would you have been comfortable estimating for him how long the project would take for him to build?
I would have no idea. No.
Okay. All right, let's take a look at exhibit. Wow. Handing you what's been marked as Defendant's Exhibit 8. Do you recognize this document?
Yes, part of the contract.
And what is this?
So um, these are the remaining just requirements, that were needed for approval, to get our contract passed.
Okay. And on the first page, midway down, there's a paragraph about substitutions or deviations to the plans. Right?
Okay.
You see that?
So, yes, I see it.
Could you read that for us? Just the first two sentences.
Sure. Substitutions or deviations to the plans and specifications must be approved by VA in advance. The contractor and the veteran must request approval of any substitutions or deviations by use of a change order VA form 261844.
Okay. And I see some signatures at the bottom. Did you sign this?
Yes,
Did Mr. Reynolds sign this?
yes,
And did you sign for your father?
yes,
Okay. So we've got two documents that say this,
yes.
right? We've got the contract, and then we've got an addendum that's submitted to the VA.
Right.
All right. Let's do Exhibit 20. Yeah. I'm going to come back to that. All right, let's do 114. All right. I've handed you what's been marked as Defendant's Exhibit 114. Do you recognize this?
Yes,
And is this an email from Mr. Reynolds to you?
yes,
And then attached to that email, is there an invoice?
yes.
And all right. I will offer to admit defendants or move to admit Defendant's Exhibit 114.
Any object? No objection is submitted.
All right. So what's the date on this email?
October 2020.
And did you receive this?
Yes.
All right. And what does the text of the email say?
It says, "Dear Regina, the invoice for the covered walkway is attached. Per our discussion, this will serve as the deposit for the greater job. Payment is due prior to the commencement of the job. Thank you for your business. We appreciate it very much."
All right. So what did you think of this when you got it, or how did you respond?
I spoke with Simon.
Okay.
This is not an option.
Okay. Not an option?
No, this is not an option. No.
Yeah, we can't hear you that
No, I
well.
spoke with Simon. This is not
Pull that
feasible.
microphone towards you. Just grab onto it. There you go. And you might need to hold it up a little bit.
Okay.
Francisco really leaned into it.
Okay.
All right. So, do I understand that you told Mr. Reynolds that this was unacceptable?
Correct.
Okay. And did you refuse to pay it?
Correct.
All right. And you had these conversations with him how?
How, on the phone?
Okay. And did he indicate that he would still proceed with the project anyway?
Yes,
Okay. So now this is dated October 20th. That's the same day that y'all signed the contract.
yes,
So then you sign the contract, you get this invoice, you have the conversation. And is it your understanding from that point forward that you're moving forward under the terms of the contract without this change?
correct.
Okay. And then are you at that point investing your time into the approval process in reliance on this contract?
Correct.
Okay. Did you agree to pay him an extra $16,380
No.
to build out the breezeway?
No,
Did you pay him $16,380 at that time?
not at this time, no.
Did you ever tender a payment in that exact amount?
No.
Okay. Let's take a look at the contract. And we've already been looking at it, but let's look at the description of plans. So that'll be our number 4. Okay. 4's already been admitted, so that's going to be coming up on the screen behind. All right, so this is what is this?
This is the exhibit that goes with the contract dated October 20th.
And did you understand this at the time to be part of the contract?
Yes,
And it's part of what you submitted to the VA?
yes,
And were you relying on this description when you continued working on the VA approval process?
yes.
Okay. And who wrote up this description of plans?
So Simon and I collaborated on the first part, and the scope of work is verbatim from Simon. So exactly without even changing a period or comma, it's copy pasted from Simon's email, the scope of work.
Okay, all right. So please please look at this first page. It's marked page 3 of 7. All right, on the top right-hand corner.
Mm-hmm.
You can see that's the original pagination from the contract. Read that first paragraph.
We are building a one-story addition connected to the existing single-story house via a covered breezeway. The overall square footage of the new construction is 705 square feet.
Okay, so based on this, was it your understanding that the breezeway was included in the work?
Yes, and I wanted to point out, see, it says addition because it's connected to the house, and this is an addition, not, they're treating it as a part of my main house, not as
Okay.
separate structure.
I see.
It is an addition, and that was required. The breezeway was required to connect the two, making it technically an addition, not a separate structure.
Okay.
That kept me from having to start all over again from ground zero on the grant.
Okay. So so you had to have the breezeway to get approval,
Yes.
right? And the breezeway had to be part of the contract.
Yes.
Okay. Let's look at page 5 of 7 at the top. And would you read that first paragraph?
The breezeway will contain a 4-inch thick concrete slab walkway with a covered roof. The roofing material will be a standard color option and powder coated metal panels.
Okay.
The roofing material will be a standard color option and powder coated metal panels.
All right, try to stay close to that mic.
Okay.
So now we go to the next section entitled Scope of Work. And did you understand this to define the scope of the contract?
Yes.
And if we look at the bottom of the page and we go up 5 bullet points, would you please read that bullet point in scope of work?
It says begin framing, including installation of covered walkway between buildings over future ADA ramp.
Okay. And whose signature is right down there below that?
Simon, mine, and me signing for my dad.
Okay. Let's go to 5. Yes. It's 5, which has already been admitted. And please turn to the last page, which is already up on the screen. And what do you see there?
It's the more basic version that we've settled on that's
Okay.
more pergola-like
Okay.
of the breezeway.
All right.
So just with the beams and the, simple beams and the awning, the roof.
Okay.
For the
So,
breezeway.
and what does it say right below that?
Covered breezeway over existing VAMC installed ramp.
Now, these plans, these were Exhibit B to your contract?
Yes,
Okay. So did you consider these to be part of the contract?
yes,
And was it your understanding that the contract would be carried out in a manner consistent with these plans?
yes,
Everything in these plans was to be included in the ADU?
yes.
Okay. All right, now I've kind of bounced back and forth between the contract and the approval. And
Mhm.
we've covered those 2 stages, I think, as well as we need to. Let's talk about the start of work. All right. So at the time Mr. Reynolds started work, or maybe just before, he collected a deposit from you, correct?
Yes,
And what was the amount of that deposit?
$16,000.
And did you expect that it would eventually be refunded?
So that was our agreement, yes. I
Okay.
expected that, yes,
Did you discuss that with him?
yes,
And did he tell you it would be refunded?
yes.
And how would it be refunded? Where would the funds come from for that refund?
So we had already been doing this on other occasions. So there were perhaps 3 or 4, maybe other times where I had put money down
Mm-hmm.
and then the money came back.
Okay.
So, and I believe that money came back to me through a disbursement or something, I can't remember. It was one of the disbursements.
Okay.
So by the time, this issue came up,
Is a disbursement a payment from the VA?
yeah, the same agreement that this was.
Okay. So you were expecting to advance him some money and have that paid
It's
back out
not
of
what I
a,
wanted, but
and have that paid back out of a disbursement from the VA?
right.
Okay.
This would have been already like the 3rd or 4th time, maybe.
Okay. Permits, did that include inspections?
Yes,
And what about application fees?
yes,
Okay. And were these all before the start of construction?
yes,
All right. And so based on this series of interactions, Did you believe he would refund the funds that you were advancing to facilitate the construction?
That was our pattern. So yes, I felt comfortable and I felt like the money is in escrow with the VA. It's safe there. We had been doing it. Unfortunately, I wanted to say one thing though.
Okay.
I had to do it. So, and
Okay.
when I say I had to do it for these things, the city was gonna just dismiss our permits because Simon wasn't paying the permits.
Okay.
So I'm watching our things move through the system for the variances and all of these things that are included in the permits, well, all this stuff, right? You can track it online. There's due dates, pay by this, pay by this, pay by this. It's all in the contract. Simon wasn't doing it.
Okay.
And if you don't do it on time, then the next thing isn't done on time. And then that's another month and another month and another month. So I had to go, Simon, why isn't this getting paid? Why isn't this getting paid? Then, the 11th hour, I got to put my card down. I got to pay it. And so then that money would then come back to me. So we had been doing this and then Simon's like, okay, can you just keep doing that? Because, it's just, I'm busy, you're watching it, you're on top of it. Can you just do that? And then we'll continue doing this. And what do I do? So 3 or 4 times I'm paying and I'm getting the money back.
Okay. Did you imagine that this $16,000 would end up being an increase in the total price of the project?
No.
All right. Did Mr. Reynolds ever indicate to you that this was going to be an increase in the price of the job?
No, he indicated that if it didn't happen, that the job wasn't going to happen.
Okay. And this is right at the start of work, right?
Yes,
So you've spent many months trying to make this happen, right?
correct.
You've invested numerous hours trying to get this project approved.
Correct.
Okay. And are you concerned at this point that if he pulls out, you're going to lose the grant?
Yes.
Okay. Is it possible you could have found another contractor?
My dad probably would have died by then. I mean, it's vulgar to say that, but realistically, that's the reality.
Was there ever an amendment executed to the contract in connection with this deposit? Did you guys ever amend the contract to allow for this deposit?
No,
Okay. Be sure to answer audibly.
No.
For the record.
no,
So when he started work and you paid the deposit, did you think that the total price of the project would still be $120,279?
yes.
All right, Exhibit 77. All right, I've handed you a document that's been marked as Defendant's Exhibit 77. Do you recognize this document?
Yes,
Is this an email from Mr. Reynolds to you?
yes.
Can you read the email?
As requested, here's the invoice on the deposit. I had never requested an invoice on the deposit. But okay. After printing and shown as fees, let me know how much you've outlaid and we'll put that in as a request to the VA. That is what I requested, a refund of my money that I have been paying out. That was what I requested.
Okay. So then on the next page, we have an invoice, right? And was this invoice attached to the email?
Yes,
All right. And you recognize the invoice?
yes.
Okay. And what's the date on it?
May 5th, 2021.
Okay. Your Honor, I'll move to admit Defendant's Exhibit 77.
Objection.
Admitted.
All right, scroll up a little bit, Lexi. All right, that's actually, sorry, go ahead and scroll down. That's perfect. What's the date on this invoice?
May 5th, May 5th, 2021? Yeah.
Okay, and that was that around the time that work started?
We had planned for the work to start the following week or that week.
Okay,
And then I got hit with this.
okay, all right. So he hits you with this right as work is supposed to start?
Yes.
Okay. And would you read the description of the charge?
Deposit to begin work.
All right. So this invoice just says deposit to begin work, right?
Yes.
And did you pay this?
Yes. I didn't want to, but
Why'd you pay it if you didn't want to?
because as Simon said, if I did not pay it, he was not going to do anything. He was not going to start.
Okay, so you've entered into this contract.
Mm-hmm.
It has a set price. You've submitted it to the VA. You've gone through an arduous approval process.
Mm-hmm.
You get to the point where everything's ready to start work,
Mm-hmm.
and he demands more money from you.
Yes.
And you give in to that demand because you're afraid of losing the grant?
Yeah. And I also felt like the money is in escrow, essentially, and I will get it back.
In escrow, does that mean that, what does that mean?
That means that the VA holds on to all of the funds,
Okay,
right? The money is dispersed to Simon.
okay,
So the $16,000 is essentially, if I'm fronting that as I had fronted the other things, the money will come back to me. Simon's not going to just go bankrupt and not have it.
right.
The VA has it.
It's
It will be
it's there.
released. I'll get it.
You've got a big entity holding the money.
Mm-hmm.
All right. And you understood that this would be paid back to you because it's a deposit.
Mm-hmm.
All right. So
Oh, and by the way, that was one of the excuses. He said, I can't just go bankrupt kicking off your project. So that's why he needed this.
okay. All right. So he's telling you he can't move forward without the deposit.
Right.
Financially unable to do so.
Right.
Okay.
And I actually, well, hold on.
All right. Let's keep moving here.
Mm-hmm.
So, how did the construction process go? Just briefly, how would you characterize it?
I would say immediately, right off the bat, I had concerns, but Simon is great at calming the concerns. And there were problems all along, but we worked through them. And, you know, I'm I admit, too much of a people pleaser. I wish Francisco was involved because none of this would have happened.
Okay.
But we had issues all along, and I worked very hard to get through them in a way that everybody we could just keep going.
Okay. Now, there were a couple change orders that were done during the construction process, right?
Yes.
All right. So I want to show you those. All right, there's Defendant's Exhibit 1. Or what has been marked as Defendant's Exhibit 1. Do you recognize this?
I recognize this as being change order number 1.
Okay, thank you. Your Honor, move to admit.
Second, I'm trying to verify. No objection.
Okay, so there's change order 1. And I don't want to talk about this for too long. Did you sign this?
Yes.
And were you happy with this change order?
Well, initially, by the way, he was trying to put in a substandard window, and I kept having to refuse.
Okay,
And
let's not get sidetracked
okay,
though.
not get sidetracked, but eventually I became happy with this. It was
Okay.
acceptable.
It was accepted, submitted
Yeah.
to the VA,
Yeah.
and done.
Mm-hmm.
Okay. So let's go to second change order.
Okay.
All right, Mrs. Maia, do you recognize this document?
Yes, the second change order.
Okay. And did you sign this?
Yes.
And so this is marked as Defendant's Exhibit number 2, and I will move to admit.
Any objection?
No objection, Your Honor.
Admitted.
All right. Can we get that on screen? Thank you. All right, so what does this change order say that it does?
It says adaptive change order, remove sidewalk from scope of work.
All right, and is that your signature?
Yes.
All right, and what is the date of the
Octo-
signatures?
October 25th, 2021.
All right. And you're testifying that you did sign this, correct?
Correct.
All right. All right, go to 3. All right, here we have a document marked as Defendant's Exhibit number 3. And do you recognize this?
I recognize this as a document produced after we started having disputes. Yeah, it's the same.
Okay, all right. And Your Honor, I'm going to go ahead and move to admit Defendant's 3.
Any objection?
No objection.
Submitted.
All right. Now, what is this document for?
This is also a change order that says adapt. You want me to read it?
Well, what change order number is it?
Number 2.
Okay. So we just looked at change order number 2, and now we're looking at a different document, also marked change order number 2.
Correct.
And can you read the description on this one?
It says adaptive change order, remove sidewalk from scope of work, allocate funds to adaptive use by connecting porch to pergola entry by building a deck and radius turn to allow passage.
Okay. Now, did you sign this?
I do not recall signing this.
Okay.
No.
Did you approve of this change that's described here?
No.
All right. Lexi, can you see if we can get these on the screen side by side? Oh, yes, we are. All right. All right, that's good. Yes, stay zoomed in on the signatures. And Mrs. Maia, you've got the paper copies in front of you. As you look at and compare these signatures, are they, aside from the fact that one is color and the other is black and white, are they precisely and exactly identical?
Correct.
Now, what is the date on the second version of change order number 2?
October 25th, 2021.
So the exact same date?
Correct.
And Lexi, can you pull those dates into view on the other one? Okay, great. And are those dates exactly identical in the way that they're written?
Correct.
All right. So you signed the first version. Did you sign the second version?
No. Well, I don't know how to answer that because it looks like the same signature.
Okay. When you signed this document, which description did it have?
The one on the right.
When you say the one on the right, it's the right side of the screen. Read that description.
Adaptive change order, remove sidewalk from scope of work.
And nothing else?
Correct.
Okay. Now, let's go back to full screen on version 2. So we've got 2 versions of this document. One has a simpler description and one has a more elaborate description, but the signatures are clearly exactly the same. Right? Okay.
Correct.
So let's look at the second document. And there was a site plan that went with this one, right? Can Lexi, that's farther down. Can you scroll down? And Regina, that'll be your page 3. Okay.
Okay.
And can we zoom on the purple? Yep, and let's go even bigger. Perfect. Okay, so we've zoomed in on this diagram behind you. All right?
Okay.
Now, do you recognize that diagram?
Well, I recognize Exhibit C, but I had never seen this until discovery.
Okay. You recognize Exhibit C. Now, was that purple marking present on Exhibit C when you originally signed the contract?
No.
Okay. So there appears to be some writing on this diagram, correct?
Correct.
And some drawing, correct?
Correct.
Okay. And do you know what that drawing signifies as you look at it today?
It signifies the wraparound porch that blocks the driveway.
Okay. Now, were you ever presented with this drawing on your site plan?
No.
And did you agree to change the house in that way?
No. And I have no signature on, oh, sorry, go ahead.
Okay,
No,
you did
no.
not sign off on that change?
No, I have no signature on this.
Now, you did sign the site plan back on October 20th of 2020, correct?
Yes.
And that signature is on the site plan elsewhere on this page.
So my only signature is October 20th, 2020, which is the original drawing.
Okay, I think Lexi's going to get that on the screen for us. All right, so that's the date of the original contract, right? So that's not a change order signature.
No.
That's the contract signature.
Correct.
Okay. All right, let's go back to the diagram, the drawings. Now, are there any measurements on this drawing to indicate the size, the exact dimensions of the porch?
No,
Do you know if it's drawn to scale?
no.
And do you see anything wrong with that picture as it's drawn there?
Yes, I do.
Okay. All right, I'm going to come up and point at the screen. So what is this area right here?
So this is the street and this is the driveway for my handicap van.
Okay. So, sorry, what?
She's gonna have a contract.
Okay, either speak up
Okay,
or.
so,
Can we just pause 1 second?
okay.
Thank you, sir. Does she need to take that off when she turns back around to prevent feedback?
No.
All right, so what's this area?
So this is the street and this is the driveway for my handicap van. This is the parking pad.
Okay. And do you see any problem here?
Yes,
So what's the problem?
that this is the space that, this is the proposed wraparound porch that I'm seeing for the first time on this plan. And this is the amount of space it allows for my handicap van in the driveway.
So that porch is sticking out into your driveway?
Yes, it's covering half of the, on this, covering half of the driveway and it's allowing no functional space for my van or any real car to get up the driveway.
So would you have expected maybe they'd have to modify the driveway to accommodate this porch?
Well, I would expect a lot of things with this, but to answer your question, yes.
Okay.
I would expect a lot of other things, but
Is
yes.
there any modification to the driveway depicted there?
No.
So would you have been comfortable approving this if it had been shown to you?
No, no.
Okay. Do you know if this was ever submitted to the VA?
I don't know, but it does not have the same date as the change order even. So I have no idea. I don't know.
Okay.
It's a different date than the change order.
But ultimately, you did not approve this change, correct?
No.
And was this change made by Mr. Reynolds
Oh, yes.
in the construction?
Oh,
Okay.
yes.
All right. Now let's talk about more generally some of the problems with the construction.
Okay.
All right. So let's talk about the location of the ADU building
Okay.
on the property.
Mm-hmm.
Now, I'm going to come up. On this site plan, we could ignore the drawings now. Is this the ADU?
Yes.
Is
Oh.
this the border of the property?
Yes.
Does the ADU sit flush against the border right on it?
Yes.
Okay. Is that how it was built?
No.
Is it offset from the border?
Yes.
And did he move it east? That way?
Yes. More into the property. Yes.
So it's offset this way?
Yes.
Okay. And does that exacerbate this problem?
It does. Yes.
Okay. Was there ever a change order to change the location of the ADU?
No.
Are you having a problem with the driveway now?
Yes,
And did that problem arise as this construction project was completed?
yes.
Tell me about it.
Okay, so, the curve on this driveway is so extreme. I cannot, or any normal person, no visitor can get their car up this driveway, number one.
Okay, so the driveway is now impassable for a normal
Lost.
car?
The whole driveway is just useless. The parking, I've lost my driveway.
You've lost your driveway. And so, I mean, what about your handicap van? Can you get your handicap van up the driveway?
No, I cannot. I cannot.
So this is a building built specifically for a disabled person. It's supposed to be handicap accessible. And you can't get the van up the driveway.
Or any car. up the
Or any
driveway.
car.
Yeah, correct.
Did you talk to Mr. Reynolds about this problem?
Yes.
And what did he say about it?
There's just nothing to be done about it.
And did this become apparent to you when the retaining wall was put in alongside the driveway?
Did it become apparent to me? It was,
Yeah.
it was the difficulty. Okay, the difficulty was there before.
Okay.
And it felt like we could do something about it by perhaps putting more concrete in somehow.
Okay.
But then, once I come home and then there's blocks there, well, now there's nothing we can do about it.
Okay.
Because now-
Where's the retaining wall that I'm referencing? Can you point to where it is?
Here.
Okay.
So now, okay, so again, maybe we can do something about it. Maybe we can like pave over here a little, make it wider. Okay. No, come home, he's got blocks over here. So now I've got a wall. I've got a sharp corner here, I've got a wall here. It's just nothing, a rock in a hard place.
Okay.
Cannot get a car up there.
Did Mr. Reynolds change the elevation in your backyard?
Yes.
Okay. So let's see. I think we already have admitted 65, right?
65.
All right, let's just get her a copy if we've got another one. Oh, great. All right, so let's zoom in on that retaining wall.
Okay.
Thank you, Lexi. So is there a retaining wall in this picture?
Yes.
And is that retaining wall, is it right next to the wheelchair ramp?
Yes.
All right. And did you need this retaining wall once construction was more or less complete?
The construction created the need for the retaining wall.
Okay, so did he basically dig an embankment in your backyard?
Yes.
And then was it unsupported?
Yes.
And so did you ask him to fix that?
Yeah.
Okay. And then he did fix it, right? He put in the retaining wall, right?
He put it in prematurely.
Okay. But he also wanted to charge you for it?
Yeah.
Okay. So you presented him with a problem that he created, correct?
Mm-hmm.
He came in and made the repair, but then he wanted to charge you extra money for that.
Yes.
Okay.
Sort of went rogue. It just prematurely started.
Okay. All right. So was this 3-foot drop created by moving the fence back?
No,
And
I don't even understand, like, that doesn't even make sense.
right, right. And how far back was the fence moved?
So there's going to be some variations in the distance.
Okay.
So on the front side, there's about 3 inches
Okay.
or less.
Okay.
And towards the back, a little more, maybe 12 at most, I would say.
Now, how would moving a fence back create an embankment?
It's above the ground on top of the grass, so that doesn't make any sense.
Okay. Um, so let's go to.
Oh, and it's flush with the neighbor. My yard was flush with the neighbor until this embankment is there. But the part that is on that grassy part is flush with the neighbor.
Okay.
It's exactly the same, so it doesn't make any sense. And my previous builder of the fence did not put it in the wrong place. It's exactly where I asked them to put it.
Okay. Handing you what is marked as the defendant's exhibit 28. And do you recognize this?
Yes, it's the side of the house or
Okay.
the ADU that he
All
built.
right. Move to admit.
Need a number on that one.
Oh, defendant's exhibit 28.
Any objection to 28, D28?
No objection.
It's admitted.
All right. On screen, please. All right. Could you just zoom in a bit, Lexi? We don't need the whole length of the house. Great. Perfect. So is this the north side of the ADU?
Yes.
And so is there a retaining wall right next to the house?
I mean, it is so close that I don't know if you could even put like an arm down there between
Okay.
your hand between the house and I mean, it's right up there.
So before that retaining wall was put in, was there a bare embankment there?
No, no.
So a bare embankment. Was there a bare embankment next to
Oh.
the house?
So before the ADU existed, this was even.
A gradual slope or?
Yeah, it was even. Then when he built the ADU, there's this big carve out,
Okay.
which created the need for this wall, which is
Okay.
touching right up against the ADU.
So then so there's a big carve out.
Mhm.
Is that soil collapsing toward the house?
It would have, yeah, you can see, look at all the color. It's still kind of like, splattering through the wall for some reason. You can see all the dirt on the house.
And so did you believe that this retaining wall was necessary to protect the side of the house?
Yeah, it's several feet high. It
Okay.
would be collapsing onto the house.
And was this necessitated by the way that Mr. Reynolds went about building this ADU?
Yes, I have no idea why it's so low.
Was there a change in elevation indicated in the site plan or the building plans anywhere?
No.
So when he eventually put in this retaining wall, did he want to charge you extra for it?
Yes.
Okay. And that was to come out of your pocket, right?
Right. But I wanted to say that he only introduced the idea of charging me for it after he had started it.
Okay. So he built it without explicit permission from you to start work?
Right.
Okay.
Well, so some of it had to be damage control from actively falling dirt. So you
Okay.
have to do some mitigation there to put some stuff to keep it from continuing, because then it's just getting worse. So there
Okay.
has to be some mitigation there, and I understand that.
Okay.
Okay. But then, so he's effectively now starting. But then once he's active, oh, so I've already ordered the rest of the blocks. No, And then he's now we're in the same cycle of, that saying, ask for forgiveness, not permission. That's
Okay.
Simon, send a bill, don't ask for permission. That's been our experience.
Okay.
And so I understand we have got actively falling dirt. You've got to do something, put some things there. But then that happened before the bill.
Okay. Now, Mr. Reynolds has claimed that moving the fence created the need for this retaining wall. I want to look at, let's see, hold on. Exhibit 28. No. 49. Okay, we're going to stay on 28 for a second. All right.
Yeah, got it.
All right. So, yes, I just want to point out a couple of things here, or have you point them out. So in this picture, right here, is this the corner of the house?
Yes.
All right, this is the northeast corner, right?
Yes.
And this is the retaining wall beside the ramp, right?
Yes.
And it comes and it contacts the corner of the house.
Yes.
So it runs right there at the corner.
Yes.
Right?
Yes.
Okay. Now, so I'm going to hand you, it's been marked as Defendant's Exhibit 49.
Okay.
And do you recognize this document or this picture?
I understand what it is. I don't think I've ever seen it before.
All right. So does this show a worker laying the foundation for your ADU?
That's what it looks like, yeah.
Okay.
Yes.
And does it have the fence in the background there?
Yes.
Your Honor, I'll move to admit. Defendant's 49. Any objection?
No objection, Your Honor.
Submitted. All right, let's get this up on the screen. All right, and you can zoom out a little here. All right. Actually, let's bring it in and just focus on the top half of the image. Okay, great. Okay. So right over here, we have that same corner of the ADU, correct?
Yes.
And so the retaining wall runs right here,
Okay.
right?
Right.
So it's in front of the fence, correct?
Yes.
Now, what do you see growing on the fence?
Vines.
And were those vines there after the fence was moved?
I don't think so. No. No.
No,
No.
because you've moved the fence. Can't have vines growing on it.
Right. Yeah.
We can look at a picture after construction of the fence and compare if you like.
Well, yeah.
I think it's 65 with the ramp.
Well, I mean, you can see that they cut into the side to make room for the ADU, right?
Right, right. So, but is that the old position of the fence?
That's the original. Oh, yeah. So that's the original. That's original fence. It's an old fence.
The original old fence?
Yeah, that's old.
And did the old fence have these vines growing on it?
Yeah, yes.
Okay. So let's get number 65 back up. Oh, before we do, Okay, that's fine. So here we have 65, and we've got the new fence, right?
Mm-hmm.
And do you see any vines?
No.
Okay. And do you see some fresh planks there?
Yes.
Okay. So let's go back to the other one. So this is pre-move, correct?
Yes.
Okay. And so the ADU, it sits to the south of where the old fence was, right?
Yeah.
And the embankment right here, isn't it?
Yes.
Okay. So it's in front of the old fence, right?
Yes.
So moving this fence back,
Mm-hmm.
could it have created that embankment?
No.
All right. Let's take another look at the, let's see. We admitted 76. All right, let's bring up 76. Let's take another look at your yard before the construction took place. All right, so is that the old fence there?
Yes.
And is there any 3-foot drop there?
No.
Okay, so did Mr. Reynolds create the 3-foot drop?
No.
He did not create
I'm
the.
sorry. I'm sorry. Yes.
Okay. So did Mr. Reynolds change the elevation in your backyard?
So yes, and not just there, but towards the front too. I have a big dip across the entire front that we haven't talked about. It's a
Okay.
huge dip down.
All right.
So it's not just on that side. It's the front part looking at it this way. It's a big dip down. So it's like a bowl.
Okay.
It's dipped down on all sides.
All right, let's move on to the floor in the ADU. Oh, but one last question. Was there a change order for changing the elevation in your backyard?
No?
And was that part of the plans?
No.
All right.
No.
So are there any problems with the floor in the ADU?
Yes.
Okay. Let's take a look at Exhibit 75. This is 74.
Thank you.
Could the jury have a 5-minute break?
Let's take 5.
Goodness.
Maybe you can set that.
Reset my.
All right, juror 32, we're off the record. Juror 32, can you just come up here for just a second? No, you can just stand right there. I appreciate you being back from lunch on time, and we'll see you next time, okay? You're excused. I promise to do better next time, right?
Apologize for everything.
All right, take care. All right.
So we can. Okay. We'll get that. That might, please just. Yeah, you're fine. I'm just saying when we get, yeah, that way I'll.
It kind of depended on.
It's
I'll-
it's not something people do every day.
I'll work
so,
on it.
I was just letting you know not to worry about it.
Okay.
Done, but when you really sit here and when you pause it for breaks, I know when you're pausing for breaks and stuff, you realize it's actually a lot longer than you think. And you don't get as much like pure testimony per day as you might think you do. So, good thing to know for next time. Did you read that emergency petition at all?
All right. How many? Well, no,
Yeah, yeah. Like, was it for something specific? I wasn't just people complaining to complain. Cause I feel like that's the majority of protests.
There was a, after the police came on,
Yeah.
and then everything else looked like it was like a play, it looked like a play.
Huh, interesting, yeah, cause she was telling me about the protest, we were talking about protests.
Yeah.
There was like.
I wasn't
stuff going on.
entirely sure.
Detours.
No, I was telling her,
We're making
to
great
me,
time now, I
it
think,
looked like someone here would make
Good.
to show a protest, like,
Have you ever watched Portlandia?
yes.
You know the episode where it's like, parents, look, we're gonna protest.
Actually, yeah, no, I get, that's what it felt like.
They had the
He's
paper
gonna-
mache,
he's gonna-
something
Yeah, it was
going on.
weird.
I couldn't tell the message.
Someone should have taken a photo because now I have FOMO.
Yeah,
I
it
don't
was,
know.
it was bizarre. Do you have your?
Yes, so anything that is not checked has been tendered today and I'm gonna check as.
Anything, so anything highlighted?
Everything highlighted has been admitted.
I just, there was like four that I got lost on.
Okay,
Can I just hold this for a second?
Yeah.
So check marks means, what, I just need to know
check
what was
marks are from
admitted.
yesterday. No check marks admitted today.
Oh, okay,
Yeah.
that's what I need.
Yeah.
You just see something.
My own system to track results.
This is weird though, because.
Well,
Working order.
You check the hallway?
It's a different version. This on 5/5. This. They sent you one that said deposit to start work, then they turned it
because
into.
this one is
Then they
stamped
added it.
paid.
Yeah,
They
5/10.
added that after.
Would I comment on those?
No, we need to, I think we're gonna comment on that. Version that was,
No.
this wasn't sent to.
All right, Lieutenant.
Great question.
Ma'am. You can come on back. Miss Maya.
I can help you too.
There we go. Yeah.
All right, so that's okay, man. Perfect. 7.
Thank you. Please be seated, everyone. All right, Mr. Craig, you can proceed when ready.
All right, thank you.
Share the genius.
I don't know the exhibit. Oh, great. And that's, is that the real?
I'm almost done.
Oh. All right, Mrs. Maia, we've just been talking about some various defects in the construction of the ADU.
Yes.
Okay?
Mhm.
And we're going to talk about that some more. We're going to talk about the floor.
Okay.
But before we get into that, we've just identified a kind of a discrepancy between plaintiffs and defendants' exhibits.
Yes.
So I wanted to highlight that for you
Okay.
and see if you could comment on it for
Okay.
us. All right, so we've got plaintiff's exhibit 13. Plaintiff's exhibit 13 that was previously admitted. And we have defendant's exhibit 77, which has also been admitted. We've got them both on the screen for you there. Now, before we compare these side by side, Lexi, would you scroll up on defendant's exhibit 77? All right, so just to remind you, defendant's exhibit 77 is an email from Mr. Reynolds to you, right? You see that there?
Yes.
Okay. And the attached to that email, was there an invoice?
Can we scroll up?
Scroll up, please. Thank you.
It says invoice 20, okay, it says invoice, whatever.
I'm gonna cover that.
Okay. Okay.
So this is an email, right?
Yes,
And did you receive this email on May 5th?
apparently. It looks like it, yes.
Okay. And is there an attachment indicated there?
Yes.
What's the invoice number on the attachment? Scroll back up, Lexi, sorry. Right there under attachments.
21, 14, 23.
Okay. Now let's scroll down to the second page. And what do we have there? We have what?
21, 14, 23.
All right, that's invoice 21-14-23. And what's the description on that?
Deposit to begin work.
Okay.
Same name as the file.
All right.
Basically.
Okay, let's switch over to plaintiff's exhibit 13. All right, and would you zoom in, please? And what's the invoice number there on that exhibit?
21, 14, 23.
Okay. And then is it stamped paid?
Yes.
Okay. What's the date on it?
May 5th, 2021.
So same date, same invoice number, correct?
Yes.
Now scroll down and look at the description. What does that say?
It says covered walkway, footers, posts, roof structure, clear panels for roofing, deposit to begin work.
Okay. So I'm a little confused here, Mrs. Maia. How are there two invoices issued the same day with the same invoice number that have different descriptions?
I can't answer that. I don't know. I've never seen this invoice.
Okay. So the one you paid was the one that said deposit to start work. Is that right?
Correct.
All right. Now, we've exchanged a bunch of documents in discovery, right? And when we exchanged documents in discovery, we had a Bates number at the bottom, right?
Yes.
A little serial number that indicates the document has been given to the other side.
Yes.
All right, would you scroll down to the bottom of this one, Lexi? Do you see a Bates number there, Regina?
No.
I'm sorry, scroll to the top. Okay, all right. So, all right, keep going down. All right. I'm not seeing Bates numbers there. Go to the very first page, Lexi. I just want to make sure we're doing this right. All right, scroll down to the bottom of the first page. Okay, still no Bates number. All right, let's go over to our exhibit. All right, keep scrolling a little more to the bottom. Okay, what do you see there, Mrs. Maia?
So there's a little symbol on the screen that's blocking that for me.
Oh, keep scrolling then, if you would, Lexi. You can't go any farther?
Can I hit,
Okay.
oh, this meeting is being recorded. Okay, can I do that? Just get rid of.
I've got.
Okay.
And you can actually look behind you.
Okay, oh, yeah. So this has Bates, R Maia 0635.
Okay, so that's our indicator that we have produced this to them in discovery, correct?
Yes.
Okay. So this is the invoice that you received, correct?
Correct.
And this is the invoice that you paid that said deposit to start work.
Correct.
Okay. So they sent you an invoice that said breezeway on it for $16,380 back when you first did the contract, right? You remember from earlier? I know it's been a long afternoon.
Yes.
Okay. And you refused to pay that, correct?
Correct.
And then later at the start of work, they sent you this invoice for a deposit, correct?
Just deposit. Correct.
Yes. Okay. All right, let's talk about the floor. Let's go to Exhibit 75. Okay, yes. Thank you. Yeah. All right. I've handed you Defendant's Exhibit 75. Do you recognize this photograph?
Yes.
Is this a picture of the flooring in the ADU?
Yes.
Okay. Your Honor, we'll move to admit Defendant's Exhibit 75.
A little more foundation, Your Honor, just when the picture was taken. Is it a photograph? I'm sorry, James. I was
That's okay.
distracted there for a second.
This is a photograph. Is this a photograph?
It's a photograph.
And was this taken inside the ADU?
Yes.
And was this taken during the pendency of this lawsuit?
Yes.
Okay. So sometime in the last couple of years?
Yes.
Okay. And was this after all the construction was complete?
Yes.
And does it accurately represent the floor in the
Yes.
ADU, a portion of it?
Yes.
Okay. And does it accurately reflect the state of the floor today?
Yes.
All right. Your Honor, I'll move to admit.
Your Honor, objection. This is the timing of this is extremely important. The construction finished in,
So you're just still making an authentication objection as to the timing of it?
Exactly.
Okay. I think it's admitted for what it is, and any other of those kind of arguments go to its weight and what the jury should give it, and not its admissibility. So it's admitted over objection.
Thank you.
All right, let's get that on the screen. All right, can you zoom in a little bit, Lexi? That's great. Okay, so is this showing that the floor is uneven?
Yes.
Is the floor uneven?
It's very it's wavy. The
Okay.
floor is wavy
All right.
all over.
And is that a problem?
It's a big problem, yes.
And why is that a problem?
Because for you and I, it's perhaps not such a big deal, but for somebody who is limited in mobility, like my mother, or she's already fallen on the floor. She
Okay.
uses a walker, or even without the walker. I mean, it's a wavy floor. It's
Yeah. Have you ever had a wavy floor before?
No,
Uh,
I've never seen a wavy floor.
okay. Is this, okay. Let's talk about that breezeway.
Okay.
All right. Did Mr. Reynolds build the breezeway in the location shown in the plans?
No.
Did he change the location of the breezeway?
Yes.
Did he move it north?
Yes.
Did he ask your permission to do that?
No.
Was there a change order for that?
No.
Did that cause a problem
Yes.
for you? And what's the problem that it causes?
Well, I don't know if it's helpful to bring up the picture, but
You want the site plan?
it could be helpful to explain the problem.
All right, let's get the site plan up. All right, can you point to the breezeway on the site plan?
So I'm gonna just stay seated. I don't think I need to stand up. So this is the breezeway here. It's black bar.
Okay. That's on the plan. Is that the intended location of the breezeway?
Yes.
And how was the location changed?
He pushed the breezeway this way, farther toward the fence.
Okay, all right. And why is that a problem?
So what happened was when so this is my porch. And this is the entrance into the porch. So in pushing the breezeway back, he could not attach to the porch anymore. There's nothing to attach the porch. There's no landing. So then I come home and he says, oh no, we couldn't attach the porch to the breezeway. So we just went ahead and extended your porch out. So now I've got an extra, he thinks it's a benefit for me to have a bigger porch.
Okay,
Now he's built this porch out without my permission. He built my porch out to here,
okay,
blocking this walk-through gate. So now I have no use of the only flat exit from my backyard here. So this is now, I can't use this only exit from my backyard that's flat.
okay,
He pushed this out, making it unable to reach this, which meant he built my deck out, blocking this
okay.
only exit out.
So at the present time, for your mom, you can't get the handicap van up the driveway.
Nope.
And you can't use that side passage that's flat.
Right,
And you can't really use the front stairs,
right.
right? So you're kind of in is that a difficult situation?
It's yes, extremely.
Okay. And did you have such a difficult situation before this project?
No,
So has this project improved your quality of life or reduced it?
it's actually made things immensely difficult for me.
Okay,
And hazardous, as you know about what just happened with my mom.
okay. Let's talk about the electrical in the ADU.
Okay,
Did you have a problem with the electrical system?
yes.
And what problem did you experience there?
So if you simply plug in a laptop, the entire power in the whole ADU shuts off. If you try to pop popcorn in the microwave, the entire power in the ADU goes off.
Okay. So how did that affect your ability to use the ADU?
You can't. You can't use it because, well,
You can't live with that problem?
no.
And why not?
Well, first of all, let's just limit it to my dad. That's the
Okay.
purpose. He lives using a breathing machine and his bed with the rolling air. Those are just
Okay.
the two basics. And we have limited time, but we can go on, but those, I mean, that's enough, right?
Well, I do want to explore this topic a little bit more, Regina, because I think it's really important. So you needed an oxygen machine working for him nonstop,
Yes.
right? You testified to that earlier.
Yes.
He has did he have an electric wheelchair?
So, yeah, so he had the Hoyer lift,
Okay, the Hoyer lift.
which is the thing that is you have to charge it. And so runs on electricity. It's the little crane, has to pick them up and move them around.
Okay,
The electric wheelchairs, all of the things that he needed were electronic in some way. His sleeping mask, like everything was like he's all.
So did he need 24/7 reliable electricity?
Yes.
Okay. So without that, could you move him into the ADU?
No.
All right. Were you ever able to move him into the ADU during his life?
No.
All right, we're gonna go through a few more problems. Is there a problem with the roof?
There is, and that's beyond my level of understanding. It's something that the inspectors pointed out.
Okay.
I don't even understand that.
What about the bathroom door?
Oh, gosh. Yes.
Okay, let's get Exhibit 42. I handed you what's been marked as Defendant's Exhibit 42. Is this a photograph?
It's a photograph, yes.
And do you recognize what's in the photograph?
Yes.
What does it show?
It's my husband standing near the door of the bathroom in the ADU.
All right. And about when was this taken?
After the completion of the construction and after Simon, just after Simon just wouldn't replace the doors.
Okay, so this was after he was prohibited from coming back on the property.
Correct.
All right. And does this accurately represent the doorway as it exists today?
Yes.
Okay, I'll move to admit.
Okay.
All right.
D 42 is admitted.
All right. So now, where is this doorway?
Can we scroll to see the top? Yeah. Okay.
Okay.
So this is the bathroom door.
The door for the bathroom in the ADU?
Yes.
And is that a barn door?
Yes.
Okay. And is this picture taken from inside the bathroom?
Yes.
And
I'm sorry. It's just so ridiculous.
all right.
Sorry.
All
I
right.
just had to laugh. It's so
All
ridiculous.
right. Yes, I see Francisco
man.
peeping through the edge there.
I'm sorry. It's just, oh man.
I hope you staged this photograph. All right. So, so what's going on here? What's the problem with the door?
All the interior doors are too small for the openings.
Okay. So when you slide the door in front of the doorway, does it completely cover the doorway?
It does not, from side to side, top to bottom, it's just small.
Okay. So the door's just too small?
Correct.
All right. Now, did you talk to Mr. Reynolds about this problem and ask him to fix it?
Yeah, multiple times.
Did you ask him to get a bigger door?
Multiple times.
And what was his proposed solution?
He wanted to attach rubber to the door edges to make it look like it filled the hole.
Okay. Was that acceptable to you?
No, it's not acceptable.
You just wanted a door that fit the doorway, right?
I wanted a door that is appropriately sized for a barn door, fitting an opening so that it extends over the edges of the wall, like a barn door is supposed to. He
Okay,
has 35 years of experience.
right. He should be able to make a door fit.
You're right. And if it wasn't going to, for his experience, he should tell me.
Right. Okay. Let's talk bathroom floor tile. Did you see a problem with the floor tile?
Yes.
What was the problem with the tile?
So in our addendum here, there is a signed choice of my floor tile. This I don't know if you can show it.
I'm sorry. I was just looking ahead to see what we needed to cover.
So in the contract, there is the signed agreement of this is the floor tile that he's supposed to install. And this is per VA requirement. It has to do with the coefficient of friction, right?
Okay.
It's very high. It's super expensive, ridiculous, like $9 a square foot.
Okay.
And so that nobody falls. It's very specific requirement.
Okay.
And this is what I paid for in the contract.
Okay.
It's supposed to go in the whole bathroom.
Okay.
And so he bought the wrong tile.
Okay.
He put this in the shower stall, and then in the rest of the bathroom, instead of the $9 tile, he put in the one that's like $1 a square foot
Okay.
for the bathroom.
Okay. What about the HVAC?
Again, signed and agreed. I selected, because I'm right up against the neighbor, I selected a quiet unit. He swapped it out for a lesser unit that's I can hear from across the property inside my house with my AC on.
Okay.
Not what we agreed. No change order. By the way, no change order for this bathroom tile either.
Okay. All right. So with the HVAC system, is the make and model of the HVAC system actually specified in the plans?
Yes. Oh, can
Okay.
I go back to this tile, by the way?
Sure.
This tile included in the contract, he made me pay for it a second time outside of the I had to cut him another check for it. So I
Okay.
paid for it twice,
Okay.
by the way.
So I want to move quickly through these remaining defects, but I do want to touch back on this HVAC system.
Okay.
It was specified in the contract, correct?
Yes.
Okay. Specific make and model.
Yes.
All right.
It's signed, initialed in here.
And did he tell you he was making this change?
No.
All right.
Well, I don't think so. No, not until it was in there or no. I actually found it because I crawled around in the attic with the litigations because I'm like, all these mistakes. I think that's how I found it.
Okay.
I actually took the contract matching serial numbers.
Okay.
That's how I found it.
And did you look at the water heater too?
Same thing. He put a cheaper model in.
Did he tell you he was doing that?
No.
All right. What about debris in the yard?
Massive chunks of concrete, cinder blocks, bricks, just trash, like hard construction trash, not car parts, trash. We
Did
have
he leave
photos.
that behind after the job was
Yes.
purportedly finished?
Yes, so I can't mow. I'm out there with a crowbar trying to get get it out. I can't,
So did you ask him to remove that stuff?
yes.
And did he say that he would?
No, he didn't.
Okay. Let's look at just Exhibit 38.
He denied it was there.
Oh, he denied it was there. All right. Exhibit 38. So I handed you what's been marked as Defendant's Exhibit 38. And is this a photograph of the ground in your backyard?
Yes,
And was this taken after the completion of construction?
yes,
And was this after you had requested that Mr. Reynolds remove debris from the yard?
yes. And this is actually outside the fence.
Okay.
So whether or not the fence is locked, he doesn't need anybody's help to access this one. There's much more inside the fence, but this one's
Okay.
outside.
All right. Yeah, this is just one example, correct?
Mhm.
All right. Your Honor, move to admit.
B38, any objection?
No objection, Your Honor.
B38 submitted.
All right.
What's the feet on that?
Let's see, can we zoom in and see the length of that?
It's like 5 feet of concrete. It's all over the yard,
Yeah, it's kind of hard to see how long it is.
but you can tell by the black dots, right? The big boom, boom, boom.
Yeah, but kind of a big chunk of concrete, right?
It's everywhere.
Okay.
All over the place.
Is a lot of that still there?
Yes.
All right. All right, I want to talk about this, this builder complaint because you did complain to the VA, correct?
Many times, yes.
Okay. And you wanted their help in dealing with this problem.
Yes.
All right. And do you feel that the VA gave due consideration to your concerns? And did they impose any constraints for the time to complete and submit your builder complaint?
Yes.
Tell me about that.
You want to know
What constraints were you under?
so Eric Good, who I'd been working with since 2016, he was transferring to another department
Okay.
and he was leaving on that particular day. On that particular day, if I did not have my complaint in on that day, he was going to close my case.
Okay. So when you notified him about your concerns, he only gave you 1 day?
I think that it was perhaps 2.
Okay. So were you able to adequately catalog all your concerns before you submitted the complaint?
No. So what he said was just do something, put your foot in the door, and then I will give your complaint to Philip Richards,
Okay.
and then he will have it. That way he's done his thing, it's marked in the system, and then it will go from there. Otherwise, he has to close up his cases and move on. So I'm allowing you to, there's other things to mention, but I'm not gonna go there.
Sorry, can I hear?
But,
Okay. You can elaborate.
okay, so when I was under this deadline, I was trying to explain to Eric Good that I could not do this complaint because when this short turnaround happened, as he's telling me this,
You had a personal tragedy?
right, so they had said that my brother and my sister got hit by a FedEx truck on an icy road in Montana, and that it happened like a couple days prior, but nobody knew because they were in a coma and nobody could be contacted. They had a hard time, so
Was that the day the complaint was due?
it was like the next day
Okay.
the complaint was due.
Okay.
And so I'm like, where are the boys? 'Cause my nephews and my brother-in-law died. He would not allow me time to, I'm like, I cannot do this like right now. I cannot write an exhaustive complaint about all these issues when I'm trying to do that and this.
Yeah.
Okay, so he says, just get it, something in there, just get the basics. Your foot is in the door holding it open. Okay,
Okay.
my brother-in-law ended up dying and my sister remained in a coma for like 2 weeks. I'm trying to manage like transporting his remains. There's all of this going on. And then there's this new person, Philip, I've never met, who just takes the complaint and he just does not care. As Simon said earlier, The VA was desirous of just closing it out. They did not care. They did not want to hear me. Nobody's listening to me.
Okay. So is this the point when you kind of put Francisco in charge of communicating with Simon?
Right, because also my brother was going into organ failure and I'm trying to arrange a transplant for him and he died. So it's just,
All this is happening at the same
they
time.
did allow a break for, Philip did allow Simon to pause for his mom's birthday, but they would not allow me the time to do these things. His birthday party was allowed to pause on that for our scheduling, but I could not pause my issues to arrange the very detailed things I needed to list out. Nobody cared. So this is like, Philip just wanted to close, he was desirous of closing the thing out, as
Okay.
Simon said.
And this was in April?
It lasted March through April.
Okay.
The time.
Now, Mr. Reynolds has argued that, all this could have been resolved if you just let him on the property to make a few minor repairs, right?
I begged for him to come do the repairs. Even with all of my stuff going on, I begged for him to come do the repairs.
Mm-hmm.
No.
And previously, when you'd pointed out a problem, like the embankments in your backyard, he wanted more money, right, to make that repair.
Or they blew me off, which is, well, I don't know how much you want to get into that. They either wanted more money or they just went through a cycle of blowing me off. Just depends on which issue you want to talk about.
Now, at that time, was he offering to to fix the faulty electrical?
No,
Was he offering to fix the warped floor?
no.
Was he going to replace that door?
No. Actually, he wanted to come in and do the rubber.
Yeah.
That's what he wanted to do.
Was he going to remove the debris from your yard?
No.
He was, I think you said he denied that it was there.
Right.
So when you got sued to foreclose on your home, how did that affect you and your family?
Well, at that point, my dad was in hospice. So that was incredibly stressful and difficult because when you are in hospice, that means you have 6 months left to live. And so I'm dealing with that. And then the lawsuit saying, we're going to foreclose on your home when we had a terminal transition plan of my dad dying in the house. But then at the same time, I'm like, I just cannot take this anymore. And something about it is just like, I'm just not doing this anymore. I'm not doing this anymore.
Yeah.
And then Bernie said, you could have just paid it. That's extortion.
Yeah.
Which I've been doing all along anyway. I've just been paying all this demands.
Why were you paying his demands?
I had no other choice.
Why did you not have another choice?
Because I either lose the entire project, the whole ADU goes away, or other things, like where the front sidewalk is all torn up that he's installing, and the nurses come and then they leave because there's no sidewalk and I have to pay them anyway, and my dad's not getting the care. So I had no choice but to cut him a check so that he will continue putting the sidewalk in.
So,
I didn't pay him because it was an agreement.
so this project, it tears up the whole backyard, right?
Mhm.
And did you feel kind of trapped in the house?
Yeah.
Did it make it difficult to get your dad out?
Impossible.
And so, did you need to have this project completed as quickly as possible?
Yes.
And when he started asking for more money for various things, did you resist?
Politely, I resisted, and
And what happened when you resisted?
he resisted back.
And what form did that resistance take?
So there is, the friendly verbal resistance, but then there's just that work is not going to continue.
Okay. Would work slow down?
It would stop.
I see. So he would be demanding more money for one thing or another. And if you resisted, work would just stop?
Well, Simon has said multiple times he does not work for free.
Sorry, I cannot hear the response.
So Simon has said multiple
Get that
times.
microphone.
Simon has said multiple times he does not work for free. If I did not pay him the things that he wanted extra,
Mm-hmm.
even the tile here that I have already paid for, that he
Mhm.
wanted paid for a second time,
Mm-hmm.
okay, he wasn't gonna come back unless he got that. So what's the quickest exit for me to get this going is just pay it. Right? I cannot do anything else. The VA is not listening, nobody's listening. How do we get this back? Because I gotta get my dad out of the house. I gotta get the nurses back in. I
Okay.
do not have a choice.
So I think this sheds some light on an issue that we brought up earlier in Mr. Reynolds' cross-examination. So I'd like to turn to Defendant's Exhibit 20, which I believe has been admitted, right? So can you bring that up on the screen? And this is that letter from the VA to Mr. Reynolds, correct?
Yes, yes.
And can you read the bold?
Also, there must be no side agreements or exchange of funds between you and the veteran pertaining to the approved plans and specifications.
No side agreements with the veteran, right?
Right?
And so why is that there? Who is that protecting?
I think it's protecting both sides.
Okay, but weren't you in a sort of vulnerable position with your house all
Yes.
messed up?
Yes,
And hadn't you put a lot of work into this project?
yes,
Weren't you scared of losing the grant?
yes.
So weren't you in a vulnerable position?
Yes.
And did he take advantage?
Absolutely. And I think strategically, yes.
And he did that with his alleged side agreements, right?
Yes.
Because you can't amend the contract without VA approval.
Mm-hmm.
So the loophole is, oh, we'll do a side agreement for you to pay me more money.
I mean, that's what he's saying. It's not accurate.
Okay, all right. So let's just review a few key points from your testimony,
Mhm.
all right? Did Mr. Reynolds honor his agreement with you?
No,
Did he honor the contract price?
no,
Did he comply with the plans and specifications?
no,
When he deviated from those plans, did he get your consent?
only once, or yeah, once.
Did he finish the job on time?
No,
Do you remember how long it took, start to finish?
I think it was an extra 8 or 9 months.
8 or 9 months?
Wasn't it? I don't, oh.
So
Maybe?
135 days was the original deadline, right?
Right,
We add 8 or 9 months on that?
right.
Did he mislead you about his intentions when you entered into the contract?
Yes.
Did he actually intend to complete the job for the agreed upon price?
I don't believe so, no.
Did he mislead you about his intentions with the deposit?
Yes.
Did he steal lumber off your property?
Yes.
Did he steal a marble countertop from you?
Yes.
Did he do a good job on this?
No.
Was he honest about his mistakes?
No.
Did he try to charge you extra money for fixing his own mistakes?
He didn't try, he did.
Okay.
Me, yes.
Did he pressure you for money?
Yes.
When he pressured you for money, were you in a difficult position in your life?
Yes.
Did he threaten to walk off the job if you didn't pay him additional money?
Yes.
Did you have no choice but to give in to his demands?
Correct.
Did he deprive your father and your family of the full benefit of the VA grant?
Correct.
In the end, did you get any benefit from this grant?
Not for its intended purpose, no.
Did your father get any benefit from the grant?
None.
Who ended up with all the money from the grant?
Simon.
And was your father ever delivered any value for that money?
No.
Would you have sued Mr. Reynolds if he hadn't sued you?
I don't believe so, no.
Would you brought a case against him in Superior Court?
No.
Would you have just moved on with your life?
Yes.
And did he file a fraudulent lien against your home?
Yes.
And did he use that lien to try and foreclose on your home?
Yes.
And was your father in hospice at the time that this lawsuit was filed?
Yes.
And was this lawsuit still hanging over the family when your father passed away?
Yes.
And when Mr. Reynolds and Mr. Burney filed suit to foreclose on your home, did you actually owe Mr. Reynolds any money?
No.
And have you paid him everything that he asked for, even his unreasonable demands?
Yes.
And has dealing with this lawsuit been expensive for you?
Yes.
And what would you like to get out of this case?
I would like to be made whole.
Okay.
Just have peace.
Thank you very much, Mrs. Maia.
Thank you.
All right, unless any members of the jury need a full break, we can just stand, stretch in place, and Mr. Burney, you can begin your cross-examination when ready.
Good afternoon.
Good afternoon.
Ms. Mai, what's your occupation starting in 2019?
In 2019, I worked in tax.
I'm sorry?
I worked in tax.
Can you tell me more about that?
I did a lot of trucking. So basically truck registrations. I did database work. Airline flights, things like that.
So was that logistics kind of work?
No.
What, can you explain more like what you did on a day-to-day basis?
So if a truck needed a license plate, for example, or to get registered, they might need certain registrations. Database work, so like if somebody flies on an aircraft and they buy a ticket, I might look at their ticket and just see like what's on it. Was it booked right? Things like that. And look at the taxes on like how is that those how were those charges on the ticket? The taxes, like if they flew to Mexico versus South America, right? There might be something wrong there, stuff like that.
So you were looking at rules and interpreting rules and that kind of thing?
No, not
No.
really. No.
Okay. And did your job change, your occupation change from 2019 forward?
Yes.
How so?
I became a caregiver, just a caregiver.
You're a full-time caregiver?
Yeah.
When was that?
2023, I guess, or 2020. Yeah, I think 2023 maybe.
So were you working full-time when the relevant facts time period to this case was going on?
What do you mean?
Were you working full-time while this case was going on? I'm sorry, from October 19 until spring of 2022, were you working full-time?
I had a flex schedule, so I mean, I guess I put in 40 hours. I guess if that answers your question.
And that was, okay, that's fine. And did you work from home?
Yes.
All right. You mentioned in your testimony that you had involvement with the VA starting in 2016?
Yes.
Okay, can you elaborate a little bit more? What was the first project you did or attempted to do with the VA?
I attempted to get, well, it was the beginning of the application was 2016.
That was the beginning of the application that started out as a bathroom?
Right.
And that was a bathroom in your main home? Is that correct?
No, it was actually, it was just the bathroom in my father's home. And it was just to get qualified. So if it was it was attached to my father. It wasn't attached to the property.
Was it at 1261 Grant Street?
No, it was no address. It's attached to my father, not to the property at that point because it's so early.
Okay, where was
It was wherever my father chose to live.
I see.
Period.
And where was your father living at that time?
In Augusta, Georgia.
I see.
Mm-hmm.
And when did he move in with you?
It was a few months before I engaged with Simon.
Okay. When you say you engaged with Simon to start talking about potential project?
I think so, yeah.
And that would have been?
Or it may have been at the same time. It was so close, it's hard to say.
And you testified at that time that your father was bedridden at that point?
Yes.
But is it true that, or correct, I wasn't quite sure that he could get up and be put in wheelchairs or be in wheelchairs as well, or no?
Like what do you mean?
Could
Like
you put him in a wheelchair?
with a Hoyer lift, yes.
Okay, and so was he getting into wheelchairs on a daily basis, or?
He didn't do anything.
I understand. Were you assisting him or his caregivers assisting him to get into a wheelchair?
At that time, I don't think we were regularly putting him in a wheelchair. It just depended on maybe what was going on.
And did that improve over time or no? In other words, did there come a time after 2016 when he was able to get into a wheelchair, or did that happen less and less as time went on?
I guess I'm confused by when you're saying, was he able to get in a wheelchair?
Well,
Because anybody can be in a wheelchair. You're saying able.
Well, let me change the question. So was he put into a wheelchair in any kind of regular basis from 2016 forward?
At any time that so you sort of need to change the body position because otherwise you get ulcers. So we would oftentimes take him and move his body so that he didn't get ulcers down to the bone. So that would mean occasionally having him sit up, having him lay down, having him lay on his side, right? Because otherwise the skin, it literally disintegrates away all the way down to the bone. So you want him to sit up, which would mean a wheelchair.
Right.
And we actually got him a new wheelchair at my house.
Okay.
So we used it
Mm-hmm.
and it was brand new
I see.
at my house. We actually got 2 new wheelchairs at my house for him.
Okay. And you said you engaged with Simon, you knew him from the HOA situation, correct?
Right.
And he had come to make a bid on a project for you which you didn't accept,
Yes.
and you hired someone else to do the work?
Mm-hmm.
Okay, what was that work?
It was a renovation of my front porch.
Okay. And you decided later on that you would approach him again to see if he could help you with the getting the grant money.
Mm-hmm.
And you had Francisco reach out first.
Just to make the phone call, the first phone call, and then that was it, period.
Was it just to make sure that Simon would be receptive?
No, actually just so that if my phone number was in his phone, that he wouldn't just like brush me off saying, oh, she's just a waste of time. I gave her a free estimate. She's just gonna not, waste of time. I don't want to do another estimate for this lady that's not gonna respond.
Did Simon
So-
strike you as the kind of person that would react that way?
I don't know, because I didn't know him.
Okay.
So
So when you said earlier that he gave you some attitude, that wasn't correct.
no, it was.
Okay.
He said, good luck with that.
Okay.
In an email, like, I guess you can infer the tone, but when someone says, well, that estimate seems pretty low, so good luck with that. If someone writes that in an email,
So he wrote the words, good luck with that.
exactly
And you
that.
took that as the tone to be negative in some
Because
way.
I think it says when that price seems too low, so good luck with that. There is words, there's text, subtext, context. It is pretty obvious. It's not meant as a well-wished good luck.
But it wasn't so negative that you didn't feel like you wanted to reach out to him again.
Right, exactly.
And you did reach out to him.
Yes.
And you connected with him on the string of 80 or string of VA grant projects that you were pursuing.
I don't understand that.
Okay, so I thought you testified that you talked to Simon and he was assisting or gave you information to help you prepare grant applications more previous to the one that we're talking about in this case, or the two that
No.
we're talking about in this
No,
case.
no.
Okay, so Simon didn't assist you in any way on any other grant prior to this?
So this is only one project. I don't understand what you're referring to.
I understand that, yeah, I agree with you, it's one project. What I'm asking is, I thought you said from your testimony that you were communicating with Simon on other ideas prior to this project.
So there is the SAH grant, right? The adaptive housing grant. And then there is the alteration grant. So there's the $100,000 grant and the $6,000 grant. Those are the only 2 grants. That's it. Now, those grants, although they are a lot of money, I wasn't going to exhaust that expense. I was going to just do a bathroom. I wasn't going to do the $100,000. It was just a small project. And together it made sense. Well, the words are, hey, all this free money, why are you going to leave it on the table? And then the project, and it made sense, I agree. Just, it's there, use it. So the project developed and today, here we are. So it wasn't, I don't know what you're saying about a string of projects. It's the same project that developed over time.
Right, so the project evolved,
Mhm.
and during that time, while it was evolving, Simon was there giving you some help or assistance, trying to help it go forward for you?
No,
Help you plan it?
no.
Okay,
So
what was happening?
So in the same way that he gave me the free estimate on the porch in 2009 and how he gave my neighbors their free estimates, this is an estimate. It's a contractor giving work. I've never been charged for an estimate ever.
Right.
So it's that.
Right, okay.
And he didn't help me do anything with the VA at that point. No.
Okay. And so let's fast forward if we can and talk about I want to talk about how you communicated with Simon.
Okay.
What methods did you use to communicate with him?
I would say there's 4 methods. Well, perhaps email, text, phone, and in person.
And of those, which do you think you did the most?
I don't know. I can't even hazard a guess. I don't know.
Did you text him? You texted him, correct?
I did text him, yes.
And you texted him from kind of the beginning of October 2019 through the spring of 2022.
Well, I texted him long before that, but you deleted them all from your evidence. Sorry.
No, that's not correct.
Yes, it is.
It's not correct.
I have them, so yes. it
Okay,
is
well, I'm not
correct.
saying that they didn't exist. We produced a selection of texts. So that doesn't mean we deleted anything.
Oh, so, well, then they disappeared from the evidence span of time that we requested. You didn't produce them.
Okay. And you communicated via email,
Correct.
right? And what was your email?
Oh, Regina@gmail.com.
Is that the email that you used throughout?
I believe so. I don't think I would have used my work email. It seems highly unlikely. Because I don't think that's likely. So, Regina@gmail.com.
Okay.
I'll speak louder. Okay, sorry.
So let's fast forward to October 2019. Okay. You're talking with Simon in one of these ways of communication. And you're working with the VA. At that time, what was your idea for what you wanted to do with the property?
At what time period?
October 2019.
So because the project evolved, I don't remember as of October 2019 where we were in the development. It spanned from overall bathroom to mom and pop suite to ADU. So I don't know in that time frame at what point that falls.
Okay. Do you have any idea when it went to, you're going to do the ADU under the SHA program?
Well, it is very likely since I believe that's the first time I met Shona. So that would have been the ADU
Okay.
because that would have been Shona. So that was very likely around August, maybe around, I'm trying to think of when I first communicated with Shona we were probably in ADU at the time then.
Okay. And just to clarify, you came into contact with Shona and how exactly?
Because Simon introduced Shona into the project.
Okay. And you met with Shona on your own and with Simon, or how did that work?
I don't think I ever met with Shona on my own, no.
Okay. And Shona was the designer of the plans for your project?
Correct.
Okay. And in October 2019.
Can I rephrase? So
Sure.
after the project was rolling, I did communicate with Shona regarding permits and things like that without Simon's presence. But initially in those kickoff stages, I did not meet with Shona. I don't recall ever meeting with Shona alone.
I see. And when was the first time that you sent any kind of money or anything to the VA for any kind of, I think you stated that there was payments that went into escrow or payments for different things. Can you give me some feedback on when that would have happened?
I didn't send payments to the VA.
You never sent any payments to the VA?
I think I put I think I sent them to Simon. I think that's the way it worked, was to
Okay.
Simon. And then I had to send the VA proof that I paid Simon.
Okay. So you're talking about this project now. I thought you talked with Mr. Craig about having done some things before.
Right, so we have a contract with Simon, or I had a contract with Simon, and certain things are included in that contract that Simon was supposed to pay for, right? And when those things were not paid for by Simon and were up against the wall, I had to come in and pay those things.
Okay.
And then Simon refunded that back, or it came out of a disbursement,
Okay.
or whatever wording it was in the email that was on there where Simon says, let me know how much I owe you, or whatever that email said. Maybe we should pull that up so I'm not saying the wrong thing. Whatever Simon's words were
I'm
is
just
the
asking
way.
you to tell me what you know about the questions that I asked.
I don't want to say the wrong thing. Maybe we could pull up
I understand.
Simon's email about me being reimbursed. I don't remember.
About what?
Maybe we can pull up Simon's email where he's asking about how much he owes me to be reimbursed. That would be helpful.
That's an email that you have in this case. Maybe you can.
Yeah, we had it up earlier.
Okay, we'll do that in a second. Hold on just a second.
I just don't want to say the wrong thing. That's his words. I said it was his phrasing. I didn't want to misspeak.
Okay, so when you started on this project, you were in communication with the VA and you were preparing information applications and things like that, correct?
Mm-hmm.
You had to have Simon approved as a contractor with the VA.
Yes.
Simon, you knew that Simon had not done a VA project before.
Yes.
And what was it about Simon and Reynolds Renovations that you decided would be worth to have him be approved?
I found Simon very charming. I went to his work site. I thought that everything from the way it looked nice. But I don't have the refined eye, but to me it looked good. I liked keeping the money in the neighborhood. I like to support small business. I thought, what can go wrong? He's right here.
So you actually drove and saw some of his other projects?
One project.
Okay. And you found that good and
I
acceptable?
thought it looked good.
Okay, what kind of project was it?
It was a house. I spent like maybe 5 or 10 minutes there. And I walked around and I mean, I admit I don't really know what I'm looking at, but it looked good. Like, I don't know what I'm looking, I mean, it looked fine. It looked nice.
Right.
I don't know. I didn't see like mislaid tile or anything. My tile's falling off, but I didn't see that there.
Okay. And so when you have you had other contractors come to your house and do work in the
Yes.
past?
Yes.
What kind of work have they done?
I had a kitchen renovation, bathroom. I had my floors redone. I had the fence put up. I had gutters. The retaining wall on the Dalton Street was not my installation, but I was involved with it. The city put it in on their election to put it in. But because it was on my property, I had comments. What are you doing there? Right. It wasn't my nickel. I had, I'm sure there's things I'm not remembering, but
When you had, let's take your kitchen renovation, what was the monetary amount in range of that job?
the monetary amount? I mean, I don't remember. I don't remember.
Do you remember if you gave it an upfront payment to the contractor to get started?
I don't remember how that went.
Do you recall in any of the contracts that you've had, whether you've made an upfront payment to get the contract started?
I don't remember the kitchen. It is possible, but I can say with the bathroom, I did not.
Okay.
I did not give any upfront payment.
Have you ever given a contractor a payment at the beginning that they then gave back to you?
Well, Simon did
Besides
it.
Simon.
Well, Simon did that.
Besides Simon?
Oh, besides him? Well, the hallway bathroom, I didn't pay a penny until the project was done. My floors were financed through a financing company, so my fence was done like 20 years ago. I think that was a financing company. I just haven't been in that situation. And so the only person that has done that is Simon. So I don't know
Okay.
how to answer your question.
Did Simon ever tell you, did you ever have a conversation with him as you were moving forward that he would need some upfront money?
So Simon discussed that with me, yes.
Tell me about when that conversation occurred,
When?
as best you can recall.
Well, around the time he sent me the invoice.
So that would be in October 2020 or?
Yeah.
Okay, was there an invoice in May of 2020 as well?
May of 2020 or
Yeah.
21?
Well, I'm asking you if you recall when the first time that you had a conversation with Simon where he expressed to you that he would need some upfront money to do the project.
So around the times of the invoices is when we discussed it, the dates of the invoices.
Okay. So what was the conversation?
So on the first invoice, he was saying, that's just not realistic. The whole contract as a whole was not realistic. And so that conversation, it was regarding the contract paying for that breezeway. It was an entire discussion that this is not feasible. The breezeway as is not feasible. This upfront money is not feasible. The disbursement schedule ultimately was not done right.
Okay.
That was a later conversation.
All right, hang on just 1 second.
There was also discussions about, wait.
Go ahead.
So later, he had mentioned that because of the price of our contract, that he didn't want to go bankrupt doing my project. I mentioned to him that there are waivers in place.
Right.
Oh, wait.
So there are waivers in place?
Sorry, that I have put waivers in place when things didn't work out according to the VA plans.
Okay,
Right.
and what kind of things were you getting waived?
So the main one that is top of mind is Simon and the need to have the 3 estimates. There are a couple other waivers that I don't remember. It had to do with just other things related to my dad even getting the contract, and I don't remember what those are. So I think I had to go through 3 different waiver processes.
Right.
And so we had some discussions around that. Okay. There is, yeah.
So when is the first time you had a written contract with Simon?
We had a few versions of the contract, and I don't remember I actually think there's a contract for 109,000. This is not the first contract. I think there's one for 109.
You don't have a copy of that contract?
I don't.
That's fine.
Yeah.
So let's look at
There's
plaintiffs too.
multiples.
What's the date of this contract again?
July 2nd, 2020.
Okay, and if you look at this contract, the price is $136,334,
Yes.
correct?
Mm-hmm.
And if we go to the next page, well, first of all, that's your initial on the first page, correct? RO?
Yes.
If we go to the next page,
It doesn't have Simon's initial though. So.
That's
I don't-
correct.
I don't know if this page even corresponds to anything Simon signed.
Okay.
It's got no association with Simon on it.
You said to Mr. Craig that you didn't sign this agreement, but you did sign plaintiffs too, didn't you?
I'm sorry, what?
You said, I thought you told Mr. Craig that you did not sign this agreement.
I
You
never
said
said,
you initialed it, but didn't sign it.
no, I never said that.
Okay, so
What
that
you
is
say?
your signature?
No, I initialed this.
So I'm looking, if, at page 2 of plaintiffs
Yeah.
2,
Mm-hmm.
is that your signature?
Yes, I never said I didn't sign it. I don't
Okay,
know, I
that's
don't know what
fine.
you're talking about. I'm sorry, I'm confused. I
I'm not
said,
trying to
I
confuse you.
said this page 1 has no indication that Simon initialed or signed this. So that's
Understood.
what I'm saying.
And I'm pointing you to page 2 where the
Okay.
signature blocks are.
Yeah,
That's got a signature on it
yeah.
from, for your father that you signed on behalf of him as power of attorney, correct?
Yeah, I've never said anything contrary that I didn't sign this.
But why did you have to sign this agreement if it was just a version that you were working on?
Because at the time, this was something that we were like, it was a possibility. Like that's the one we were gonna go with. And then we didn't.
Okay.
It never got submitted. We didn't finish it. It doesn't have any of the agreements, attachments. It is got none of the requirements to perfect the contract.
We'll go back to page 1 of this agreement, please. So this agreement's got 2 exhibits, well, it's got 4 exhibits really, but
Mhm.
exhibits B and C are basically specification sheets, right? You've got them referenced here. Whoever prepared this has them laid out as PDFs, right? And if you look at those, aren't those the same exact specifications that are listed on the October 20th, 2020 agreement?
I don't know. Can you pull that up and show me? Oh, I have it. I have it here.
It's the same, correct?
Yes.
Why did you sign this agreement for $136,000 if you thought it was too much money?
Well, I had reconsideration.
So you signed the agreement and then you decided to not go along with it. Is that what happened?
So, correct. And
Okay.
also, we didn't perfect the contract.
I think there's no dispute that this was not submitted or approved by the VA, so it's not, it can't be an active contract. I'm not trying to say that.
Mhm.
But you didn't know that at that time when you signed it, did you?
Correct.
You thought it might be approved.
Well, yeah, I mean, that's something that we were working on, yeah.
And you were willing to pay $136,000 for the same plans and specifications that are listed on the October 20th, 2022 contract, 2020 contract, correct?
So with any.
Just answer the question
No.
and then you can explain. Yes, please.
No,
So that's not correct?
because you always have an option, a time limit with any contract to say no. And that's immediately what happened.
Well, explain that to me.
I believe when you sign a contract within, I think 24 hours, you can say no.
Okay.
Don't you have
Did you
that?
tell him no within 24 hours?
Within a quick amount of time, I think so.
Then why on page 2 of this contract did Simon sign it on July 10th?
That's an excellent question. He should have torn it up.
Because you said no on July 3rd,
I didn't,
but he signed it anyway.
probably, he should have torn it up. Why isn't it torn up? It looks good for him though. This is why he kept it.
On page 2 of this document, there's a similar clause, construction start date acknowledgement. Construction may not begin until the VA's provided authorization. The construction will be completed by blank days.
Mm-hmm.
So you sign a $136,000 contract to do the same things that are listed on your October contract, but you don't have the dates, you don't have the number of days on there. Why is that?
There's a text message from me to Simon asking him to fill that in.
Is that for the July 2nd one or for the October one?
No, for this one.
Okay. And so you were just going to leave it up to Simon. It was so important to you about the number of days that you just said, hey, Simon, let me sign this, and you can put the number of days in, whatever you think is right.
This, so this contract is not perfected.
I understand, but that's not what I'm asking you, because you've already testified that you said when you signed this, you thought it might be approved.
Yeah.
But you signed it without filling in that construction start date
Yeah,
and the
because we
days
have
of
a
completion.
lot of elbow room with this in terms of the timing. There's an escape clause. We have so much time. This contract is paper tight. It's nothing. It's nothing
Can you go
until
back
it's
up one
approved
page,
by
please?
the VA. It is nothing. It
So
is,
the
you
escape
can.
clause, let me just interject on number 2,
Mhm,
the second paragraph, the escape clause that you mentioned.
mhm.
It says this contract is conditioned in its entirety upon the veteran receiving a grant.
Mhm.
And if the veteran doesn't receive the grant, the contract is null and void, and any and all monies will be returned without exception.
Hmm.
That has nothing to do with you.
Yes, it does.
I mean, it doesn't, it's only, if the VA doesn't give the grant, then it voids the contract. But it doesn't give you a way out of it.
That makes absolutely no sense. You make that, what?
Okay, so you're saying you could sign this agreement with Simon, and then the VA, and then you'll never get, if you don't get the grant, it's void,
This contract is null and void.
correct?
Boom.
But at the time you signed it, you didn't know it was going to be, it might be, you were going to try to get it approved,
You gotta submit it to get approval.
okay? But you never submitted it,
Correct.
okay?
Thank
Can you go to
you.
plaintiff's one, please?
Thank you for that. Confirmed.
Maia, this is plaintiff's one. Have you seen that document before? Can you make it a little bigger,
Yes,
please?
I have.
And what's the total amount? That's an estimate. And what's the date on it?
May 15th, 2020.
So that's about a month and a half prior to the July 2nd contract, correct?
Yes.
And at that time, you had been working with Simon to develop what the project was going to be and giving him information so he could make an estimate, correct?
Correct.
Okay. And if we go down, please, to the bottom of this, keep going, stop. It says $136,194.
Mm-hmm.
Right.
Correct.
And so that's a little different than what's on the July 2nd. It's about $140 different. Do you know why that's different?
I don't recall.
Okay. And so it also, the only other real difference here is that the very last line item on this exhibit, which is, if you go back up, please, go back up just a little bit. Keep going. Keep going. It's an estimate from Reynolds, Renovations and Restoration. And now if you go down, the only difference here in terms of the line items at the very bottom, please, Katie, is specialty covered walkway, footers, posts, roof structure, clear panels for roofing. That's included on this one for 136,000, correct?
So what do you mean difference?
What I'm saying is that this document here, which was created on May 15th, 2020,
Hmm.
and is within a few dollars of the amount that on the contract you signed on July 2nd for $136,000. The only difference between this document and the Exhibit D to the October 20th document is the fact that this last entry is gone off the second one. The walkway is not on that one.
Sorry, I need to find that.
Let me get it for you. Can you, let's pull up our version of the contract. No, it's not, it's 3. Here you go. That's been previously entered into evidence as plaintiffs 3. I'll represent to you that what that is to be is a copy of the contract from October 20th with A, B, and C and D exhibits attached.
Okay,
So take a moment to look at it.
So this is October 20th. So you want me to compare the invoice from October 20th with the one from May?
Correct.
Okay. And you're saying,
I'm just asking you to tell me whether or
Okay.
not the specialty walkway, the very last line item on the exhibit that was from May of 2020 and almost matches exactly the July 2nd contract that you signed, whether or not that last line item is on the October 20th line item.
but that wasn't your question earlier. I would like
Okay, well,
to,
that's the question now.
would like to answer your other question.
Not how this works. You can answer the question as asked.
Can I answer the other question? The first one?
Ask your question. That's the one you answer.
Okay.
Let me make it simple for you.
Mhm.
Are those two documents the same?
No.
Okay, and how are they different?
This one for 136,000, there are $21,000 worth of line items on this that do not exist on the other one.
Okay,
21,000.
right, but one of them that doesn't exist, there are changes on it, I agree with you, but the one thing that isn't on there is the very last one, which is the walkway.
Among thousands of other dollars.
There's also an addition on the other one for the installation of the gas line.
Mhm.
So I submit that there are some differences,
So
but
it's
the main
not-
difference is the 16,000.
It's 16 is a big chunk of the $21,000 that
Right.
were removed from this. It's a nice convenient insinuation that, ooh, 16,000, that's convenient. It's $21,000 off of this that are different.
Let me show you what is marked as 15A. That's the text messages.
Okay, I think we do have a copy. Sorry.
It's from July 21st.
Okay, thank you.
Miss Maya, you can publish it, Katie.
Give my computer.
Taking a second to load up.
Sorry, I promise. Oh, there we go.
We have.
Having a little computer glitch. So if you look at this text message chain, is your phone number at that time, was it this phone number ending in 4123?
Correct.
Okay, and on July 21st, 2020, you say, I have an idea about the deposit we can discuss offline. What is that idea?
So I had submitted at least 3 times different waivers to adjust the VA's requirements. And so it's a pretty lengthy, like in-depth process. And so that is something that we really needed to talk about with Simon because he didn't do his draw schedule. You're entitled to up to 20% of the total contract price in advance in the first distribution with pre-construction costs. And it's a pretty lengthy process to do the waiver. So that was option number 1. And that's very viable. It would delay the project probably some weeks, but you can get up to 20% of the overall project in advance with pre-construction costs.
Okay.
So
and-
that's number 1. And then there was spitballing some other ideas.
Like what?
So what ended up happening,
Well, what were the other ideas you had?
so like I have put my card down and gotten reimbursed like I have with Simon, like we did 3-4 times.
So the other was you providing money.
To the vendor, not to
Okay.
Simon.
So you never have given Simon any money that you didn't expect to get back. Is that correct?
At that point,
Yeah.
up to that point on that, no. Well, no, I guess I did get that back. I guess I don't understand. I did get it back, and that's Simon's, that money is Simon's in the contract. I paid and got back, so that is this weird convoluted exchange of funds that is Simon's that came back to me.
But
So
this,
it is, I don't
the whole
understand.
issue that we're having here, this disagreement, I think you would
Yeah.
agree, is whether or not this $16,000 that you undisputably paid in May of 2021, whether or not that was going to be refundable to you, correct? And so my question to you is this. If you wanted it to be refundable,
Mhm.
why isn't that in the contract? You've gone through you've been going through multiple versions of the contract. You've been dealing with the VA since before October 2019. You know how to do contracts. You do them with work and you do them, you've been doing them
Well,
on these
Don't make that
projects.
assumption about my
Okay.
job because you don't
Well,
know.
you know how to fill out title registrations. I mean, that's,
I don't fill those out.
okay. So in October of
don't assume.
2019, you started working on this project.
Mhm.
You were working on the VA
Can I
project the
answer
whole
it
time.
now? Why it's not in the contract? Because he dropped it on me like a bomb 1 week before we were breaking ground. That's why it's not in the contract.
Now, hold on a second. You broke ground in May of 2021.
Right.
After the issuance of the
Mhm.
building permit. This is July 2020.
Yeah.
And you're talking about the deposit.
Yeah. That's Simon's interaction with the VA. That's not my interaction. That's Simon getting that money from the VA through a waiver, organizing the 20% pre-construction arrangement. That's not my
So
money.
you expected Simon to do that when you've been handling all the VA things. That was what he was going to do.
100% of the disbursements was arranged by Simon.
Okay. So
That
you're
is
saying that in July of
100%
2021,
I had
Simon did not
zero
say to you.
interaction.
Hold up. One at a time.
In
Let him
July
finish your
of-
answer. Let him finish his question.
In July of 2020, you're saying that Simon did not bring up the idea to you that he needed to have some upfront money to get started on the contract. Well, he must have, because you just said that you were giving him some ideas on how to get it.
Yeah, so 100% of the disbursement schedule arrangement was done by Simon, and I had nothing to do with that. But what I can do is I can share with him what I did to get my waivers. That is extremely helpful. I had nothing to do with Simon's disbursement schedules. He copied me toward the end. I didn't arrange his disbursement schedules.
Okay, so,
I was courtesy copied at the end of those.
okay, so you go through that process. Simon doesn't say anything about that he needs money up front.
No,
or
he
does?
did.
Okay.
And when that is, no, that's not going to happen. And it's clearly not going to happen, which tells me he was just married to that idea. And that's what he wanted all along, was just to keep the money.
Or that's what his course of conduct has been, to get upfront money to start on jobs, like
Exactly.
he's testified and like Mrs. Hine has testified.
Exactly. Which is not the way this project was designed. Exactly.
Okay, so when we get to, in between July of 2020 and October of 2020, when you signed the agreement, do you have any text message or email from Simon saying, I don't need any upfront money?
Well,
Did he ever tell you it's okay, you don't have to give me a down payment?
no,
Okay,
because we never said it was gonna be a down payment.
okay, so you're saying that in May of 2021, excuse me, yeah, May of 2021, after you signed the contract, when you received the invoice for $16,000, right? You didn't like that. I mean, was
No.
that a welcome sight to you?
No, I didn't like it.
Okay, and what did you do? Did you write him an email? Did you send him a
I
text?
think I called him, just talked
Called
about it.
him, but you didn't put anything in writing in your text thread.
I think something like that deserves a conversation. It just is better.
So is
No.
that why this text
Maybe.
thread between you and Simon is completely devoid of any issues between you and him? And if we go to May of 2021, around that time, May 5th to 10, there's nothing about this. Simon Why are you asking me for $16,000? We're supposed to start work in a week. How could you do this?
Well, we did discuss that we had that discussion, but ultimately we got to do this and I have to maintain this relationship. And ultimately I am going to get that money. So,
Okay.
I am getting that. That money is in escrow there. It's going to be waiting for me. I've already gotten refunded. I've already got money back.
But
So
did you send that money to Simon?
what do you mean?
Sorry?
I don't understand your
The
question.
money, when you paid that May invoice in 2021, did you wire transfer that money to Simon or to the VA?
To Simon. And I felt okay doing that because I knew that was going to come back to me out of the last disbursement. And I had to get this project going. It
And
had to
then
happen.
the draw schedules start to happen. You have to pay the first draw or the first payment, and then you pay part of the second payment, correct? And then from then on, it was the VA who was paying for the project, correct?
They were releasing my father's grant money, my
Right,
father's
they were
money.
giving, it was money that was, we're not disputing that money was your money,
Mhm.
your and your father's money, to use to purchase this construction, okay? But you've given Simon $16,000 on May 10th, 2021. Those grants money payments are happening all through the fall and all the way into the beginning, like April of 2021. And there's not a single email from you to Simon or to the VA or to anybody saying, pay me my money.
Well, that was our plan, was it to come out of the last one. And that's what I wrote in my emails at the end when we were having our dispute.
Where is that agreement that it was to take it out of the last one?
That was our discussion.
So Simon is supposed to take the 16,000 and then at the end, pay you back out of the last draw.
Correct.
Okay. And so you don't have that in writing.
No.
Okay. And the contract that you're so willing to enforce against Simon is completely silent about this major issue that you're going to upfront money to him for $16,000 and then he's going to pay it back to you.
Because that wasn't happening at the time we signed the contract.
Okay. So at the time you signed the contract, you're saying to this jury that you didn't know you were going to have to give Simon $16,000.
Correct.
Okay. And that, but that you agreed to do it. So you departed from the terms of the contract. Is that what you're saying?
I felt like I was frankly extorted. It was
Where's
either,
the email or the text? Where's the outrage?
why are you determining my emotions for me?
I'm not. I'm just asking you. I would think that someone in your situation who's just thinking that they're going to get this beautiful ADU started in 1 week and suddenly gets this out of the blue demand for $16,000 that they don't agree with, didn't expect, don't want to do, would say something.
I did.
But you didn't write it down. You
Why
don't
do
have
I-
any documentary proof
Because
of it.
that deserves a conversation. And I don't think that you should determine how my feelings are expressed or what I should feel.
I'm exploring what happened in this case, and I'm asking you questions to explain your actions. And I want
am
you to tell
explaining
me, I'm not trying to tell you how to feel, but I'm saying that it would seem normal or reasonable for someone to be upset about that.
I don't know.
I'm not saying you have to feel that way, but I want the jury to understand what you say. So that's it.
Okay. So you want to get my husband arrested for being
Okay,
too
ma'am,
mad.
listen to the question that's asked.
and then
Answer
me,
only,
I'm
excuse
not
me,
mad
ma'am.
enough.
Would you like to have your case thrown out now? Listen to my instructions. Thank you, sir.
Thank you. On May 10th, 2021, you say, I sent the wire transfer this morning.
Correct.
Nothing else.
Yeah, correct.
Then the next thing you say is, perfect.
Correct. Well, hold on. Can I see those texts?
Sure. I think they're up there, if I'm not mistaken. Maybe not. It's just the one thing. Let me sit over here. We had a binder.
What are you
clip
looking
set
for?
of Regina's.
A binder of Gina's texts.
Binder clip section.
Do you want this binder? Would that work?
Oh,
Oh, you gave it to maybe the.
Oh, there it
corner.
is.
I'm so sorry. It's 22.
No, yeah, it is.
So I'd like to get it turned to May 10th, 2021. That's a lot of text there, isn't it? And you're telling us that it's not even all of them.
A lot is relative, so I don't.
Well,
know
hold
how
it
to
up.
answer. So over the
Thick- it's a
course of
thick-
years, maybe this is a lot, maybe it's not to some people. I don't know.
Okay, but it's
A
a
lot.
lot between a homeowner and a builder. Wouldn't you agree?
Maybe it's not enough. I don't know.
So can you look at May 10th, 2021 and confirm for me that the only thing you say about the deposit that you didn't want to pay, that you didn't agree to, and that came out of the left blue and that you felt coerced to give because you were supposed to start work in a week, is you say, I sent the wire transfer this morning.
So there are a couple of things that hopefully I'm allowed to talk about with this.
You're on cross-examination, so I want you to you can talk about what's this relevant text thread right here.
Okay.
And I'm happy to hear about that because I want the jury to understand what were you thinking at that time?
Okay, so
Thank you, Lexi.
I am not sure that, and I cannot say that this text thread is complete.
Okay.
That's my hesitation. It could be, but you have deleted a lot of text messages.
No, I have not.
Okay, you will not make personal representations, Mr. Bernie, either. So you can just ask the question and she can answer it.
So I am not sure. I don't know how to answer that to say if this is complete or not.
So you think that there may be a text in there
I
that was
don't-
deleted? Let me just finish the question.
Sure.
You're telling the jury, you think there may be a deleted text where you say, why do I have to give this to you? We didn't talk about this. This wasn't the deal.
I'm saying, looking at this, I don't know if this is the complete chain of text messages.
Okay, fair enough.
Based on my knowledge of deletions.
Fair enough.
I don't think this was added. I can say this one text I did send, but I don't know what else there could be. I don't know.
Very good. But you would agree that in the contract at issue, the written contract at issue in this case from October 20th, there's no mention of a deposit. But you did pay a deposit.
Correct.
Did you ask for a change order?
No.
Why not? Contract says you have to do change orders.
Well, it was definitely against the rules.
So that's okay for you, but not for Simon.
It was that or lose the whole contract. So,
Is there anything in that text message thread from Simon that says, if you don't pay me this money, I'm going to stop working?
it's not in, well, in this, so I have to go back to my prior answer that I don't know how complete this text message
But
thread
you have
is.
access to your text messages, right?
But I don't have all of this stuff memorized.
You have a phone with your text messages on them, correct?
Not here.
Okay, but you have it and have had it since 2019 or
So
however long.
on my recollection, I don't remember. I don't remember anything like that, but you're asking me about this. I don't know about your thread.
Understand. My point is that you're here telling this jury that you don't know if that's a complete set.
Correct.
But yet this was provided to you in discovery.
Mm-hmm.
It's bait stamped from Reynolds Renovations.
So off the,
It was provided over a year ago. You've had all this opportunity to confirm whether or not that's the complete set. And here you sit telling this jury that you don't know.
no, okay, so off the top of my head, sitting here, I can tell you I can probably recite about 20 cases sitting here off, just pulling it out of my head. So, but pulling it out of my head, I don't know if I can recite all of them.
So you're saying
I did.
cases
Let her
of,
finish.
I'm sorry.
So what I did was I took your entire history of text messages and I put mine and I went line by line and I made a list of all of your missing texts.
Okay.
But sitting here, I can't recall every single line item of that because I'm not a computer.
Okay.
So
You didn't think to bring that and have your attorney?
we did that in your motion to compel and then you lied about it.
Your Honor, I lied about what? Mrs.?
That nothing was missing. You said it wasn't, and we kept showing and we.
In the motion to compel?
Yeah, in the motion to compel discovery.
Okay. I think, well, that issue was resolved, correct?
No, well, it was closed, but what, just define resolved.
Again, as I said, I don't think we need to get into discovery.
Yeah, let's move on.
Issues about that nature.
In any event, you didn't bring it with you here today.
The list?
Yeah.
Well, you have all our text messages. Did you compare them? Because we told you about all the missing ones.
It's not my responsibility. I'm just
Well,
asking you if you did, ma'am.
we gave them to you and
Okay.
told you that they were missing.
Do you have personal knowledge of the 20 or so that you're thinking about that have any effect on this discussion about the deposit?
I don't know.
Yes or no?
There's more than 20. There's like hundreds, but I mean.
Of the more than 20, are there any that affect this text message thread about the deposit?
Out of those hundreds missing, I don't remember.
Okay.
I mean, I don't remember.
Mr. Bernie, may I just interrupt you for a quick second? Did I leave a pile of exhibits out there?
I think there's a couple of yours here.
Can I come up there and just try
Sure.
to sort out our stuff? I apologize for leaving this.
Oh, it's fine. There's some under here too.
Should I just take the defendant ones?
Yeah, that's fine. Yeah, there you go. I think there's some in that sack that aren't.
Keep this one,
No,
this one.
nope. I'll keep this one.
Sorry about that.
That's okay. One of the things that you brought up in this case, or then brought up in this case, is the fact that we demanded a jury. When we filed a complaint and we asked for a jury. You asked for a jury as well, didn't you?
In the complaint?
In the answer.
In my countersuit?
In your answer and countersuit, you asked for a jury.
I think they go hand in hand, right? I don't think that you can have a jury and then we can tell them to go and then we continue. I think doesn't work that way.
Well, the way I would submit to you that the way it works is if you don't ask for a jury, we don't have to have a jury. But you did ask for a jury, and unless we both agree, there's going to be a jury.
Okay.
So the point is, you asked for a jury.
Yes.
Okay.
Yes, we did.
Let's talk about.
No, I think
The change orders. This is most interesting.
Which exhibit do you need? Yes, sir. Let's, I've got them right here. They just happen to float to the top. Well, here's one. Are you looking for both versions of the second change order?
Yes.
Okay. Okay, here's the first one. You've got the second one. Or, I'm sorry, is that the second one, version 1?
Yeah, I think this would be fine.
Okay.
For 1 and 3. And it's exhibits 1 and 3. Oh, 1, no, let's do.
001 and 003.
Correct. You can start with 001. Actually, let's just go to 003. Ms. Maya, when did you first notice that Simon's company was building a wraparound deck on the ADU?
When did I first notice?
Yeah,
It was you mean in terms of the date?
yes.
I don't remember the date, but I believe, that the change order was after the deck. I mean, after it was done.
Okay. And can you explain why in your text message thread to Simon, there's nothing about why did you build a wraparound deck instead of what was in the original plans?
Because it's a discussion and I'm on the property.
So you didn't think it was important to document, which was a very major issue to you
I
in this case, correct?
So I think you're failing to acknowledge that my project manager and my communication and my complaints go to the VA. So I'm also on the property and I'm talking, and you seem to just be relying only on text messages.
Okay.
There's
so-
a whole
so
thing
did you-
happening
did-
that's
finish? Let her
not text
finish.
messages. Not everything is committed only on text messages. There's a whole world of communication outside of text messages.
I understand. I'm just impressed by the sheer volume of the text between the two of you about every little detail.
It's
But
not
the-
every little detail.
Okay.
They are ones, look at the nature of the text messages. Phrases, little phrases. These are not massive, lengthy, robust conversations. These are little onesie-twosie sentences.
So do you have an email to the VA the minute that you noticed that there was a wraparound deck being built?
I think it's a phone call.
Okay. So it was so important, you just called them. You didn't document it.
Absolutely.
You didn't document it in writing.
Absolutely. So the purpose of this is because, think about it, that's the whole reason for their existence, is to relieve the administrative burden from the caretaker and regarding the veteran, right? They are relieving the administrative burden. I call them and speak with them. They document, they case management. They are doing this.
Do you have the record of your contacts with the VA?
Do I have the record of my contacts?
Do you have any record from the VA of your contacts to the VA?
Some an email that I have there, but I mean, are you talking about my phone calls?
I'm talking about contacting the VA concerning the wraparound deck with a phone call or an email.
I mean, there's some documentation. I mean, I know I've complained about it and it's in the discovery where I've complained about it.
Your Honor, is this a good time?
Just would inquire how much more,
Sorry?
just how much more you would expect to cover.
Probably I would think another 45 minutes or so. Bring it down to 2 hours, I think is somewhere in there.
All right, members of the jury, I think we're going to call that a wrap for today. Thank you for your attention to everything. I am optimistic that we're going to be getting to closing arguments at some point tomorrow. I can't promise you how long you would have for deliberations, but depending on direction from you, we can always stay late as well. So with that, I'll instruct you that we do not to discuss the case with anyone, including amongst yourselves, not to do any research about the case. We'll see you back 9 o'clock tomorrow. Thank you. And you can step down. Do we have any stray exhibits that need gathering?
Reynolds.
All right, for housekeeping for tomorrow, I want to first check in. Again, recurring issue, just to see, has there been a decision reached on amount of attorney's fees as it relates to the defendant's case, Mr. Burney? Or is he still going to need to prove those tomorrow morning?
We can set to the overall, to the total amount. I do think there's case law that states that, you know, unless as you suggest, unless the claims are completely interwoven, they have to be independently proven. I think that, you know, the breach of contract and the fraud claims, there's case law, I think, that show that those are often interwoven in a situation like this. But I think the slander and the conversion claims may be separate. If you would say, you know, I'm inclined to rule that these are interwoven based on what I've seen in case.
I can't make that ruling. That's a finding of fact, as I understand it. They get, like, typically, if this was just, you know, we're not stipulating anything, the jury has to determine everything. They'd have to sit there and mark down the amount. I would instruct them, here's how you come to find that amount. But then they would make that call. That's how I understand it. Now, if you want to do some more research on it, go for it.
My thinking is that it would be up to you to say if you could reject. So if I said, I don't want Mr. Craig's attorney's fees to come in because he hasn't proved them on a per claim basis, you could, I think as the judge, my understanding is you could say, no, these claims are interwoven. And so therefore he's not required to do that. So that's, I may be wrong about that, but I think.
I mean, if some of them get, I guess, let me ask this, Mr. Craig, you'd kind of put a pin in this, were there some that you were wanting to kind of lay by the side and set aside, or is it anything along those lines?
I still need to discuss that with my client. I apologize. Just had a very busy day.
It's been busy. We've covered a lot. I get it. And I mean, at this point, I think, Mr. Craig, it sounds like you may need to be prepared to prove that point, I suppose.
Okay, all right, that's
So,
fine. I can testify
FYI.
as to my fees. I don't think I would belabor it for too long.
Understood. Okay. As it relates to the charge, I think I have everyone's requests. Well, again, like I said, we'll be putting those together into a consolidated packet. As I think through these issues tonight and read the charges, I would be curious, just anticipating the issue that Mr. Burney, I think, raised from the outset, which is, you know, I expect him to make a directed verdict based on kind of whether Mr. Reynolds in his individual capacity should be part of any of these claims. I think he flagged that from the very beginning in the pretrial conference, right? So this is implicating piercing of the corporate veil type arguments. And so could you just give me a little bit of a sneak preview of what your response would be to that?
Sure, absolutely clear under Georgia law, an intentional tort committed by an individual. They're personally liable for that, regardless of whether they're wearing, you know, the company hat. So even if they're acting within the scope of their employment with an entity, if they're committing a tort, they are liable individually for that tort. We got a fraud claim here.
We'll take them one at a time. You have the negligence claim against Mr. Reynolds. That wouldn't be considered intentional.
That's true. I'd have to look and see if the same rule applies to negligence personally committed by the person.
Okay. But I understand what you're saying about fraud, conversion. Would slander of title be considered an intentional tort when he's filing a lien through a corporation?
That's a good question. I do believe slander of title is an intentional tort generally.
All right, some homework for tonight.
Yes, okay.
All right. And what else? Anything you want to add to that, Mr. Burney, since we're just discussing this?
You know, I think on that topic, Your Honor, I think there's no evidence in the conversion claim that my client personally converted any of those items. I think the testimony was mixed about they took it, Ed Smith, they mentioned Ed Smith as being involved, and Simon testified that he was the one that removed it. Not him, but Ed Smith removed it. So, I mean, he can't convert. First of all, I don't believe you can convert the $16,000. It's not like a bag of money that was identifiable as a separate fund. It's a it's mixed money and it's not capable of conversion.
Oh, the conversion is just the lumber and the countertop, as
Well,
I
I think
understand it.
actually in their claims, it was also for the 16,000. I understand about the lumber and the conversion, except for the fact that there's no evidence that it wasn't done, it was done by Mr. Reynolds.
Right. I'm just trying to hone in on that. I don't think it's alleged as just being a quantity of money or money had or received. It just says, I'm reading the pretrial order. Mr. Craig, was your conversion claim kind of cabined to just the lumber and the
It was at one
countertop?
time.
Is it, I don't have the pretrial order in front of me. I could try to pull that up. I'm not sure how we presented that. Maybe I could talk to my client about the conversion claim and we might not have to hash through this. It's like a tiny, tiny fraction of our damages.
Sure. And I'm not, saying which way I would go in one way or another. In fact, I'll indicate that I'd most likely defer again and refer to after receiving a verdict and reserving some of these questions and letting the jury have their piece before I kind of weigh in as a matter of law. Generally, when we come to these kind of issues. That being said, coming up, so you said obviously, Mr. Bernie, you have more cross-examination, and then Mr. Craig, you would have your second witness ready tomorrow morning.
Yes. Has he confirmed for us for tomorrow morning?
I can confirm with him.
Okay.
I would say, probably by 10 to 10:30, you should be in the hallway.
All right.
And then after that, I guess you could be either proffering or taking the stand. I don't know if he's wanting to examine you on the issue of attorney's fees. But after that, would you be expecting to rest at that point?
Yeah.
Okay. And how long is the second witness?
I'm thinking, I'm planning to have him done by the end of the shot clock there. So I don't anticipate spending a lot of time on him. But I was wondering, does that include closing?
No, not at all. No,
Okay.
you're statutorily entitled. You don't have 7 minutes left. I feel like you'd be sprinting to the stand and back if you only had 7 minutes left.
All
No, and that's another thing we can discuss is whether the parties are willing to cap themselves to say an hour and a half rather than the 2 hours that they're entitled to. But no, I'm not touching your closings. That's a matter of law. This is just the evidence.
All right.
I touch everything else I can, but not that.
Okay. All right.
So another thing to think about as you plot it out tomorrow. But I expect another full day tomorrow, and I feel like the way things are moving. Were you planning to call any witnesses in rebuttal based on how things are looking at this point?
Perhaps, but I want to talk to my client about that too, Your Honor. I understand the court's desire to get this case to the jury tomorrow, and we would like to see that happen too. Just have to talk to him and report first thing in the morning.
Understood. We'll see where it goes. And even if, again, if we're just, I'd like to at least see if we can get closings and I can charge them. If it just gets in their hands at 4:55, so be it. And they can come back Friday morning and start deliberating. Or if they want to stay late, we can do that within reason. We qualified them for the whole week. So I think they potentially would have a lot to talk about here. So we'll take it from there. Anything else on behalf of the plaintiff before we wrap up for today?
No, Your Honor.
Okay. Anything on behalf of the defense?
Oh, I'm sorry, Your Honor.
No, I was just saying, anything else on behalf of the defense?
I was just wanting to say my client didn't mean to speak over you.
No, look, it's I know this has been a long time getting your day in court, and that it is, there's no question in my mind the importance of this case to everyone involved. So I try to keep things, I want to let the parties, this is y'all's case. I want y'all to do battle at trial. And so I only feel like I should step in when absolutely necessary. But when I do step in, that means you've hit a guardrail and that we need to acknowledge. But I appreciate you mentioning that. And certainly that's not something at all that I'd take offense by or affects consideration of anything whatsoever.
Thank you.
All right. And if you want me to instruct the jury as well, I'm happy to do that as well, that's not something they should be inclined to